Commissioner Craig?
Here.
Commissioner Compton?
Here.
Commissioner Hawkins?
Here.
Commissioner Holton?
Here.
Commissioner King?
Here.
Commissioner Spielman? Commissioner Woke? We do have quorum.
Very good, thank you. Enforcement matter docket 150100174. What should we do now?
That is the first matter on the agenda. Assistant Attorney General Britta Beckstead and Peter Gowan, Enforcement Officer, will be representing the staff. Jamie Kavanaugh and Stephen Lechner will be representing LLC, and James Rouse will be serving as hearing officer in this matter.
So staff is going to, well, you have time allegations and you're going to be the official timer
I will be the official timekeeper.
and you're going to be as strict as you usually are.
I will. I have my paperwork ready to go,
Okay,
and I've already advised the parties regarding the time.
wonderful. So Ms. Beckstead, do you begin?
I believe the hearing officer is going to introduce the case.
Oh, great, great.
Yes, good morning, Commissioners. Jim Rouse, hearing for the Commission. This is a contested enforcement case wherein staff seeks an order against Will Source Enterprise LLC for allegedly failing to timely conduct mechanical integrity tests on Will Source Beaver 1-20 well, and also for allegedly failing to maintain mechanical integrity on the Little Beaver 1-20 well. The NOIVs were issued in November of 2014, and Will Source filed an answer to each NOIV denying any defenses. The staff filed a motion to dismiss 3 of the affirmative defenses asserted by Will Source, and Will Source filed a response asking that the motion to dismiss that was filed by staff be denied. I entered an order granting the motion to dismiss as to 2 of the affirmative defenses and denying the motion as to the 3rd affirmative defense. Will Source also filed a motion for summary judgment asking that I invalidate the NOAVs as a matter of law and enjoin staff from further prosecuting the NOAVs. Staff filed a response and Will Source filed a reply, all of which were taken into consideration. I entered an order denying the motion for summary judgment and allowing this hearing to go forward. After that, I entered the 2nd pre-hearing order. The first pre-hearing order was called a scheduling order to control things in the case. Will Source is now asking the Commission to reverse those 3 orders that I entered, and staff is asking that the orders be upheld. If the orders are upheld, this case will go forward and the parties will present evidence to support their respective positions. And the facts that the parties stipulated to are set out in the 2nd pre-hearing order.
Okay,
You want to do a time schedule or do you want to?
So Will Source will have 15 minutes total to argue why the pre-hearing orders entered by the hearing officer should be reversed. Will Source can split that time between initial presentation and rebuttal. Will Source? Ms. Kavanaugh?
Thanks, Mr. Rouse, for the introduction. I'm Jamie Kavanaugh on behalf of Will Source Enterprise, LLC. We're here today talking about Will Source, a small local operator with just 7 federal leases and 2 wells on those leases, as you just heard, the Little Beaver and the Will Source 113 well. It is undisputed that in July 2013, Will Source received a letter from Commission engineering staff notifying Will Source of the Commission's requirement for mechanical integrity tests. MITs are governed by Rule 326B1, which we'll all be talking a lot about today. This July 2013 letter provided that Will Source must comply with Commission Rule 326B1 within 3 months by performing MITs at its wells or by plugging and abandoning its wells. The letter also notified Will Source that if Will Source is unable to comply within 3 months, that notices of alleged violation would be issued. However, the letter provides specifically that if notices of alleged violation are issued, enforcement staff would not seek any penalties for an additional 3 months, giving Will Source an additional 3 months to comply with Rule 326B1. After receiving the July 2013 letter, Will Source determined that due to many different circumstances beyond its control, it would be unable to perform the MITs within 3 months, and it then requested a variance from this commission. the commission granted WillSource's variance and granted WillSource an extension until July 31st, 2014 to comply with Commission Rule 326. Despite this variance, on July 21st, 2014, WillSource received a set of NOAVs referred to today as the July NOAVs. The July NOAVs allege that as of July 18th, 2014, WillSource was in violation of Commission Rule 326B1. Although those NOAVs were issued without reasonable cause, WillSource followed up in good faith and spoke with engineering staff regarding the technical requirements for performing the MITs. This was in July 2014, prior to the date of alleged violation. Engineering staff then advised WillSource that it would be able to complete MITs without needing a full workover rig. That had presented a problem to WillSource in the past because WillSource has been advised continually by the Forest Service, the manager of the surface of WillSource's leases, that WillSource was not allowed to bring a workover rig across Forest Road 800 unless WillSource hired a third-party engineer to okay and approve the reason for bringing a workover rig across the road. So WillSource remained in close contact with engineering staff throughout July and August 2014. After hearing from engineering staff, WillSource followed up on the suggestion that MITs could be performed with a hot oiler truck and not with a full workover rig. WillSource and its consultant and engineering staff continued to have conference calls at the beginning of August, and when it became clear that engineering staff had given WillSource erroneous advice and that the hot oiler truck approach would not work at WillSource's wells, WillSource, again in good faith and in full cooperation with the commission, filed a request for variance requesting an extension to comply with Rule 326B1. And engineering staff received copies of both requests for variance on August 13th, 2014. Unbeknownst to WillSource, during this time, while WillSource was working prudently in good faith to perform MITs at its wells, staff was working behind the scenes because it had realized that it issued the July NOAVs without reasonable cause. Specifically, on July 29th, engineering staff realized and issued the July NOAVs too early. Engineering staff immediately notified enforcement staff. However, staff did not close, revoke, or otherwise amend the erroneous July NOAVs. For over a month, enforcement staff did nothing, and then on August 28th, 2014, staff initiated enforcement of the erroneous July NOAVs against WillSource, even though staff was fully aware that it did not have reasonable cause to issue the July NOAVs to begin with. This was a violation of Colorado Rule of Civil Procedure 11 and Commission Rule 501B, which prohibits any party from using proceedings before the commission for an abusive purpose. WillSource was shocked when enforcement staff initiated enforcement of the July NOAVs, given the existence of its valid variance through the end of July, through July 31st, 2014, and in light of the fact that it had received a letter the previous July, which specifically provided that if NOAVs were issued by staff, WillSource would be given an additional 3 months to comply with commission rules before staff would seek any penalties. However, WillSource continued to work in good faith despite these deceitful actions, and on October 24th, 2014, at its very first chance, WillSource passed an MIT at the WillSource 113 well. On November 6, 2014, the Little Beaver well also passed an MIT. Thus, as of November 6, 2014, both of WillSource's wells had passed MITs in compliance with Rule 326B1. It was not until November 18, 2014, that enforcement staff moved to dismiss the unlawful enforcement of the July NOAVs. On November 18th, the hearing officer granted staff's motion to dismiss the July NOAVs without prejudice and over WillSource's objections. Instead of providing WillSource a reprieve from enforcement proceedings, and instead of taking into consideration the fact that both of WillSource's wells had now passed MITs, immediately after the hearing officer dismissed the enforcement of the July NOAVs, WillSource was served with a renewed set of NOAVs, and those are the November NOAVs at issue here today. As WillSource later discovered, engineering staff purports to have closed the July NOAVs on November 13th, prior to the November 18th dismissal of the July NOAVs. Engineering staff did not notify the hearing officer or WillSource of its attempt to close the July NOAVs on November 13th. On November 13th and 14th, engineering staff issued the November NOAVs to WillSource, again alleging violations of Commission Rule 326B1. Finally, on December 4th, 2014, over 3 months after WillSource had submitted its requests for variance, WillSource received an email from engineering staff denying WillSource's request for variance at the Little Beaver well. However, to date, WillSource has still not received any response to its requests for variance at the WillSource 113 well. As the hearing officer mentioned, 3 preliminary orders were issued in this case, and WillSource takes exception to each of these issues. Each of the orders implicate WillSource's right to a fair hearing before an impartial tribunal. And any order written by a hearing officer is not binding on this commission and is not final until this commission adopts it. Please remember that the commission has substantial discretion to overrule or modify any order of the hearing officer. First, let's consider the hearing officer's order on staff's motion to strike, which was also called a motion to dismiss today, but it was originally filed as a motion to strike. WillSource takes exception to the ruling that staff's delay and failure to respond to WillSource's 2014 requests for variance is irrelevant and immaterial. The ruling is incorrect as a matter of law, and in fact, staff's decision to issue the November NOAVs while requests for variance were outstanding and prior to responding to those requests for variance is necessarily an abuse of discretion and contrary to the intent of the Oil and Gas Conservation Act and the commission rules. The hearing officer also erred in ruling that WillSource could not have been relying on obtaining variances because WillSource went ahead and performed MITs on its wells before receiving responses to its requests for variance. This ruling is nonsensical and sends a dangerous message to industry that it is better to file requests for variance and then sit back and do nothing instead of continuing to work with engineering staff in good faith while those requests for variance are pending. The order on staff's motion to strike also contains a predetermination of WillSource's guilt. More than once, the order provides that WillSource has violated Commission Rule 326B1. This type of finding is wholly inappropriate in a preliminary order, and these findings unfairly prejudice WillSource, implicate WillSource's right to a fair hearing, and constitute reversible error. Therefore, WillSource urges the commission to overrule the order on staff's motion to strike, denying WillSource the ability to present relevant evidence regarding staff's failure to respond to WillSource's requests for variance. Next, WillSource takes exception to the hearing officer's order denying WillSource's motion for summary judgment. First, the hearing officer erred in ruling that engineering staff has authority to close existing NOAVs at any time, even after enforcement proceedings have been initiated for those NOAVs. The hearing officer took administrative notice of the January 2015 enforcement guidance policy on its own motion. This constitutes reversible error because the January 2015 enforcement guidance penalty policy was written to clarify commission rulemakings that occurred after August 1st, 2014, the date of alleged violation here. In fact, the rules that apply here are the commission rules in effect as of August 1st, 2014. And the promulgation of the application of the enforcement guidance, and penalty cannot be applied to WillSource retroactively. Second, the hearing officer wrongly ruled that Commission Rule 522B1 confers authority on engineering staff to close existing NOAVs even after enforcement staff initiates enforcement of these NOAVs. Rule 522B1 encourages the director to engage in, quote, informal procedures, unquote, to dispose of NOAVs. Rule 522B1 provides that the director may revoke NOAVs if during the course of these informal procedures, the director determines no violation has occurred. However, Rule 522B1 clearly includes the term informal procedures to denote the fact that the director does not have authority to revoke NOAVs after formal enforcement proceedings have been initiated. Third, the hearing officer wrongly ruled that the November NOAVs and the July NOAVs did not exist simultaneously. The hearing officer upheld engineering staff's attempt to close the July NOAVs on November 13th prior to the November 18th dismissal of the enforcement of the July NOAVs. Since engineering staff's action of attempting to close the July NOAVs on November 13th had no effect on the existence of the July NOAVs, on the dates when the November NOAVs were issued, two sets of NOAVs existed simultaneously against WillSource, both alleging identical violations and both premised on the exact same underlying facts. Fourth, the hearing officer wrongly indicates that the enforcement and penalty amendments in HB 13-1456 apply familiar with the General Assembly's amendments to the Oil and Gas Conservation Act, the amendments to the enforcement and penalty sections. However, the hearing officer ignored the sworn testimony that was properly presented to it from staff, which provided that staff admits to issuing the November NOAVs that issue today under the previous version of the Oil and Gas Act, or the Oil and Gas Act as it existed prior to June 6, 2014. Finally, the order denying WillSource's motion for a summary judgment prejudices WillSource by containing findings that WillSource has been out of compliance with Rule 326 for multiple years. As a matter of law, that is impossible given the Oil and Gas Conservation Act's one-year statute of limitations. For the foregoing reasons, the Commission should overrule the hearing officer's order denying WillSource's motion for summary judgment and enter its own order ruling that the November NOAVs are void and unenforceable. In the alternative, if the Commission declines to do that, the Commission should still allow WillSource to present more evidence as to why the November NOAVs were improperly issued. Last, WillSource takes exception to the second pre-hearing order for 3 reasons. The order limits WillSource's ability to raise all relevant defenses and present all relevant evidence to the Commission today. The order limits WillSource's ability to call necessary and relevant witnesses, and the order severely restricts the amount of time WillSource has to present to the Commission. Each of these errors constitutes
Time.
Thank you, Commissioners.
Can you wrap up in a?
Yes, each of these errors in the second pre-hearing order implicate WillSource's right to a fair hearing as protected by the 14th Amendment. And for all the foregoing reasons, the Commission should overrule the 3 orders of the hearing officer.
Thank you, Ms. Kavanaugh.
Thank you.
Ms. Kavanaugh, I have a quick question for
Sure.
you. Let's assume that both NOAVs existed for the same time or they overlapped. How is your client prejudiced?
My client is prejudiced because the version of the Oil and Gas Conservation Act in effect governing these proceedings today limits the Commission to seeking only $10,000 per discrete violation, but each of these NOAVs sought $10,000 for the violations that are alleged at WillSource's wells. So as of the date that the November NOAVs were issued, the Commission wrongly sought $20,000 for each violation of Rule 326B1 by WillSource.
Staff will now have 15 minutes. Oh, do you have any other questions? Okay. Staff will now have 15 minutes to argue why the pre-hearing orders entered by Hearing Officer Rouse should be upheld.
Good morning, Commissioners. Britta Beckstead, Assistant Attorney General and Counsel for Commission staff in this matter. Staff requests that the Commission adopt the hearing officer's orders and limit and direct the parties to limit their case presentation accordingly. I will be focusing on two issues: the issuance of the November NOAVs and the 2014 variance request. In this case, staff was not perfect, as much as we strive to be a well-oiled machine.
Oh,
Thanks, I was hoping for a little chuckle.
a pretty good pun.
Yeah.
It took me a minute to catch it.
There was
Apologize, Ms. Bixby.
Oh, no problem. There was miscommunication regarding the date of the alleged violation in the July NOAVs, how staff was going to handle it, and some minor delays. But nothing staff did should impact a finding of liability or the penalty. WillSource has asserted these arguments in an attempt to distract from the substance of this case, because it has no evidence to refute its liability. Here are some facts that are relevant to these orders. I'll go through them because they're pretty complicated, and although Ms. Kavanaugh touched on a few, it's helpful to hear them again, I believe. NOAVs were issued on July 18th for violations of Rule 326B1 at the wells. This was prior to the date of alleged violation in the current NOAVs because a variance request submitted in 2013 and granted by the Commission had been approved and gave the operator until July 31st, 2014 to MIT or plug and abandon the wells. On August 13th, WillSource submitted a second variance request requesting an additional year to achieve compliance with Rule 326. I'll refer to this as the 2014 variance request. On August 28th, the matter was noticed for hearing under docket number 1410 OV69 with the underlying July NOAVs. In late October, WillSource performed MITs on the wells. On November 13th and 14th, the July NOAVs were withdrawn. New NOAVs were issued for the violations at the wells, which corrected the date of alleged violation for the Rule 326B1 violation. I'll refer to these as the November NOAVs. On November 18th, the hearing officer dismissed docket number 1410 OV69 without prejudice. In this matter, docket number 1501000174 was noticed for hearing with the underlying November NOAVs. On November 18th, the 2014 variance request was denied in the COGCC database as is shown in Staff's Exhibit 12 in the data entry. I would also like to clarify that WillSource did file two different variance requests for each well. However, they were both filed under the API number for the Little Beaver 120 well, and therefore only that one was entered into the system. However, both variance requests were substantially the same. They had the same letter attached to them that provided the same reasoning for the variance request. First, turning to the issue of the NOAVs and the motion for summary judgment. The hearing officer's order on this motion is firmly grounded in Colorado law, Commission rules, the Commission's enforcement and penalty policy, and the undisputed facts. The order denied WillSource's argument that the November NOAVs were improperly issued and void. Furthermore, this Commission is clearly authorized to take administrative notice of its enforcement and penalty policy pursuant to Rule 519C. Rule 522B1 explicitly authorizes the director to withdraw or revoke an NOAV at any time. WillSource has presented no provision for the assertion that the Commission must approve of this withdrawal, or that a notice of hearing somehow changes staff's authority to do this. Furthermore, the Colorado Rules of Civil Procedure only apply to the extent that they're not inconsistent with Commission rules. Therefore, trying to perfectly analogize an NOAV with a civil complaint is a flawed proposition. In these proceedings, an application for order finding violation hearing is what initiates a formal adjudicatory proceeding, not the NOAV. Here, staff withdrew the NOAV unilaterally as it clearly has authority to do and requested a dismissal from the hearing officer for the adjudicatory proceeding. Even if you were to analogize an NOAV perfectly with a civil complaint, Colorado Rule of Civil Procedure 41A1 allows a plaintiff to dismiss an action without a court order if the defendant has not filed an answer yet. In docket number 1410 OV69, at the time that staff withdrew these NOAVs, the defendant, here WillSource, had not yet filed an answer in that matter. WillSource has also provided no evidence that the NOAVs actually existed simultaneously. For example, for the Little Beaver 120 well, under the stipulated facts, this is simply not true. The Little Beaver 120 well July NOAV was withdrawn on November 13th, and the new NOAV was issued the next day. In addition, for the WillSource 113 well, it is staff's practice to commonly withdraw and then reissue if necessary. There's no evidence here that that did not occur. Furthermore, the NOAVs that were issued are not identical. This was the entire reason for the reissuance, to change the date of alleged violation. Staff and the hearing officer have acted within their clear authority in this proceeding, and this is why staff asked this commission to find that the November NOAVs were properly issued in docket number 1501-0000174. Now to the second issue, the 2014 variance request and staff's motion to strike. WillSource has argued that the 2014 variance request, if it was granted, would moot the November NOAVs. The order on the motion to strike determined that this issue was irrelevant because the variance request was denied. The variance request filed by WillSource was also filed after the date of alleged violation, and even after the days of violation that staff is alleging for penalty purposes. In addition, WillSource has provided no evidence that it inquired about the status of the variance request prior to its statement at a pre-hearing conference on November 18th. The variance request was also denied on that date. Staff also never gave the operator any indication that the variance request would be approved. In addition, docket number 1410 OV69 was noticed for hearing on August 28th. Therefore, the operator was on notice that an enforcement action was proceeding against them, and the high likelihood that the variance request would not be approved. Moreover, as pointed out in the hearing officer's order, it is irrelevant to speculate about the effect of whether this variance request had been granted, because it simply was not. It was denied. For these reasons and additional reasons provided in the order itself, staff asked the commission to find that the 2014 variance request is immaterial to this proceeding. WillSource has attempted to use these procedural issues to avoid addressing the substance of this case. Approving the hearing officer's orders will allow what is truly in dispute to be the focus of this hearing. This is why the second pre-hearing order lays out the remaining disputed issues should this commission approve the hearing officer orders. All these remaining issues apply only to penalty mitigation. In fact, WillSource has agreed that if the hearing officer's orders are approved, these are the issues to be determined at the hearing. Staff respectfully requests that the commission adopt these orders and find that the November NOAVs were properly issued and the 2014 variance request is immaterial. Thank you.
Would you address Ms. Kavanaugh's response to my question concerning prejudice?
Of course. Staff is alleging violations under the old Penalty Act in this matter. However, the old Penalty Act only prohibits seeking penalties for more than 10 days for a particular violation. Here, NOAVs themselves don't seek the penalties. The application for order finding violation does. In addition, these NOAVs were not seeking penalties for exactly the same violation. They were seeking penalties for a different violation that occurred on August 1st. Does that help answer your question?
I think so.
Okay.
Just to help, so what are the different violations? Can you say that without
Sure. So on the July NOAVs, they alleged a date of a violation of July 18th. That was when those NOAVs alleged that the operator was in violation for not having performed an MIT. If you take that, 10 days out, that would be July 28th. And that was prior to the date that the variance request expired. The November NOAVs changed the date of alleged violation to August 1st because that was the day after the variance request expired. So therefore, in a way, I mean, they're different violations and there's nothing in the act that prohibits doing that. Does that help?
No.
Okay.
What are the different violations that they relate to timelines?
Exactly. So from July 28th to July 18th to July 28th is a discrete violation. The operator was in violation then. From August 1st to August 10th or 11th, they were also in violation. So And by in that instance, does that help clarify?
That did, thank you.
Okay, thank you.
Except my counsel didn't quite get it.
Okay.
Is staff currently seeking penalties for July 18th to the 28th?
No, those NOAVs were withdrawn.
So from August 1st is the first day of your alleged violation.
Yes.
Any questions from commissioners? Sir?
I'm not sure I have a question. I do have a couple comments.
Oh, good.
Primarily concerning the motion to strike. So the motion to strike, motions to strike are rare and they're rarely granted. In this case, the hearing officer entered an order striking 3 affirmative defenses by will source. One is the argument that the NOAVs, the first round of NOAVs, were improperly issued. The second affirmative defense is that the NOAVs were mooted by subsequent successful testing. And the third is that concerns this request for variance. The third concerning a variance, to me, should be adopted by the commission. The variances, the timelines, I'm going to repeat them again because I think they're important. The first variance is from September of 2013, and that the duration of that first variance went to July 31st, 2014. There's a second variance sought on about 2 weeks later, on August 14th, 2014, which was never granted. It was subsequently, but it was never granted. And to me, that's analogous to a party filing an opposed motion for extension of time in court. There's no presumption that you're going to get that. There's no presumption that you're going to get what you want. And we heard a little bit about that yesterday about variances with respect to retrofitting existing pits at these locations. So the fact that an operator submits a variance does not entitle an operator to a belief that it's going to be granted or extend the date of compliance. So in my view, the fact that a variance was sought on August 14th, 2014 is immaterial and should be affirmed or should be adopted by the commission. The remainder of the motion to strike, I think, should be rejected by the commission. The motion to strike does, as Ms. Kavanaugh advocated, suggest that there were prior violations and there were, in fact, findings of violations. You're here to decide whether there have been violations. There's been numerous facts stipulated to by the parties. Will Source has conceded and admitted various facts, but they have not conceded or admitted liability. They're here to advocate and present facts and testimony and legal argument that there's no underlying violation. So there's lots of facts that have been stipulated to, but guilt or liability has not been stipulated to. So this order says, given the past history of failure to conduct MITs, I disagree with that. And it says that Will Source has been caught violating them, the rules previously. I disagree with that. That's what we're here to decide today. So the effect of that is this motion to strike addressed 3 affirmative defenses. Whether the second round of NOAVs were properly issued, whether the second round of NOAVs were moot, those to me are primary legal arguments, which I think Will Source should be entitled to present through counsel and their witnesses who are here today and prepared to testify. But the third recommendation concerning the effect of the variance, as I said previously, that was properly rejected by the hearing officer in my view, because I believe it's immaterial. An operator should not be entitled to assume that they're going to get that requested extension. So that's a long way of saying I think you should reject in part and adopt in part the hearing officer recommendation on the staff's motion to strike various affirmative defenses by WillSource. And in particular, the concluding sentence of this order is the staff's motion to strike WillSource's affirmative defense number 11 and number 12 is granted and said defenses are stricken, meaning the materiality of the variances which were ultimately denied. The remainder of the order, I think you should reject. The motion for summary judgment, I agree with, and I think you should adopt. And the second pre-hearing order, I also believe you should adopt. The hearing officer did substantially limit WillSource's intended witnesses, finding in part because they were redundant or in some cases immaterial. I don't believe there's any prejudice arising out of what I'm recommending here today because, or prejudice to WillSource, because the issues of whether the second round of NOAVs were properly issued or not, or whether they were mooted or not, are primarily legal arguments, not factual arguments. So that's my recommendation.
No, I'm really confused.
The motion to strike various.
Can you say whose motion to strike it was?
WillSource's motion, I'm sorry, staff's motion to strike WillSource's affirmative defenses. I'm recommending that the commission adopt in part and reject in part. And I think WillSource would argue, well, if that's the case, we should be able to get a bunch of different witnesses in here, which we were precluded from doing so under the second pre-hearing order. And I don't believe that is prejudicial to WillSource because the arguments that the hearing officer initially precluded were primarily legal arguments and not factual arguments. So I believe that's appropriate. What else is on your mind?
Question, I do have a question.
Sure.
The second variance, you said it was August 14th, 2014. When was it denied?
I think December 4th, one of them was denied, and then
November 18th, it was denied in the database, and then December 4th, WillSource was notified by email that it had been denied.
So November it was denied, December they were notified.
Yes.
And that was only one of the requests for variance, as staff noted.
Okay, I need some direction. My colleagues probably have that.
why don't we take them piece by piece?
That's exactly what I was going to suggest, is that we do this piecemeal.
I think it would be appropriate for you to invite a motion accepting the hearing officer's order denying WillSource's motion for summary judgment.
You understand that? I think I do. I'll entertain a motion to that effect.
So moved.
We have a motion and a second.
Second.
And a second. I need a little more discussion there. Okay, and let's vote. Those in favor indicate by saying aye.
Aye.
Opposed, same sign. And that motion passes. Now, the next piece, which we are being, I'm sorry.
Oh, go ahead.
In the hearing officer's order dated January 29, 2015, regarding the staff motion to strike certain WillSource affirmative defenses, hearing officer found that on August 14, 2014, acting upon the advice of COGC staff, WillSource submitted Form 4 requests for variances requesting an extension to complete the MITs on the wells. COGCC failed to timely respond to WillSource's Form 4 variance request. WillSource was not notified that the COGCC had denied its Form 4 request for variance until December 4th, 2014. These affirmative defenses are affirmative defense number 12 and number 11. At page 7 of that order, the hearing officer found at paragraph 4, the staff's motion to strike Will Source's affirmative defenses number 11 and 12 is granted, and said defenses are stricken. Commissioner, I believe it is appropriate for you to invite a motion adopting paragraph 4 on page 7 of 8 of the hearing officer's January 29, 2015 order regarding staff motion to strike certain Will Source affirmative defenses.
Okay. I will patiently wait for a motion.
So moved.
Motion. Second.
Seconded.
And they second. Any further discussion? Any more clarification?
So this is going to limit Will Source's ability to speak to their case then, or?
In one way. One way. And it would limit Will Source from saying, we sought a variance on August 14, 2014, and the commission either accepted or rejected, never notified us of its action on that variance request. And as a result, we're not liable, or our penalty should be less. So the fact that it would erase the fact that a second variance was sought.
And as I recall, you indicated that they should not have a presumption that a variance would be granted.
That's correct. Under 502B, our variance rule, operators are entitled to submit a request. That's all it is, and that request is in the discretion of the director. It doesn't speak to the effectiveness of that request in the meantime.
Right, so that doesn't,
Suspend your
Suspend.
obligations under the rules in the meantime.
right.
Okay, any other questions? Have a motion and a second?
Well, wait a minute.
Oh,
I'm,
you have-
I'm troubled by the process. You know, a lot of the rules, for example, yesterday, we talked about, before we approved the new rules related to flooding, saying that these operators could go ahead and if they can't get the work done, they could request a variance. Well, they have to know in a timely fashion that that variance has either been approved or not approved for them to do their work, right? And so the question here, if we're gonna hold them accountable, don't they have to have, a timely response? And isn't that part of the question here? I'm getting tripped up on this, okay?
Well, if you have any doubt, you are free to admit everything that Will Source intended to present, and you are free to override my recommendation. And you are certainly free to allow the unfettered presentation of evidence to you. And if that's what you decide, that's entirely appropriate.
Particularly with the new fines that were, and admittedly, this is a process question. And where we're headed in the future with these huge fines, the process, the burden is going to be on the commission to make sure that everything is done by the letter and the process is totally clean. And I'm concerned. I'm really concerned. We're putting a burden on the industry, and the staff performance is going to consistently be called into question. So this is where I am. Please, people, straighten me out. I've got to understand this.
I see it two issues. One is this case is coming under the old
rules.
So we all understand that.
Yeah.
I also understand you're telling us, and rightfully so, that what we do is, in essence, precedent setting.
It is. With much stiffer penalties.
But the issue of law, like I know, is, there is no timeline designated, I understand, for responding to a variance request. We don't have anything written down that says staff must respond in 10 hours, 10 days, whatever. And companies should not operate with the presumption that they submitted a request for variance and they're going to get it. Therefore, they don't need to do anything, at least until they get a response. It's not right. It's not the legal way to do it. That's how I see the issues. I understand your point, and I'm in agreement with it. But in this particular case, I think what we're looking at is whether or not we, the commission staff, followed the law as we understood.
I want to make sure that you understand where I'm coming from. That there is no right or wrong. This is an evidentiary ruling within your discretion. And the question is, how do you interpret 502 variance process? If you have any doubt whatsoever as to whether or not a piece of evidence should come in, then let the parties make their case and be forthcoming in allowing that sort of evidence. By the same token, if you decide that this is an important application of the variance rule, you are within your discretion to back at the second variance was sought.
Sure. Commissioner Allworth.
I appreciate where Commissioner Craig is coming from, and I would feel differently if the variance request came in prior to an operator being in violation. So if it would have come in before the previous variance had expired, then if the staff delayed, I would say the staff allowed something to take place. But when a variance request comes in after the violation is taking place, the operator is still responsible for abiding by our rules. And under the current rules, they would still have been in violation, even though they had submitted a variance request, and until the remedy had been in place or commenced, or whatever term we use. So I think delaying, it's the operator's responsibility to know what their responsibilities are. And if they're unable to meet them in a timely fashion, notify the staff and ask for additional time. And that didn't happen. So I'm not too concerned about the timeline following the request for the variance in this case.
Mr. Chairman. I agree with Commissioner Allward. I also want to be clear, under the new statute, we do have the authority to levy significantly higher fines, but we're not obligated to, right? So we look at the conduct of the operator, the intent, whether staff might have played some role in, could we have done better? All those factors go into ultimately what a fine will be. We're obligated to find a fine for every day in violation, but it can be a nominal amount. So I don't want to go down that road, but I want everybody to understand as we move forward, we have a lot of discretion here when it comes to the amount of fines.
Okay, I recall we have a motion on the rule of the second. And probably have to have that reviewed. Do you happen to take any notes on that, Mr. Reed?
Motion to strike affirmative defenses 11 and 12. Is that the one?
Yes.
That was, the motion was from Commissioner King and the second from Commissioner Hawkins.
It's to affirm the staff's
Adopting paragraph 4 of the hearing officer's order to strike the affirmative defenses 11 and 12.
And it will be part of the record, but it's the timing of it. after the violation that is there, so that everybody knows, right?
Well, that is part of the record, yes.
That's.
Okay, any further comment or discussion? Those in favor indicate by saying aye.
Aye.
Opposed, same sign. The motion passes. Okay, Council,
And lastly, would be appropriate by the motion rejecting the remainder of the hearing officer's order regarding the staff motion to strike certain will source affirmative defenses. The recommendations aside from paragraph.
okay?
Would you please read the affirmative defenses that you are recommending be, that the hearing officer order be rejected as to?
Paragraph 1 of that order contains the following findings. July NOAVs were improperly issued in violation of COGCC rules in effect on August 1st, 2014, the date of the alleged violation. Affirmative defenses 9 and 7. Paragraph 2 on page 1 of the order reads, paraphrasing, the July NOAVs are moot given will sources proper completion of an MIC. Will source 113 well and Little Beaver 120 well are affirmative defenses 8 and 10.
Okay. I'll entertain a motion for the two council recommendations for the hearing officer.
Can you read them? Can you say the motion? one more
Sure.
time?
I believe it's appropriate for you to write a motion rejecting the hearing officer's recommendation that will sources affirmative defenses number 9 and 7 as identified in paragraph 1 of the January 29, 2015 order, and affirmative defenses 10 and 8 as identified in paragraph 2 of the January 29, 2015 order be rejected, and will source be permitted to present evidence, testimony, and argument at this hearing addressing those affirmative defenses.
So moved.
We have a motion
Second.
and a second. Any additional discussion? Hearing none, those in favor indicate by saying aye.
Aye.
Opposed, same sign. That motion passes. And the hearing officer's recommendation goes down. Okay. Now, how do we proceed?
At this time, each party has an hour and a half to present their case in chief, including opening argument, direct examination of the witnesses, cross-examination of each of the parties' witnesses, rebuttal, testimony, and closing arguments. Staff will,
Has an hour and a half.
an hour and a half total. Staff will be,
The party gets to, the party has to present.
it's staff's burden of proof. Staff will begin with their opening argument.
Really quickly, Commissioners, did you approve the second pre-hearing order? I don't believe that was in the motion. Am I?
You're right. I believe it's appropriate for you to invite a motion adopting hearing officer's pre-hearing order.
Okay. Entertain a motion to adopt hearing officer's second pre-hearing order.
So moved.
Motion. Waiting patiently for a second.
Second.
And a second, any discussion? Hearing none, those in favor indicate by saying aye.
Aye.
Opposed, same sign. And that the hearing order is adopted. Okay, Ms. Bexfield, I believe
Yes.
the ball is in your court.
Excellent.
You
Yeah,
have a moment to.
some technical, yeah.
you want me to limit your time on opening?
I think I'll be okay.
Okay.
Thank you.
Ready?
Commissioners, I ask you to remember two things throughout the party's case presentation today. The MITs on these wells were overdue 8 years. And
Objection, prejudicial. Given the 1-year statute of limitations in the Oil and Gas Act, it's impossible as a matter of law to find WillSource out of compliance for more than 1 year, and staff admits to seeking only 10 days of penalties, August 1st through August 10th.
Okay,
Suggestion.
I'll grant the objection. You know, we understand that.
Now, wait a second. Mr. Chairman, with all due respect, when we start talking about if we do get to a penalty phase, these are the types of things that I think would help me to understand. We're not asking and seeking violation for 8 years. But I think the context is important when we determine, if we get to that point, what a penalty should be.
I sit corrected, so the objection is denied. I want to have that total picture.
Okay.
Sorry, and just for the record, Commissioner Wilk is present.
Thank you.
The mechanical integrity tests on these wells were overdue 8 years. And when the tests were finally performed, one of them failed. This should be a simple case. WillSource has stipulated to all facts that prove its liability, and the only remaining issues are issues regarding penalty mitigation. Staff requests an order finding that WillSource violated Rules 326B1 and 326E and imposes a $24,000 penalty for these violations. Staff will prove to you today that the penalty should not be mitigated because WillSource has asserted only excuses and distractions in its defense. To provide you some background, I'll move briefly through some of the important facts to your remaining decisions today. Hopefully you all can see this. You all have young eyes, right?
This is presbyopia.
Why don't we move that closer?
In the
Can
center?
you put it in the center in such a way that the council can still see it?
Thanks, Still.
Fast. It's the leg is collapsing. You're gonna have to turn it quite a bit.
Is it okay? Commissioner King, can you work?
I pretty much know what the chronology is.
Thank you both. Okay. The wells at issue in this case, the WillSource 120 well and the WillSource 113 well and Little Beaver 120 well, have been shut in since 2004. WillSource Enterprise LLC became the operator of these wells in 2006. Also at that time, these wells required MIT's pursuant to Rule 326B1. On July 29, 2013, the COGCC issued a warning letter to WillSource for violations of Rule 326B1. On September 23, 2013, WillSource filed the 2013 variance request that has already been discussed today. The variance request was approved and the operator was given a deadline until July 31st, 2014 to plug and abandon the wells. On July 28, 2014, WillSource first contacted staff regarding the MITs. This was likely in response to the fact that the NOAVs had been issued on July 18th, and they gave the operator until 10 days to respond to those NOAVs. On August 1st, 2014, the variance had expired and the wells were not MIT'd or plugged and abandoned by that date. On October 24th, 2014, the first ever MIT was performed on the WillSource 113 well, and it was successful. On October 28, 2014, the first ever MIT on the Little Beaver 120 well was performed and it failed. On October 31st, the Little Beaver 120 well was repaired and then it passed a successful MIT on November 6th. I'll leave that up for reference if that's helpful. Rule 326B1 requires operators to perform MITs on wells within 2 years of their initial shut-in date. Here are the stipulated facts prove this violation. These wells were shut in 2004. They therefore required MITs in 2006. Prior to October 2014, the wells had never had mechanical integrity tests performed on them. Rule 326E requires that all wells maintain mechanical integrity. And if an operator is already overdue for an MIT, when the test fails, the operator is not given an additional 6 months to repair the well. Again, WillSource has agreed to facts that prove this violation. The Little Beaver well required an MIT in 2006. When an MIT was finally performed, it failed. It was not repaired until October 31st and therefore lacked mechanical integrity at least from October 28th to October 31st. Staff is alleging 2 violations of Rule 326B1 and requesting a penalty of $20,000 for these violations. Staff is also alleging 1 violation of Rule 326E and requesting a $4,000 penalty for this violation. Staff is requesting this total penalty of $24,000 under the old Act because many of the facts supporting the alleged violations arose prior to the effective date of the amendments. Because liability is clear here, the only remaining issues before the Commission after your approval of the hearing officer's pre-hearing orders, to the extent that they were approved, are whether the penalties should be mitigated. First, mitigating factor 4, and this factor has 2 parts: whether the BLM or the Forest Service delayed or prevented the MITs, and secondly, whether staff did anything to delay or prevent the MITs. The next issues are what I'll call the good behavior mitigating factors, whether WillSource did anything that would otherwise justify a penalty reduction. Lastly, the issue of whether WillSource has the ability to pay the penalty. I would like to emphasize that the Commission may or may not apply these mitigating factors in its discretion.
Can I interrupt you for a question? Not clear on the last issue. In fact, whether the company has the ability to pay the penalty, has some consideration relative to how we look at the time that we're coming up with the penalty.
It's not a mitigating factor in Rule 523D, but in the enforcement and penalty policy, and historically the Commission has considered it in extraordinary circumstances. And WillSource has put forth this argument in its materials that were submitted. Yes. In addition, if it would be helpful, we have a handout of Rule 523D that lays out all the aggravating and mitigating factors, if that would be helpful for the Commission. The Commission may consider mitigating factor 4. I'll give it a minute. Yeah.
Thank you, sir.
Do you have any more?
Oh, is there enough? Sorry.
Thank you.
The Commission may consider mitigating factor 4, where the cause of the violation was outside the violator's reasonable control and responsibility. I will prove to you today that the BLM and the Forest Service did nothing to delay or prevent these MITs. The evidence will also show that one suggestion from staff should not abdicate WillSource of responsibility. This is staff's Exhibit 6. which is an email sent by Steve Ficklin, BLM Program Manager, to Reed Williams, the president of WillSource, on August 29th, 2013. This was almost a year before the deadline set forth in the 2013 variance request. This email explicitly states that neither the BLM nor the Forest Service will do anything to delay or prevent the MITs at the wells.
WillSource wants to lodge on the record that it objects to this exhibit as hearsay. Mr. Ficklin is not present today to testify, so you cannot consider this email to prove the truth of the matter that it asserts.
Noted.
Thank you.
Jay Kraybacher, COGCC Northwest Area Engineer, will testify to his subsequent conversations and emails with Mr. Ficklin that support this fact. Mr. Williams even acknowledged Mr. Ficklin's communication to him in Staff's Exhibit 7, which is a letter that was signed by him and attached to the 2013 variance request. Lastly, it is undisputed that WillSource was able to perform the MITs in October of 2014. The BLM and the Forest Service did not delay or prevent the wells at that time for any reason. Turning to the second issue under this mitigating factor, this is Staff's Exhibit 11, which is an email sent from Jay Kraybacher to Dave Andrews describing a conversation he had had with Mr. Williams on July 28th. This was WillSource's first attempt to contact staff regarding the MITs, and only days before the 2013 variance request expired, and seemingly only in response to the July NOAVs, not of the operator's own initiative. And this is also what WillSource holds up as confusing and erroneous statements from staff. Not only were these statements made as a suggestion for the operator's own investigation, they are a harmless effort to help the operator save time and money if it was possible. Testimony from Jay Kraybacher will show that the hot oiler truck method could have worked if circumstances at the well were slightly different, that he never conclusively stated that it would, or that WillSource should pursue it and only it. Most importantly, if WillSource had contacted staff earlier, as it was its responsibility to do, it would have left itself plenty of time to investigate its own options. WillSource is also claiming that it had a prompt, effective, and prudent response to the violation, cooperated with the Commission and other agencies. It had made a good faith effort to comply with the applicable requirements prior to the Commission learning of the violation, a history of compliance, and that the economic benefit of non-compliance was reduced or eliminated by the cost of correcting the violation. These mitigating factors should not apply due to the following facts. WillSource was notified of the Rule 326 violation in July of 2013 and provided with the procedures and processes for remedying those violations at that time. Then WillSource was given almost a one-year extension to achieve compliance. Even with this generous extension, WillSource did not contact staff until July 28th, only days before the extension expired. This is demonstrated by staff's Exhibit 11, WillSource's absence of exhibits to the contrary, and will be confirmed by Jay Kraybacher's testimony. WillSource also did not perform the MITs until October 2014, almost 3 months after the extension expired. Regarding the history of compliance, WillSource owns and operates only 2 wells in the state of Colorado, those at issue here, which have been out of compliance with Rule 326 for 8 years. Finally, if WillSource had complied, it would have had to perform 2 MITs by today's date. Rule 326b1 requires an MIT within 2 years of the well's initial shut-in date and 5 years after that initial test. Therefore, they were required to perform an MIT in 2006 and then in 2011 if they had been timely with their compliance. WillSource has estimated that the cost of performing the MITs at this time was $116,455. Therefore, by not having to do this twice, they have in fact saved themselves that exact same figure. Throughout the case presentation today, I ask you to remember 2 things. The MITs on these wells were overdue 8 years. When they were finally performed, one of them failed. WillSource's remaining arguments can only be considered for penalty mitigation. And staff will prove that WillSource has not provided support in the record for even penalty mitigation in this case. Staff asks this commission to see these arguments for what they are, excuses and distractions. Thank you.
say of Mr. Kavanaugh.
Yes, thank you, commissioners. WillSource has been brought here today before the commission to defend itself against these notices of alleged violation. These notices of alleged violation were issued improperly given the existence of the July NOAVs, and both sets existed simultaneously.
Objection. Chairman, these were disposed of with your approval of the order on the motion for summary judgment.
No, the rejection of the order on the motion to strike allows WillSource to continue to argue about the existence of the improper issuance of the NOAVs. I think Mr. Matter agrees. Secondly, the NOAVs were improperly issued. However, the NOAVs were also issued after WillSource had successfully completed both of the mechanical integrity tests as required by Commission Rule 326B1. We need to bear in mind today that WillSource is a small local operator. As you just heard from staff, WillSource has only 2 wells on its 7 federal leases, and WillSource is not big oil. The evidence presented today, or otherwise already admitted before the commission, will demonstrate that in July 2013, WillSource received a letter from the commission specifically stating that if the commission decided to issue notices of alleged violation for WillSource's delay in completing mechanical integrity tests at its wells, that after the issuance of the notices of alleged violation, WillSource would be given an additional 3 months to comply with the rule before any penalties would be sought by this commission. Beginning in July 2014, prior to the date of the alleged violation, WillSource was attempting to perform the MITs at its wells and was working directly with engineering staff in good faith to do so. The evidence presented today will also demonstrate that at all times, WillSource was engaged in good faith efforts to comply with commission rules and responded promptly, effectively, and prudently to the violations as alleged by staff. WillSource has only one way to access its wells. WillSource's federal leases are all located within the White River National Forest, and Forest Road 800 is WillSource's only access to its wells. WillSource has spent over $2 million to date repairing and maintaining Forest Road 800 under the direct supervision of the United States Forest Service, the manager of the surface of WillSource's wells. The evidence will show that despite WillSource's large investment into Forest Road 800, the Forest Service Road Ranger has told WillSource multiple times it could not bring a workover rig across Forest Road 800 unless and until it paid a third-party engineer to redesign the very road that it had just invested $2 million into. The evidence will show that prior to and throughout the dates of alleged violation that are relevant here, WillSource was working hand in hand with engineering staff to determine whether it could complete an MIT with the hot oiler truck as suggested by staff. It was reasonable for WillSource to follow up on the advice given to it directly by engineering staff. Engineering staff's advice regarding the hot oiler truck approach delayed WillSource's performance of the MITs, and unavailability of equipment in this area also delayed performance of MITs at WillSource's wells. The evidence will show that there exists no evidence of environmental harm from the MIT that did not pass at the Little Beaver well on October 28th. The evidence will also show there's no way to prove that the failure existed prior to October 28th, 2014. Despite the fact that WillSource was delayed repeatedly by the advice from staff and by the unavailability of equipment, staff now seeks $24,000 in penalties for the alleged violations of Rules 326B1 and 326E. Mr. Williams will also provide testimony today that the Bureau of Land Management has recently notified WillSource of its belief that it may have issued WillSource's leases in error. This issue concerns 65 leases, federal oil and gas leases in the White River National Forest, and all 7 of WillSource's leases are included in that 65. The BLM has specifically indicated that it may modify the stipulations attached to WillSource's leases, or it may outright cancel all of WillSource's leases, despite the fact that WillSource has been a prudent operator and has properly paid all of its minimum royalties, delay rentals, and done everything else to comply with BLM regulations for the past 19 years. The evidence will also show that despite the fact that WillSource was granted a variance in 2013 to complete MITs at its wells, the variance equated to only a couple weeks. WillSource's operational season at its leases is very limited, and WillSource is lucky to be able to access its leases beginning July 1st. WillSource is often not able to access its leases until July 15th. The evidence before the commission demonstrates that the 2013 variance granted to WillSource was approved on December 6th, 2013. WillSource is not allowed to access Forest Road 800 beginning December 1st because of snowmobile traffic on that road. So by the time WillSource had received its variance from the commission on December 6th, WillSource's operational season had already passed, leaving the actual to WillSource equating to only a few weeks. Despite the fact that the BLM has also admitted that it may cancel WillSource's leases, thereby taking away WillSource's assets, WillSource moved forward and MIT'd its wells, accruing a debt of over $116,000. WillSource has been unable to pay that debt off as of now. Sadly, the facts will show today that WillSource is on the brink of bankruptcy. WillSource has no current cash flow, and its current liabilities total over $2 million. In other words, WillSource does not have the ability to pay a penalty imposed by the commission. Based on the evidence that the commission will hear today, the commission should find that WillSource is not liable for a violation of commission rules and should not impose any penalty on WillSource. Thank you.
Thank you, Ms. Kavanaugh. Lauren, see if it's appropriate. Before we move into the next stage, I think we'll take about a 10-minute break.
That's fine.
10-minute break.
Britta, are you going to use the screen anymore? Or?
respectfully request that you kind of, best you possibly can, really cut to the chase. I assure you that my knowledge of these folks, having served with them for at least 3 years, they have read the material that you have submitted. And with the additional introductions that you've given us, we have a pretty good idea. So best you possibly can, because we're going to be up against a tight timeline. Be as brief as you can. I'm not asking you to leave anything out that you think is important. But that's with the most important material. Thank you for your consideration. Okay, our next step then is
Presentation by staff's case. The presentation by staff's case in chief. And Mr. Matter will be swearing in the witnesses.
Raise your right hand, please. Do you swear or affirm under penalty of perjury that the testimony you're about to provide is nothing but the truth?
yes.
Mr. Kraybacher, could you please state your name for the record?
My name is Joseph Kraybacher, but I'm known as Jay,
And what is your current position with the commission?
engineer with the Commission for the Northwest area of the state.
And how long have you worked for the commission?
Almost 6 years in the engineering department, and before that, 9 years as a field inspector.
What are the engineering unit's main tasks at the commission?
There are a few, but pertinent to this hearing, our main concern is wellbore integrity for gas and oil and injection wells.
Could you briefly describe what a mechanical integrity test is?
The well is pressured up with the isolation device above whatever perforations, and well is pressured to whatever pressure we decide is sufficient, and if it holds that pressure for 15 minutes without losing 10% of the initial pressure, then it passes the MIT.
Yeah, you can take it out.
I can hold it.
Okay. How does the MIT requirement for shut-in wells help protect Colorado's public and the environment?
It ensures that the well is not leaking material from the well, or that unwanted material will leak into the well if the wellbore is, has mechanical integrity, is solid.
Is there always a potential for harm if mechanical integrity is compromised?
Yes.
Investigating the Will Source 113 and Little Beaver 120 wells.
I'd met a program manager with the BLM, we call it the SILT office, the Colorado River Valley office, who brought these wells to my attention because they were on BLM, U.S. Forest Service land, and he'd been concerned about them, but they didn't. I don't know if they enforce against mechanical integrity or not, but he knew we did, and we would get enforced for mechanical integrity a lot quicker than the Forest Service could.
What is Steve Ficklin's position with the BLM?
It's called program manager. I think. Something like that.
Why was BLM concerned about the wells?
There were reasons, I don't know. They had their concerns, but I believe in small.
Action hearsay. Mr. Kraybacher is offering testimony that was provided to him by a third party who's not present here today, and he's offering it for the truth of the matter asserted.
You need to speak into the microphone.
You are entitled to reject evidence at discretion. And one thing you need to keep in mind is you can admit hearsay objection if a reasonable person can conduct their affairs would rely on such information. So it's a broad discretionary standard that you should rely on the basis of the question to me was, could I rely on what was Mr. Kraybacher's recollection of this conversation? I think that does in fact fall into that statement.
Denied.
What did you find when you did your initial investigation of the well records?
The first and primary thing that got my attention was that they've been idle for many years without the MIT.
So under Rule 326B1, when should MITs have been performed on the wells?
Many years ago, I think 2006, for the first one and every 5 years thereafter.
Do you consider these violations of Rule 326B1?
I don't know the exact rule, but at the time I looked it up and they were a violation, I call our MIT rule.
When you reviewed the well file, did you find a variance request filed by WillSource in 2013?
Yes, I did.
Was this request granted?
Yes, it was.
Did it state that the work had to be commenced by a particular date?
I don't know if it was commenced or completed by July 31st, 2014. I think it was completed.
After review of the well file, did you contact Mr. Ficklin of the BLM again?
Yes, I did.
Is this, which is Staff's Exhibit 10, an email communication between you and him in early July?
Yes.
Did Mr. Ficklin discuss the Forest Service and use of the road as possible reasons for delay in this email?
He said that had been used by the operator in the past as but he said it was not true, that the Forest Service would allow them access.
As a BLM employee, how was Mr. Ficklin familiar with the Forest Service road permitting practices?
I'm not entirely sure. I had the feeling he knows a bit about everything with regard the rules of not only the Forest Service.
Mr. Krabacher, would you mind reading this portion of this email aloud for us?
Not the highlight, but that one.
This one, yes.
The White River National Forest Oil and Gas personnel are a part of the interagency energy team in this office, and this is considered maintenance. Maintenance work does not require any additional road evaluation.
Thank you. Did you issue NOAVs for Rule 326B1 violations at the wells in July of 2014?
Yes.
Why did you issue these NOAVs before the 2013 variance request expired?
I don't know. I don't remember. I felt that the wells had been in violation of that rule for so long that the NOAVs were long overdue.
Did these NOAVs direct the operator to contact staff within a certain time period?
Yes.
How long was that time period?
I think it was 10 days.
When did a representative from WillSource first contact you regarding the wells?
Within that 10 days.
And do you remember the exact date?
It was either the 9th or it was either July 29th or 30th. I think.
And who contacted you from WillSource?
Reed Williams.
To your knowledge, did anyone from WillSource contact any commission staff member regarding MITs on the wells prior to July 28th?
I'm pretty sure not.
And if a staff member had been contacted, would they have notified you?
Well, I certainly hope there would be a correspondence or document in the well files.
Did you provide any suggestions for possible alternative methods of performing MITs during your conversation with Mr. Williams?
From what I remember as a field inspector, bringing in a workover rig is somewhat more intensive and expensive. And I figured if they could get a wireline unit in to put in an isolation device, be it a pack or a bridge plug, then what we call a hot oiler truck would at that time be sufficient.
Do you recognize this email, which is Staff's Exhibit 11? Which is an email you sent to your supervisor, Dave Andrews.
Yes.
And this is describing that hot oiler truck method, correct?
Yes, it does.
And is this a conversation you had, or does this email describe a conversation you had with Mr. Williams?
Yes, it does.
Why did you suggest that Mr. Williams could investigate this method?
Depending what was available. If workover rigs weren't available, then hopefully someone would have a wireline truck to install an isolation device, followed by what I call a hot oiler truck, which is basically a truck hauling fluids that can inject, put fluid into a wellbore, pressure it up, and keep it there, thusly satisfying our requirements for an MIT.
Did you ever state conclusively that this method would work at the wells?
It was offered as a suggestion.
Is it typical for the operator or staff to figure out what will work at a particular well in order to achieve compliance?
That should fall upon the operator.
In these conversations, did you ever advise WillSource to file a second variance request?
Absolutely not.
In these conversations, did Mr. Williams assert any reasons for WillSource's delay in performing the MITs?
I don't think so, and I don't remember.
Did you have any subsequent conversations with Mr. Ficklin?
Yes.
Did the BLM or the Forest Service ever indicate to you that either agency had delayed or prevented WillSource from MITing the wells?
Mr. Ficklin assured me that that was not the case.
Do you recognize this, which is Staff's Exhibit 20?
Yes.
Sorry for my hoarse voice.
No problem. Could you please read the highlighted portion of this email?
There is nothing that the BLM or the Forest Service has or will do that would prevent WillSource from performing the MITs as per your NOAV.
And this was an email sent from Steve Ficklin to you, correct?
Yes.
In this email, did Mr. Ficklin also state that the BLM considered the performance of the MITs on the wells an environmental and safety issue?
Yeah, he seemed to think that it could be.
Did he indicate that BLM was planning on issuing orders for MITs to be performed on the wells?
I'm not entirely sure, but all along I thought that the BLM was pursuing separate enforcement, but I don't know exactly what.
Do you know if the statements in this email were made during hunting season?
I'm not a hunter, but I presume early September there was some hunting season, perhaps the early one going on.
And turning now to the Rule 326E violation, besides a failed test, is there any way to determine how long a well has been lacking mechanical integrity?
Well, yeah. Yes, but we have no MITs on file. And, yeah, I'm sorry. We have no MITs on file. So, and I thoroughly searched through both the wells well files, and there were no indication ever of them having a mechanical integrity test.
So a mechanical integrity test is the only way to determine if a well is lacking in mechanical integrity.
As far as I know, there could be some other way. I don't know about it if so.
Okay. So the Little Beaver 120 well could have lacked mechanical integrity since 2006.
Yes, it's possible.
When does a well regain mechanical integrity after a failed test?
You have to fix it.
Did the Little Beaver 120 well therefore lack mechanical integrity until the repair was complete?
Definitely. If it failed a test, it obviously lacked mechanical integrity until it passed a subsequent test after repair.
Do you consider this a violation of Rule 326E, which requires all wells to maintain mechanical integrity?
For the record, I haven't memorized all the various subcategories of Rule 326, but I know it violated one of those.
Okay. Turning back to the notices of alleged violation, why did you withdraw the July NOAVs?
It was brought to my attention after July 31st that these may have been premature.
So a violation had still occurred, but with a different date of alleged violation?
Yes.
Were these NOAVs intended to replace the July NOAVs? Or excuse me, so the November NOAVs were intended to replace the July NOAVs?
Yes, and I, in good conscience, knew that they had a violation date of August 1st.
Why was there a delay in closing the July NOAVs and reissuing the November NOAVs?
I don't recall.
Nothing further.
I may have had other work to do in the meantime.
Nothing further.
Yes, I do.
Interrogation.
Do you switch seats then, or just Jake?
Typically we stay in the same seats.
Oh, okay.
But
Thank you. Okay.
You want me sitting closer?
No, that's fine. I do
Here,
know.
Jay, you
Sorry,
want-
yes.
a little easier.
Oh, it's stuck. I'll have mine. Okay.
Hey, Mr. Kraybacker. So you're aware that NOAVs are serious documents, correct?
Yes.
And NOAVs carry legal penalties?
I'm aware of that, but that's not my concern with issuing them.
What is your concern with issuing NOAVs?
Violation has occurred and it warrants a notice, NOAV.
And you're aware that commission rules require you to have reasonable cause for issuing an NOAV.
They had better.
And we just heard that you issued the July NOAVs, and when did you attempt to close the July NOAVs?
I'm not sure what you're getting at. I don't know about closing, but I guess withdrew them. That's a close, isn't it?
So you were aware as of July 29th that the July NOAVs were improperly issued because WillSource had a variance to complete.
As of
mechanical
July
integrity
29th,
tests.
I was not, no, I didn't know that, I was not aware of my NOAVs being premature until after, sometime in August. I'm sorry. I'm sorry, Mr. Matter.
Do you
Sorry,
have a copy
sorry,
of
Ms. Kavanaugh.
the hearing exhibits? Can you please look at staff exhibit 11, Mr. Kraybacher? Very first page, we have an email from you to Jeremy Farron. Can you please tell me who Jeremy Farron is?
Jeremy Farron is our hearings officer.
Okay, to David Andrews, can you please tell me who David Andrews
He's a
is?
supervisor of engineers for the state for the western half.
And to Peter Gowan, can you please state who Peter Gowan is for the record?
He is one of our hearings officers.
And is it typical for you to email hearing officers or enforcement staff?
Didn't used to be, but more and more so. Yes, we involve them in all of our enforcement actions. We have to inform them of what we're doing.
And is this a true and accurate copy of an email that you wrote yourself?
It certainly appears to be.
And the date of this email is July 29th?
Yes, it is.
And so you were aware on July 29th that the July NOAVs were issued without reasonable cause?
Yes, certainly, I correct my previous statement. As of July 29th, it was brought to my attention.
And did you think this was a serious matter?
Yes and no. The violations still were there. And withdrawing these was somewhat embarrassing, but I don't think it was that serious.
And did you know how to go about withdrawing or closing the NOAVs?
Having never had that happen before, I did not.
So this was the first time that you had to withdraw NOAVs that you had issued?
Yes, as far as I can recall.
So how did you find out how to withdraw the NOAVs or close them?
I think someone else did it for me. I don't know if I did it myself, but.
So you're not sure of the date on which the July NOAVs were closed?
No, I'm not.
And you issued the new set of November NOAVs, correct?
Yes, I did.
So how did you know that the November NOAVs were issued after some imaginary person purported to have closed the July NOAVs?
I knew they were closed at that time and a new set was warranted.
How did you know that?
Because the wells were out of compliance August 1st, 2014.
And how were you sure that the July NOAVs had already been closed?
I looked it up in the well files and I think they said withdrawn or closed as per their status.
And who would have closed those NOAVs?
I may have, I don't remember.
Was it your testimony just a second ago that you did not close the NOAVs?
I don't know how it was done. I said someone else may have done it for me.
So if you had to close another set in the future, would you know how?
This time for sure.
Interesting. Do you think this fosters trust and cooperation between the industry and the agency?
I don't know. I don't see what you mean.
Do you think that your actions towards WillSource have been forthcoming and open?
As far as possible.
And you notified WillSource then, once you knew on July 29th that the July NOAVs were improperly issued, did you notify WillSource?
I don't, if I did, I don't remember. I don't think it was my job to do so. Probably did. I have no recollection.
But it is your job to issue NOAVs.
Issue, yes.
You think, and I'm sorry, you said that you think you did notify WillSource in July that the July NOAVs were improperly issued.
I'm pretty sure I didn't notify WellSource in July.
Okay.
Because we were conjecturing among ourselves, as you can tell by that date, July 29th.
And so why were the July NOAVs not closed immediately if engineering staff and enforcement staff knew on July 29th that the July NOAVs were improperly issued?
I don't know.
And how did the decision to close the July NOAVs come to be reached?
Well, it started again when it was brought to my attention that we may have been premature in issuing them.
Who brought this information to your attention?
I think it was my supervisor,
That would be, for the record,
David Andrews.
David Andrews. I want to talk about the NOAVs for a moment also. Can you tell me what the significance of an abatement date on an NOAV is?
Have this done by the state, or additional penalties probably will apply.
And on the November NOAVs, you included an abatement date of January 10th, 2015. Is that correct?
I think so.
And can you tell me why you decided on an abatement date of January 10th, 2015?
It wasn't my decision. Someone else suggested it.
Did someone else write the November NOAVs?
I wrote the most part, for the most part, I just basically rewrote the previous ones since the same violation still was applicable.
But there are differences between the July NOAVs and the November NOAVs, correct?
The dates, for starters.
But the content as well, there are differences, correct?
I don't think so. I think it was pretty much the same.
And you're aware that WillSource complied with Commission Rule 326, B1 and E prior to the abatement date of January 10th, 2015, correct?
I would say so.
And in fact, the NOAVs include the fact that WillSource had already passed MITs at both of its wells. Is that correct?
Would you repeat that, please?
Yes, the November NOAVs specify that WillSource had already passed MITs at its wells, correct?
I'm not entirely sure. The NOVs could have had I'd have to have the NOVs in front of me to ascertain that.
Do you issue a lot of NOAVs each year?
Define a lot.
How many NOAVs do you issue each year?
Some years I don't think I've issued any. 2014, it may have been in the neighborhood of 20 or more.
So it's hard for you to remember the specifics, I guess, for each NOAV that you issued?
After a while, at first when I'm involved with some NOAVs, you kind of, you're like a shepherd them along, and then it gets resolved and you move on to whatever your work load is next.
And you spoke with Mr. Williams as you testified in July 2014, correct?
I'm pretty sure.
And you recall having phone conversations with Mr. Williams?
At least 2 or 3.
And you recall having phone conversations with Mr. Walk, WillSource's consultant as well?
A couple times.
And it was your testimony that you informed WillSource that it might be able to perform an MIT without a workover rig, correct?
I was hoping for their sake that it was possible. I wasn't entirely sure.
And you gave WillSource that advice in good faith, correct?
It was a suggestion. I suggested look into it, this method.
And you were aware that other wells had performed MITs, had been MIT'd using the hot oiler truck approach, correct?
But that, yes, provided they get what we call a pack or something which isolates the perforations. And that could be done by, I'm sorry for interrupting, but that could be done by a wire line.
Thank you. But it was reasonable for WillSource to go ahead and follow up on your advice, is that correct? Your suggestion?
If the equipment was available, yes, it was reasonable.
So it was reasonable for WillSource to investigate the hot oiler truck approach to performing MITs at its wells, correct?
Keep in mind that how they did it is their concern. I offered that as just a suggestion.
And as soon as WillSource realized that the hot oiler truck approach would not work at its wells, WillSource submitted 2 requests, So the November NOAVs that you issued seek penalties for WillSource's failure to perform MITs from August 1st to August 10th, correct?
I just issue the NOAVs because a violation has occurred. Insofar as the time duration, I think that sounds right.
So if you're not sure about the time duration, who would make a determination about the duration of a violation?
Well, if we're up to me, it'd be August 1st until the date each well passed its MIT, if it was up to me.
But who, I guess, makes the determination of the duration of a violation?
Someone besides myself.
You don't know who,
I can guess, but I don't know.
but it's your signature on the NOAVs, correct?
You're right.
And so you're not sure, your testimony is that you're not sure how penalties are calculated.
That is true.
Can you briefly describe the violation of Commission Rule 326E at the Little Beaver Well?
Keep in mind, I know what 326 generally deals with mechanical integrity. The subcategories, you'll have to read it to me what it is.
326E provides that all wells shall maintain mechanical integrity.
That's pretty simple. Thank you.
And you issued the November NOAV to WillSource for the Little Beaver Well because you believe there had been a violation of Rule 326E, correct?
Yes.
And have you ever issued an NOAV for Rule 326E before?
Yes.
For a similar violation where an operator failed a test and corrected the failure within a matter of days?
Yes.
Yes. And let's see, have you ever spoke with anyone at the Forest Service regarding WillSource's use of Forest Road 800?
Well, Mr. Ficklin's kind of with the Forest Service. He's a BLM employee. I spoke with him.
Mr. Ficklin's a BLM employee, correct? Are you aware of the difference between the Forest Service and the BLM?
Slightly. No, but yes, I am aware. But the BLM the Forest Service doesn't have a petroleum section, so they have delegated that to the BLM. So the BLM is in a sense, the U.S. Forest Service's petroleum personnel. They're for oil and gas stuff.
The Forest Service does have oil and gas rangers, so you've never spoken to any of the Forest Service's oil and gas rangers, is that correct?
The reason why I'm looking confused, I didn't think the Forest Service had oil and gas personnel per se. I thought that was BLM. I've learned something there, if that is true.
So just to be clear, you never spoke with anyone at the Forest Service about WillSource's use of Forest Road 800?
Mr. Ficklin was representing the Forest Service.
And your title is an engineer, correct? Can you describe your educational background?
I have a degree in physics from Colorado State University.
And do you have an engineering degree or certification?
I have what is called a field fundamentals of engineering certification.
Not a degree. And just one final question. Should operators be able to rely on the advice that you give them in your official duties as commission staff?
Keep in mind, I was making a suggestion, and I wouldn't call it entirely advice. It was, you could investigate this. I mean, I advise that they should check into it, but that I was not entirely sure that would be feasible.
Sure, and it's reasonable though for operators to rely on the advice that commission staff gives them.
Provided they do an evaluation and see if it'll work for them in whatever particular case.
And it's reasonable for operators to follow up on any suggestions or advice that commission staff gives to them.
Sometimes they can say, no, we'll do it our way, or we'll do it a different way.
And if they chose to follow up, I guess, on commission staff's advice, that would be reasonable.
I would certainly hope it would work. And in my case, I had hoped to save money and all, that there would be a wireline unit that could install an isolation device, followed up by what I call a hot oiler.
And you wouldn't offer any advice to any operator in bad faith, correct?
I would certainly hope not. I wouldn't.
Thank you, Mr. Kraybacher.
Questions
Next
from?
step, do you have any, what do they call it? Redirect?
No redirect, sir.
Okay. Ms. Borenstein, what's the next step?
Does staff have any additional witnesses?
No, staff has called all its witnesses.
Well, at this time, the presentation is on WillSource to start its case in chief.
James Kavanaugh.
Ms. Kavanaugh, you have 1 hour, 8 minutes, and 25 seconds remaining. 1 minute remaining.
1 minute.
Thank you. Okay.
Matter, do you have to do anything now? Before I add anybody?
Yes. Will Source calls Reed Williams.
Square under penalty of perjury that the testimony or about the prize is nothing but true.
I do.
Thank you, sir.
Can you please state your name for the record?
Reed Williams.
And what is your profession?
I'm in the oil and gas industry.
And what is your title?
I'm president and majority owner of Will Source Enterprise LLC.
And how long have you been with Will Source?
Formed it about 18 years ago.
How many employees does Will Source currently have?
Currently one, not me, full-time clerical administrative assistant.
And why don't you consider yourself an employee of Will Source?
Since the oil and gas downturn in 2008, or gas downturn in 2008, the company's not had the cash flow to pay me, so I'm not on the payroll.
And when did Will Source become operator of the two wells that we're talking about today?
2006.
And where are these wells located?
South of Rifle, Colorado, in the White River National Forest on BLM Minerals, and in Mesa County.
And as a federal lessee, does Will Source understand the difference in the duties between the BLM and the Forest Service?
Absolutely. The BLM is the manager of the minerals assets in the property, in the leases that we have, 7 leases. And the Forest Service manages the surface use of these lands. So all of our 7 leases are surfaces controlled by the rangers.
As a federal lessee, are Will Source's leases subject to a limited operational season?
Yes, we when we took the original leases, the stipulations on the back of the leases had various pre-existing conditions. Probably the primary one was that the forest had signed a usage contract with the State Snowmobile Association, so that the State Snowmobile Association had the right to maintain the road without someone like me damaging their maintenance. They had a snowplow, and they go out and plow the road, and it's called the Sunlight to Powderhorn route. It's very popular. December 1 through the end of March, we are not allowed to disturb the snow on the one only road that we can transport on. We can access, like with snowmobiles or snowcats, as long as we don't damage it.
Are there any other limits on Will Source's access?
Yes, it's a beautiful area that the elk come into for calving, and it's an annual migration that varies a little, and there's a stipulation that we're not to use heavy equipment for 30 days during the April part of the year. It gets swing by agreement with the rangers a week one direction or the other, depending on when the elk are calving.
So we've already determined that Forest Road 800 is Will Source's only access to its wells. Has Will Source been required to maintain Forest Road 800?
Yes, we work cooperatively with the Forest Service as an agency with their short budgets. We correspond with that and maintain the roads. Let me add one other restriction, by the way. This is high mountain, 7,000 to 11,000 feet of altitude, and during the winter it piles up a lot of snow. So there's a large runoff season, and the rangers don't want us crossing our rolling forwards where the creeks run until about July 1st, and sometimes it lags it till July 15th before the amount of water coming down is enough to let us get in there. Sorry, what was the other question?
Can you talk about your maintenance, Will Source's maintenance of Forest Road 800, please?
Yes, when we first took these leases, the road had deteriorated almost to non-existent, and then part of it on the eastern side is non-existent. It deteriorated so badly, they canceled it and don't want it rebuilt. But we agreed to repair the road and maintain the road. That is a very expensive proposition as a part of our working in good faith with the Forest Service. For example, the hunters come in the bidders come in beginning around August 1, set up their camps, and their transportation all through the hunting season on this public road destroys it again. And we have agreed and do maintain the road after hunting season, repair it back, although we didn't damage it.
So given all of the repair and maintenance that WillSource performs on the road, can WillSource bring heavy equipment across Forest Road 800?
Until a few years ago, we had a fairly general working relationship with what we call the Forest Road Ranger. Her name is Carla Mobley, great gal. She's worked in the forest there for a long time. And we worked directly under her supervision of how we could use and maintain and repair the road. And as long as we went out and did graveling or cut trees down that out of the way that had fallen across the road and or the county road that is the only road that leads dead ends into Forest Road 800. We had a very workable relationship. A couple of years ago, we were approached and told that, regrettably, the forest had decided they could not anymore take the liability for their engineer being responsible for managing us, and that they needed to have us hire a third-party road engineer to redesign the road to third-party specifications and then reconstruct the road to that third party. And we were told in communications, both written and verbal, in large groups that could be witnesses that we didn't bring today because we were told we couldn't, that we could not access that road, use that road for drilling rigs and our heavy equipment like a workover rig until that redesign and reconstruction had been finished and approved, signed off on by the third-party road engineer and then the rangers.
And did WillSource begin the process of working with a third-party road engineer?
Yes, we didn't like it, but and we complained a great deal, having spent a couple $1 million doing what they told us to do previously. But that's the way it works at the forest. If you're not going to do what they tell you to do, then you're not going to be there. So we went and hired a third-party engineer and started the redesign work, several major field trips, working on it, getting ready, and paid him quite a bit of money.
And do you recall who told WillSource that WillSource could not bring heavy equipment such as a workover rig across Forest Road 800?
Correct, yes. Carla Mobley, the road ranger, and was in field meetings with us. And also there is a forest ranger who's designated as the oil and gas ranger in the region, and his name is Jason Gross, and the two of them work very closely, daily basis with me.
And do you recall a specific instance when Carla Mobley may have told WillSource that it could not bring a workover rig across Forest Road 800?
We have an email from her that specifically says that we, in matters of maintenance, we would be allowed to access our sites, but that the use of a workover rig across the road was not allowed and would depend completely on them having approved it and signed off on it, which has not been finished.
Excuse me, Mr. Kavanaugh, I don't recall seeing that in the material. Is that in the?
That's not, and I was going to offer it for evidence. So if the commission would like to see it, I can provide a copy to, this was previously provided to staff in our response to discovery requests, and it was planned to be offered today into evidence. So.
The objection?
Objection to the fairness of it, honestly. Just that we didn't know that this was going to be an admitted exhibit here today. So if you think it's necessary for your decision here today, we have no objection, but for fairness, we would have appreciated it earlier.
Was it disclosed in discovery?
It was disclosed in December to, yes, it was.
Yes, it was, but not as an exhibit.
My judgment is for him.
Thank you, Chairman. If you
Thank you.
pass it around. So I was trying to set up this email. Thank you, Chairman, and we'll wait a moment for everyone to get a copy, I guess.
That email is just one of many similar meetings. The way the forest works for me is we call field trips, and the Forest Service rangers and the BLM staff that are monitoring and ruling on all of these issues will attend in large groups. 7 or 8 of us will track around out there with our environmental consultants and our contractors and Nathan Bell, the engineer that we hired to redesign the road. We go on field trips together and point at things and make field decisions. They are all in attendance, and they have all heard me readdress this issue several times, that it is inequitable of the Forest Service to have told us what to do. And I spent our money doing it exactly the way they said for many years, and then come up with a new ruling that said we can no longer access our drilling pads and or our existing well sites with heavy equipment.
Okay, let's talk about the email. Who's Mark DeHaven?
Mark DeHaven is an environmental specialist. He works for a company called ERO. They have been our and co-worker with the Forest Service and the BLM from the very first day I had these wells. So they're a longtime consistent contractor. And let me tell you that the way that works is a very strange system, but it's just the way it works all over the country. The Forest Service is supposed to do the work themselves, but they don't have the staff to do it. So they ask us to help them with those costs if we expect to move our projects forward. And then they have a list of contractors that we can select from. This company and this gentleman was selected, and we pay him.
This was not the only time that the Forest Service indicated to Wilsource it could not bring a workover rig across Forest Road 800, correct?
Many times, all the way up to within weeks of us putting the rig on the site. One of the things that's happening, is you'll all very aware these days, all of our agencies have fallen into segmented groups. One side's pro something and the other side's against it, even inside the agencies. And so we get different inputs inside the agency from different people. So we've been told this by the oil and gas people. Our effort the whole time that we work out there is to make sure that we do the best we can to service all of the interagencies overlapping requirements of us. And that's almost impossible to do because it's a catch-22 oftentimes, like this situation with the workover rig.
And just to preserve the record, Wilsource moves to include exhibit marked GG into the record as evidence.
Can we accept that?
Thank you, Chairman.
It's in the record.
Thank you.
Thank you.
So let's jump forward a little bit to when Wilsource performed the MITs at its wells this fall. Did you follow up with the Forest Service before you brought the workover rig to Wilsource's wells?
Yes, I was about to bring a rig over it and have breached my long-term relationships with the people at the Forest Service who count on me taking care of their requirements also. So I was finally informed that, yes, the squabbles going on out in the field were between the BLM and the state and the forest rangers. It had finally been imposed upon the forest and the BLM that they should not stand in the way of what the state was requiring. And they sent me or called me and told me that I had permission. And I said, well, we're going to go because we have to give 10-day notice to the state. And I'm just telling you, we're going to move the workover rig across that road. And I need to know I'm not in breach of your regulation at this point. He said, go ahead and go. Carla Mobley's out of town this weekend, and laughed. So, I mean, that's how intimate a conversation we have on an ongoing basis with our interagencies.
Thanks, Mr. Williams. Let's backtrack for a moment. Do you recall receiving the letter from the COGCC in July 2013 regarding mechanical integrity tests?
Absolutely. I recall it
this is staff exhibit 5.
I recall specific reasons. We, as a small operating company, do a very good job of keeping up with all of the different interagency requirements, but sometimes they are very confusing, and so we talk with our agents about them. I have been aware of the MIT requirement for the whole time I've been basically out here since it was put into effect, and we often ask why it was not being communicated to us by the state. And we have been told over and over that during the early years of this time, the budgets and employment situations meant that certain agencies took on certain responsibilities and others didn't defend them, let's say. So we were working up until the time we received this very letter under specific conversations that said the BLM and the Forest Service, because we were out there in their territory that was not the state's territory, that they were not, the state was not handling it, the BLM and the Forest Service was. Well, if that's what I'm told, and I never hear a word from the state, then that's what I believe is what I'm supposed to be doing. And this letter came to me for the first time on those dates and said, now we're warning you. The state stood up and said, we have some more people, and those are the things I heard. We have some more budget, and we're coming to you to say, now you need to start taking care of your MIT requirements under the state's rules, and we did.
And what did the letter say about when or if notices of alleged violation would be issued?
That letter said that we had 30 days to get it done, and that if we didn't, then we'd be filed, and we'd have 90 days to get it done, and then we'd file, we'd have 90 more days to get it done before we would be penalized.
And we've already established that the commission granted a variance after you received this letter. Can you briefly describe the basis for the 2013 variance that was granted by the commission?
Yeah, I wish I had time to fully inform you of the many difficulties that we face in this situation. But the primary thing that goes on and happened about this same time is we're working with the forest all the time about road issues, and this is an example of now we got to put a workover rig down there, and we had just been told we couldn't do that in those years. Secondly, we work with the Forest Service on a footprint basis and environmental, take care of the environment as best we can. And they require lots of attention to that. And although they may not say we're ordering you not to do something, when we apply for a pipeline route, they'll say, we'd rather you not go down that road or down that hill, up across that hill straight. We'd like for you to go down the road if you're willing to do it. So we go tear the road up, put the pipe in, spend a lot more money going around corners to enhance and maintain the environmental footprints there. We thought we were being really good stewards of the environment doing that. But as it turns out, to do that meant somebody else is building a 20-inch line, which they did right across our property, and it had been built. But the Forest Service says, couldn't you wait? Don't build something else and scar the land again. Couldn't you wait until that's built and tap into it, and we'll all be happy? Yes, sir, that's what we'll do. So the time frame delays were all in good faith and us working hard to be good partners and with both the Forest Service and the BLM and then the state. So we could not easily do hookups to pipelines, and they want us to wait to do work out there until we could consolidate finishing a well and hooking up to the pipeline, and we agreed to do so. So we thought, well, if the road is a question, we're going to rebuild it, and if the pipeline is coming and we can go that direction instead of tearing up other ground, we'll agree. And we'll go ask for an extension for the right reasons. We did, and we got it.
And by the time that you received the granted variance request, how long did WillSource have, I guess, to act on the granted variance?
Yeah. Well, acting on the granted variance is an issue of precedent in my mind at that point in time, and I think it's very defensible. When we had received the letter about us having 90 days, and then if it hadn't been done, 90 more days after that, and then got an extension 4 months later in December of that year. It set the precedent that it takes the state, as it does the BLM and the Forest Service, regrettably, unreasonably long amounts of time, in our opinion as industry people, to notify us of the decisions. We can't work like that. We have, it just kills us with the use of our money. But all we could do is say, all right, if that's the precedent, then now when I filed this most recent one asking for another extension, it's not unusual at all for it to take 90 days before we would hear back. So we thought we were working in good faith with our fellow with our Oil and Gas Conservation Commission. And even though we were waiting on a response, we were doing everything we could do to get a workover rig and get permission and go do the work, and we did. And we spent over $100,000 doing it. 116,000 is what I think is a record. And then 2 weeks later, we get a penalty notice that we're going to get charged $27,000 back when it first came to us for not abiding by the rules.
What actions did WillSource take in July 2014 to perform MITs at its wells?
The Piceance Basin has been a boom basin until recently, and there was unlimited supply and service out there for our E&P operations. As you know, the regulatory environment has started ratcheting down on activity, and oil and gas values, especially gas, for a long time, since 2008. It's made that basin completely collapse, and it's gone out of business, and the people are without work, and everything's terrible on that side of the basin. But the part of that matters to this conversation is, while there used to be a bunch of workover rigs and teams to work on workover rigs, all those people have shut down and let all their people go. So for months, we'd been calling on Piceance and Monument and the different well service companies, myself calling them personally, saying, when can you get me a rig? Well, Mr. Williams, there aren't many of you left out here, and the only guys that are left are really big, and we can't afford to make them mad by leaving the work they have us to do to come over to you. We'll probably get to you in 2016 or 2015. And we just kept persevering with it until we found a rig.
And can you tell me about when you contacted engineering staff in July 2014 to talk about performing MITs?
My sense of this story is that there is an element in the Western Slope and the Eastern Slope that would like to see the hydrocarbon industry go away. So we're confront that there are people who support that in all the agencies, and we do the best we can to work with and deal with it. One of the agents for the BLM had sicked a field officer into the field and to inspect our well sites. I think you've heard that from the other testimony. They found a little hissing noise and called me and asked me to fix it. So we sent crews out immediately in mid-July to fix those little, after the close of winter, those little hissing noises that can happen from cold expansion and heat expansion. So we got out there, we were working hard on all of that stuff. I was well aware of the MIT requirements, and I knew that I had a lot of problems. I couldn't access the road without special permission. I couldn't find a workover rig. So I called on Dave Andrews, the field supervisor, both in email and telephone calls, and got messages back from him. And Mr. Jay Craybacker called me back, I think, on July 28th to discuss it.
And what was can you tell me about the conversation on July 28th, please?
The first thing that happened was I was forwarded an email from Jay Craybacker to David Andrews, copied it. So, and I appreciate it. And basically it's an exhibit. And my read of that was, you've called in within the time frame that you're required to, and you're not in violation. Now, that gets very confusing, but that was the way I interpreted that standard. Then we talked at length with Mr. Craybacker about all of the problems I have with workover and road use and economics and all of those things, and what could we do that made this better for everybody, the best for everybody. And I had explained to him that workover rigs access was very limited to me right that minute on that road, and I couldn't find any. And he said, well, let me tell you about, in a very helpful way, in a very nice way, he explained to me that he thought, and he'd observed a bunch of MIT work done with wire lines and hot oil pressure equipment, and that maybe it wouldn't be necessary. And I said, well, that's great. Let me get my expert, Randy Wogg, my consultant, on the phone, and let's talk about it. So we did. We had several conversations over the next few days, and Randy and I both went to work trying to figure out whether that was true or not. Now, we used a few days researching that I think was done very reasonably. And we called back and said, the equipment in the hold is uncertain. Delta, the petroleum, the operator I bought it from, had not left good well files, and we weren't sure. And the only way we were going to know was to go in there with a workover rig and pull the tubing out of the hole and see where the packers and so forth were. So we appreciated the lead that we had, and we took it in good faith, and we researched and blew a few days until we knew otherwise. So to be penalized for that kind of working relationship with my fellow oil and gas people in this commission is a shocking contingent. So what Ms. Graybacher and I discussed is, well, what can I do that keeps it as best as possible? And I asked him, is there a chance for us to file it for another sundry notice extension? Well, that's possible. And if I were you, I'd do it. Not a kind of say, yeah, that'll work, but an encouragement of it. So we immediately drew the forms up all the way to the point where we said, look, we got to do this in a hurry. So we were tending to the state. We copied down the 2 reasons that we had used the year before that had been approved. And we thought, well, that's good logic. It's even worse under those 2 conditions. Now I can't use the road. And then I put a 3rd clause in it that relates to this thing you heard me speak of before, where the BLM came up with a ruling out of nowhere that 2 leases away from us had been issued illegally.
Objection, because this is the 2nd variance request, the 2014 variance request that Mr. Williams is discussing right now. And this commission has already ruled that that is not relevant to this proceeding.
I agree with Ms. Bexton that this concerns the 2nd variance. You want to hear it? That's your prerogative.
Well, my tendency, colleagues, is that this is kind of part of the narrative. I certainly would like to allow it to be included. I agree. Council has said I'm kind of crazy, but that's not the first time. So unless you have some objections.
No, I don't, Mr. Chairman. The only thing I would point out is that we're hearing something that we said wasn't something we were going to consider, so it does count against the time that is being utilized, but that's their choice.
Well, let me, I'm going to, unless I really get petition counsel, I'm going to deny your objection. I'm going to encourage you all to go as quickly as you can over this issue.
Yes, this is a major issue, but I'll cover it real simple. It's hard to believe, but there's an environmental group out of Carbondale called the Wilderness Workshop, and they filed an action with the BLM contending that back when the NEPA law was written, the face of the NEPA law says in it that the BLM shall do an EIS, and that stuff is in the exhibits. And so what happened was that got appealed up to the IPLA, and the IPLA said on a technical basis, that is what the law says. And regrettably, the government's council back that time decided to have the forest rangers prepare the EIS because they weren't as busy at that time, is what I've been told, as the BLM agents. So they wanted to use their fellow agency staff to do the work as necessary. And they did, and they approved all of the EIS work that was done, and they put it up for auction, and we bought it.
When was that? Just for everyone's context.
When were WillSource's leases issued? 19 years ago.
Yes, 1996.
19 years ago, after I put $10 million into drilling wells and building roads, the environmental group successfully came up with an argument so far that said The BLM issued those leases to me illegally, and they're going to take them back from me. Now, if I'm trying to work out there in the field under that, somebody says to me, why are you having financial problems? It's really hard to raise money from a bank or my investor group on something that all 7 of my leases have been, I've been told by the BLM, they may take them away from me. We're going to do a new EIS to fix it. And that could take 6 years. And you go, wow. Now, you want me to do a MIT test out there, and I'm trying not to break their rules and the Forest Service rules, and we do a really good job of getting almost an impossible thing done.
So when did you first become aware that a workover rig might be available in this area?
1st of October, when we got notice that they would make a window and come help me and my consultant because of his stellar reputation and relationships.
And where did that workover rig come from?
Fiance Well Service.
And do you know where it was working before it came out to the western
Yeah, it
slope?
happened to be a freak deal. It had been working on the eastern slope, and as the eastern slope was shutting down through lots of issues, it was moved to go back to the western slope home base where its company is, and it literally came over the mountain and came to us, and nothing but good fortune.
So WillSource is lucky that it completed the MITs when it was able to.
Absolutely.
And let's talk for a little bit about WillSource's finances. WillSource is an LLC. Does it have members?
Yes, it's basically a family-owned company. My family and I own, between my father and my brothers and I, my sister, own about 85% of this LLC. I own 60% of it personally. So 60% of all the money issues we're talking about are mine personally.
And WillSource has a duty to its members.
Absolutely. We have to try to take care of all of these responsibilities, including be a good fiduciary for their investments with us.
Has WillSource had any positive cash flow this year?
No. The wells that we have investments in that do produce the downturn of the natural gas since 2008 and now the downturn of oil has caused negative cash flow, meaning the daily operations cost more than the revenue from the wells currently.
So is WillSource operating at a loss each month?
Yes, we are.
And what are WillSource's current liabilities?
We owe about $2.5 million out to bank note, trade debt, and personal loans that family members have lent me in order for me to lend to the company.
What is the value of WillSource's non-liquid assets right now?
Those 7 leases have at one point in time been valued as high as $50 million. And the other assets we have in Wyoming, we're a minority non-op partner in, and we have about $2.5 million invested in those assets, but they're natural gas producing assets. And so consequently, neither of those big assets that we have are marketable, sellable at this point. These kind of actions and rulings really hurt us, our ability to find the buyer. And Ken and I were working on a deal. They're my offset neighbors in this 65 lease thing, and they were talking about buying my whole assets in the Divide Creek. And then the 65 lease deal came along and threatened their ownership of their own leases and mine, and they walked away from the negotiating table, understandably.
Has WillSource stipulated to any facts that would admit its guilt?
No, we purposefully participated in stipulating 2 facts, but the facts don't say that we think we're guilty of, that we should have been issued these novas in the first place. We think they were issued incorrectly.
And so the last question, does WillSource have the ability to pay any penalty issued by the commission?
Not currently. We assume things will get better and we'll fight until we recover.
Thank you very much.
you.
Next step.
Mr. Williams, could you please look at Exhibit GG that was WillSource's exhibit recently admitted?
I got it.
All right. This email from Miss Mosley at the Forest Service was sent in 2012, correct?
Correct.
And this email states that If the reports required for the road use permit have not been completed and the permit has not been issued on the workover rig, or has not been issued, the workover rig would be allowed if the engineer submits a report specifically addressing access for this purpose and a traffic control plan. Correct?
Correct.
Did you hire an engineer to make this report?
No,
But you had from 2012 until 2014 to do so, correct?
correct.
Also, when did WillSource first starting to call contractors in order to schedule the workover rig?
I started personally calling them in late June.
Why did you not start back in September of 2013 or December 2013?
Because this work had not yet been completed for lots of reasons, including the reason that they had at this time issued this NEPA ruling and declared that our leases were in jeopardy. They might just take them completely away from us. And at that point, you have to make some business decisions as to whether you're going to go spend millions of dollars on a road that they're going to take away from you, or work on finding solutions. So we had not responded. We had not finished getting the requirements this letter requires done, and I was working on those at the time.
But the NEPA issue did not affect whether you could get an engineer to do the report.
Absolutely, it affects the business decisions of what should and shouldn't be done in that situation.
Okay. Isn't it true that on September 18, 2014, BLM issued orders requiring WillSource to perform MITs on the wells?
Say the date again.
On September 18, 2014, BLM issued orders requiring WillSource to perform MITs on the wells?
Yes.
Okay. And it says here in this email, which is Exhibit GG, that Ms. Mobley is part of the interagency energy team with the BLM office, correct?
Correct.
And Mr. Ficklin is also in that same office with the BLM.
That's correct.
Okay, thank you. No further questions.
Okay.
Your redirect?
Yes, just a couple questions, just a couple redirect. Mr. Williams, WillSource did in fact hire a third-party engineer to work on that road issue, correct?
Yes, we did.
Okay, thank you.
You have an issue with,
Yes. WillSource calls Randy Walk. So, yeah, that's probably. Ms. Dornsey, could you tell me how much time WillSource has?
38 minutes and 39 seconds.
Thank you.
Do you swear affirm under penalty of perjury that the testimony you're about to provide is truthful and accurate?
I do.
Yes, sir.
how do you spell your last name?
My name is Randy Walk. Last name is W-A-L-C-K.
Thanks, Mr. Walk. And what is your profession?
I do oil and gas consulting, supervision services.
And how long have you been in this area?
I've had my own company 21 years, but I've been in oil and gas with other companies, including mine, for about 41.
And what is your current title?
I'm the president of Walk Consulting.
And are you familiar with the area on the White River National Forest surrounding WillSource's leases?
Yes, I am.
And you've worked in this location previously?
Yes, I have.
And do you recall when Mr. Williams first contacted you to discuss performing MITs at WillSource's wells?
Not precisely. We went out there. I was involved in taking care of the lake, helping laking valves, the hissing, late July. And we had some discussion then about needing to do those MITs.
And are you familiar with the hot oiler truck approach to performing MITs?
Yes, I am.
You'd heard of it previously.
Yes, I am.
And do you recall when it came up with the context of WillSource's wells?
Of course, Reed and I, as I was out there repairing these valves, had some ongoing discussions, but we did have a conference call with Jay Kraybacher somewhere in the first week of August. We had a conference call he brought up the fact that we could, one of the possibilities was testing with a hot oil unit. Really has nothing to do with hot oil, but just a pressure unit that we could take up there.
And have you worked with Mr. Kraybacher before?
Yeah, I've
Professionally?
known Jace professionally since he started for the oil and gas, I don't know, 16, 18 years ago.
And so you trusted him when he gave you this advice?
Yes, I did.
And it was reasonable for WillSource to follow up on the hot oiler truck approach?
Yes, the reason not only to follow up, I did follow up.
And how, can you tell me how you followed up?
Well, his suggestion of a wire line or a pressured unit to test has some downhole requirements. You can't set a packer through tubing. So if there was tubing in the hole, you couldn't set a packer for the isolation you would need. And if there was a packer in the hole with no perfs open above it, that would have been a good approach. So that required really going back into well files and determining what we had down hole, whether it was a packer, where the tubing was set, whether there were any perfs open above. And I did spend 4 or 5 days. The well files, the only well files I had that were stuff that Delta Petroleum had turned into the state, and they were pretty poor files. It really took some digging. And even once I was sure of what was in the well, we couldn't determine that there was or wasn't packers in the hole, where they were set. So I concluded the only thing we could do was take a rig out there. And even once we took the rig out there and pulled tubulars, it still didn't conform to what was in the well files. So good thing we did take a rig out there.
And while you were doing your research, you were working in good faith to determine how an MIT could be performed, correct?
Yeah, that's correct.
How many operators did you contact once you realized the hot oiler truck approach would not work?
Once we started looking for a well service contractor, I talked to 3. I probably attempted 5. There was 2 that had transferred their phones to either the Eastern Slope or Vernal, Utah. But I did talk to 3 well service contractors.
And were any workover rigs available?
No.
And were you present in the field for all the work that was performed at WillSource's wells?
Yes, I was.
Were other agency officials present to witness the MITs?
Yes, when we was ready for the actual pressure tests, both the BLM and state had representatives out there.
And were you in contact with those agency officials throughout all of the ongoing operations?
I was through either a text or email. I would kind of let them know how we was progressing. So they had at least an overnight indication of when they needed to be out there the next day for the actual test.
Which well was the first to be tested? Do you recall?
We tested the well source 113.
And did that well pass?
Yes, it did.
And then where did the workover rig go?
We moved the rig directly from the 113 on up the valley to the Little Beaver 120.
So let's talk about Tuesday, October 28th. Do you recall what happened at the Little Beaver 120 well that day?
We do.
We can talk about Monday also if you'd like.
Yeah. We had moved the rig up there on a Friday so that we was prepared Monday morning to pull the tubing and run a packer back in the hole for the test. So that Monday, we actually was able to discover or created the leak in the casing. We had the packer set then below the leak so that Tuesday we was prepared to show the state that there was a leak.
So the leak that you're talking about, was that the cause of the failed MIT? That caused the MIT not to pass on the 28th?
Correct.
And
I might mention that we was then isolated Monday afternoon. we had found the leak and isolated it mechanically at that time.
And what is the effect of isolating the leak?
Well, it'd be in essence, a mechanical repair.
And you mentioned that on Monday you may have caused the leak. That's possible that you could cause the leak on Monday. Can you describe that, please?
Well, as quickly as I can, these squeeze jobs or old squeeze jobs have a tendency to break down. So it could have broke down from well pressure over the years. The original squeeze job may have been a pretty poor job. Based on well records, that wouldn't surprise me. Or we could have actually, in the process of testing, and although our pressures were low, I don't think we exceeded 1,000 pounds, we could have broke down that old squeeze perforation at that time during our test.
So did the field agents advise WillSource to correct the issue immediately?
Well, after we did the test, there was some conversation on location. And again, up where we was at, we only had a satellite phone and it was spotty. So there was some conversation. By the end of that day, we come to the conclusion the state would have allowed us, was told the state would allow us 6 months to make those repairs. But the BLM representative had talked to his boss, which I believe was Ficklin, and we was told to effect immediate repair.
And did the state field officer ever mention that WillSource would be penalized for the days of the failed MIT?
No, no mention.
So how did WillSource proceed in repairing the cement, the open perf?
Well, again, as quickly as I can, Tuesday night when I got in from the field, I made calls to Halliburton to do the cement squeeze job. We got the procedure Wednesday, reviewed the procedure. Couldn't go back out Thursday because Halliburton's cement equipment wasn't available. So we scheduled the squeeze job for Friday morning. And again, all this time, Wednesday we did go back out and pull a packer, killed a well, pulled a packer, run back in with a cast iron bridge plug, and then come out, went back in with a cement retainer. Again, so all this time the well has achieved mechanical integrity. It was either killed with water or we had tools in place. And then we cemented then Friday morning with Halliburton. It's set over the weekend. We spent Monday and Tuesday drilling out and was able to perform an MIT test. Then prior to drilling out the cast iron plug, we performed the MIT on Wednesday 6th, I believe.
It was November 6th. Did you have to get permission from either the state, the commission, or the BLM before you could perform the cement squeeze job?
If I can't recall whether we had to get permission from the state. I mean, it was obvious. Of course, we was going to make a repair. It was a little strange where the BLM had told us we had to effect immediate repair Thursday afternoon before we go back out on Friday morning to perform the cement. I'm informed that we have to have permission to effect the repair. So on one hand, they told me, got to do it right now. On the other hand, they said, can't do it without our permission. It was strange would be a mild word.
Is performing a cement squeeze job within only 3 days considered fast in the industry?
I would say from the time we found the problem, not necessarily fast, but in the case of where we was at, and given the reduction of services in the peons, that was a timely repair.
Do you know of any way that WillSource could have performed the cement squeeze job any faster?
No.
And are you aware of how Mr. Williams responded while he was in Denver, I guess, to performing the cement squeeze job?
Yeah, of course, we had conversations all through the process on these MITs. I was doing daily reports as needed, contacting them with satellite phone. When we found out, of course, that we did have a leak, Monday, when we had already determined we had a leak prior to officially showing Tuesday, then failed MIT. We was already talking to Halliburton, in conversation with them. I know one of the things that Reed had to do was physically walk a check down to Halliburton's office before they would approve his credit to go ahead with the job.
So that helps help the cement squeeze job be performed more quickly.
Yes.
And throughout this whole time, you were acting in good faith with commission staff on behalf of WillSource, correct?
Yes, it was.
And one last question, has WillSource been able to pay you for your work in the field for the MITs?
No.
Thank you, Mr. Walk.
Good morning, Mr. Wolk. Or I guess afternoon, almost. You stated in direct that you could have caused the leak during the MIT test, correct?
Yes.
But isn't it also true that the leak could have existed prior to that?
Yes.
And possibly long prior?
Yes.
Thank you.
That's it? Okay. Do you have additional witness, Mr. Kevin?
No, we don't.
All right, advise me as to our next step.
Does staff have any rebuttal witnesses?
We do not.
Okay, well then we're just ready for closing arguments.
Okay, we are ready for closing arguments. And we have had, I think, thoroughly heard pretty much everything that has transpired, and I think we've been relatively generous in allowing you to make your case. So closing arguments probably don't need to be lengthy.
All right, that's a suggestion. I'll keep this brief then. What you have heard today from WillSource are excuses for not complying with commission rules. I'm going to focus on the issue of the Forest Service road first. WillSource has presented Exhibit GG today as evidence that the Forest Service would not allow them to use the road for a workover rig. However, I'd like to point you to their Exhibit CC, which is a BLM order that was entered on January 22nd, 2015. I think it is the second page of this order refers to a 2008 letter sent by the Forest Service. And if you don't mind, I might read a little bit of that now. This paragraph states that
Which one?
Exhibit CC, second page, third paragraph.
Thank you.
In March 2008, the WRNF sent letters to every operator on lands in the National Forest, including WillSource, informing them of the requirement to have a road use permit. WillSource's contention that in 2012 it learned of the sudden change in policy does not match the record. WillSource has been aware of this policy for 4 years. In Exhibit 2 of the request for suspension, a summary of an on-site visit to discuss roadwork and road use permit shows that WillSource was not prevented from accessing its leases. In the paragraph titled Workover for 120 and 113, WillSource's consultant states, "It is anticipated that smaller truck-mounted rigs could be used to do this work. Thus, some of the previously described road improvements may not be needed prior to the workover work. The need for improvements to the road access to the areas was the result of a proposal to drill up to 3 wells from a single pad. This would have required a larger rig and more truck traffic in general that would have a greater impact in the road than a smaller rig for only 1 vertical well." This order shows that Forest Service Road 800 was going to be usable for bringing a workover rig in to perform the MITs. In addition, WillSource had from 2012 till 2014 to schedule a engineer to come do a report and a traffic control plan for these issues, yet they chose not to. In addition, in Staff's Exhibit 7, there is an attachment to the 2013 variance request, which is a letter signed by Mr. Williams. In that letter, it states that Mr. Williams was planning on meeting with contractors who can be hired and sent into the Little Beaver 120 to perform just the MIT in October, if I must do the work by then. This was in 2013. If it was possible for WillSource to perform the MITs in 2013, then how can WillSource then claim impossibility in the same timeframe in 2014? Moreover, regarding the hunting season for deer and elk, this hunting season did not begin until August 30th, and the date of ledge violation was August 1st. In addition, neither the BLM or the Forest Service prevented or delayed the MITs when they were performed in October. Turning now to the issue of whether about staff's confusing statements. WillSource has provided no evidence that it attempted to schedule contractors prior to June 2014, as stated by Mr. Williams on Cross. The operator had from September, or actually earlier than that, from the warning letter to start contacting contractors to schedule that workover rig, yet they chose to wait until June. I understand that there might be issues with their leases and such, but that does not put on hold their obligation to comply with state rules. In addition, Mr. Krabacher's statement that they could investigate a hot oiler truck method has been held up as some excuse for not contacting staff earlier or trying to work on this earlier. Frankly, they could have contacted him much earlier. They could have contacted him back again in July or September or December. In addition, Mr. Williams has been in the oil and gas business since at least 2006. He has been aware of these specific requirements since 2013. It is the burden of the operator to determine what will work at a particular well to achieve compliance, not staff's. Staff might not be aware of what's necessarily going on in a particular well, but the operator should be at all times. Honestly, that staff is being blamed for the operator's own delay is a little beyond comprehension, especially because this operator was given a 1-year extension, chose to do nothing, and now is blaming staff. Turning back to the economic benefit one more time. Mitigating factor number 6 can only be viewed in conjunction with aggravating factor 8. Aggravating factor 8 states that the amount of economic benefit from non-compliance can be considered in determining whether the penalty should be increased. Here, WillSource should have performed 2 MITs by today's date, but instead it has only performed 1. Under the WillSource's own cost calculations, it has saved itself $116,000. Performing MITs costs money, but they are a necessary cost for responsible and safe oil and gas operations. WillSource should not be rewarded for a cost it is already required to pay. Such a reward would be a windfall in addition to the economic benefit the operator has already received. In Staff's Exhibit 12, there's an attachment to the request, the variance request that is signed by Mr. Williams. Again, this is a letter. In that attachment, Mr. Williams states that sending a workover rig to the site to do the MIT alone is not an efficient or economic step to require, given the BLM's notice of potentially taking away the benefits of the lease in the well. WillSource may believe it should be exempted from performing the MITs because it is not efficient or economic at a particular moment in time, but commission rules on MITs don't allow change based on an individual operator's convenience and, yes, unfortunate circumstances. Lastly, turning to the issue of WillSource's ability to pay the penalty. While the ability to pay the penalty is not a mitigating factor under Rule 523D, the Commission has historically considered it in circumstances where it would jeopardize the operator's ability to continue operating or to perform the necessary remediation. Here, WillSource did not demonstrate to staff that its inability to pay should reduce the penalty. Staff is more than willing to discuss a payment plan if necessary, and in fact, we have a payment plan ready should you just determine that that would be justified. However, an operator's inability to pay under these circumstances should not eliminate or reduce the penalty. These rules were violated, and this operator should be penalized for that. For these reasons, staff requests an order finding violation, finding the November NOAVs were properly issued, that the performance of the corrective action does not moot the November NOAVs, finding WillSource in violation of Rules 326B1 and 326E, imposing a $24,000 penalty for these violations, and not applying any of the mitigating factors. The MITs on these wells were overdue 8 years. When they were finally performed, one of them failed. This is what is important, and this is why we are here today. Thank you.
Thank you. Ms. Kavanaugh.
Commissioners, enforcement staff is here arguing that the issue to be decided today is black and white, but it is not. You've heard today that WillSource did everything in its power to perform MITs at its wells as quickly as possible, and yet has still been forced here today to defend itself against outrageous penalties. Staff has been treating WillSource as if WillSource has been arguing that it has no requirement to complete MITs at its wells, when the opposite is true. WillSource worked with commission staff directly and completed the successful MITs at both of its wells. Staff relies on WillSource's Exhibit CC and statements made by the BLM regarding WillSource's use of the road. Again, the BLM and the Forest Service, despite any existence of an interagency office, are two separate agencies. They're federal agencies with federally mandated authority, and they cannot confer their authority on each other. Also, the decision that was provided as WillSource's Exhibit CC is under appeal at the state director of the BLM, and so therefore is hearsay to the extent that staff relies on the statement to prove the matter that it asserts. We're talking about the alleged dates of violation, August 1st until August 10th. You've heard overwhelming evidence today from staff and from WillSource itself that from August 1st until August 10th, WillSource was working hand in hand with engineering staff to determine the most efficient way to complete the MITs. Staff's overzealous enforcement proceedings threaten more than just WillSource's livelihood. Staff's actions today foster mistrust between it and the agency. It's hard for the agency to ask industry to work in cooperation with commission staff when it's clear that industry cannot necessarily rely on the statements given to it by staff. Staff's behavior actually encourages operators not to perform MITs at their wells if operators know that they will be penalized for failing an MIT but immediately repairing that failure. Staff's also erred in issuing the July NOAVs prematurely. Staff erred in enforcing the erroneous July NOAVs against WillSource. Staff subjected WillSource to unlawful enforcement of the July NOAVs from August 28th until November 18th. Throughout that time, WillSource was forced to spend time and energy and money defending against NOAVs issued without reasonable cause. Staff further erred in issuing the November NOAVs after both of WillSource's wells had successfully passed MITs. Staff has even failed to properly calculate the number of days for the alleged violation of 326E at the Little Beaver well. We've heard that the repair was completed within 3 days of the failure, not 4, as staff alleges. Staff has disregarded WillSource's good faith actions and argues that WillSource should be penalized to the full extent allowed by the commission rules applicable here today. Staff seeks $24,000 in penalties from a company with negative cash flow. As you've heard, WillSource's current liabilities total well over $2 million, and WillSource's largest asset, its 7 federal leases in the White River National Forest, have been rendered valueless by the BLM's notice that it may modify or cancel those leases. The purpose of this commission is not and has never been to seek retribution from an operator who has complied with the commission rules. What the commission must now decide is what the commission rules, in effect as of August 1st, 2014, require. Despite staff's arguments, this commission has the discretion to find that WillSource is not liable for a violation of commission rules and to find that no penalty should be imposed against WillSource. Thank you.
Okay. Marcy, is there anything else we need to hear from before we close?
If staff wants to rebut, do you have any rebuttal? No?
No, we record.
Well, then closing of the record, just closing of the record. And then deliberations can begin.
All right, we are going to close the record as of this time. And with your permission, we're going to continue on with our discussion and deliberation. Oliver needs to leave possibly an hour. Go ahead and use his wisdom before he disappears into the sunset. All right.
May I make one quick observation?
Actually, you can make it long.
No, to me, there's three, and I don't know how you want to approach each of them. And of course, affirmative defenses to consider with respect to each of those claims. One is the 326B1 violation, alleged violation concerning the WillSource 113 well. And then two alleged violations concerning the Little Beaver well, 326B1, which is the identical violation concerning the performance of MIT, similar to the WillSource 113. The additional violation, alleged violation of 326E.
Okay. Now, while you're thinking, I'll make just a couple quick comments. I have the great fortune of doing with the Forest Service, I like with the grazing rates. Very minor, not a big deal. Total understanding and comprehension of some of the issues that you've raised in dealing with the federal agency and how they operate or have to operate. So I hear what you're saying here. I understand that. As to whether or not having to do that is a mitigating factor. But I'm not sure. I don't know. You know that, in fact, at times you get conflicting information from those agencies. And that sometimes makes it difficult since, as testified, they don't have a lot of money, but they want work done. And if you're a VC, you're kind of in a position where you're going to do the work. You have to make some decision. I'm going to do this work, but I'm probably going to irritate one group within the agency while satisfying another. I understand that. As they say, I have been there and done it. It almost feels like mitigating factors that we have to consider. I'm still struggling with the timing. The original MID, which was subsequently was staff at some point felt like they jumped the gun and issued it. Certainly understand. Then, the subsequent one, similar, not identical. I'm struggling with it, so help me out. Dr. Allward, you usually help me out.
But I don't want to step on anybody's toe.
Oh, no, I have boots on. We're looking at the final orders, and then the material we have. Almost like we have a selection of final orders. I don't know which one.
What page are you looking at?
Currently, I'm looking at 121, 123.
Oh.
Yeah. Oh, where are
Yes.
they?
They're already cited in the packets.
Are they proposed?
Yeah, there are proposed.
Yeah. Are they?
I'm just kind of operating on the assumption that that's the last one in the packet, that's the one.
Yeah, those would be the last ones in the packet. There was, I think, 3 from Will Source and 1 from the staff. And the 3 from Will Source are, if you overrule this, then we want you to do that, and it varies from there. And then the one that is the staff's is what the staff is asking for the full $24,000 penalty, I believe.
General comment?
General comment.
Just general. This is, my thoughts on this thing, and it's more on feelings, and you still have to go through the deliberation, and I'm anxious to hear everybody talk. One of the first things that I'm hearing, looking at that board, I'm hearing the ideology of the situation. To me, rules and regs are idealistic. They're what's happened, everything works fine, and you can get them done. What I hear from Will Source is the reality of trying to get anything done when you're dealing with multiple people in charge, multiple agencies in charge. When you're dealing with something as volatile as gas prices, which have totally tanked, which will, for a long time, be a burden for anybody trying to operate in Piedmont. Marcellus, quite frankly, is going to overwhelm any production anywhere because it is so prolific. So that's ideology. This is reality. If you're operating, you got to follow the rules. We have mechanical integrity for a reason. The last thing we want to go ahead and do is contaminate an aquifer. And looking at that, yeah, there probably were 2 that should have been done in the timeframe. The reality of it is, not only did you have to deal with the state, but you had to deal with the Forest Service, the BLM, the reality of a downturn in price when equipment got shifted to other places that still had operations. Right now, I'm still trying to figure out what to do, but the situation is such that ideology and reality are in conflict now, and we got to figure out where we come out with it. And I'm looking forward to my peers to shed some wisdom, particularly on the legal side, because it's not a good situation.
Go ahead. Put your thoughts together.
I think actually the legal side of this is pretty clear cut. I think there's been a violation. I don't think there's any question in my mind as a matter of law and what our rules and regs say. And I completely agree that compliance with our regs is not somehow contingent upon the price of gas. In fact, just categorically reject that. We've had this discussion before. There are risks associated with jumping into this activity and having the capital to weather what over the course of the life of a well will be 2 or 3 or 4 downturns is almost inevitable. And if you're not willing to capitalize at a level to comply with our regulations, go find another business. I think that we granted the extensions. I think we participated. Yes, there were some issues at the end about when the violation should have been issued, but outfitters, in my estimation, experience, don't move in on October 1st. The last thing they want is their camp sitting up for 3 or 4 weeks prior to the open of the first season. I don't think that's a factor. And I think that an operator, again, has to look into the future and get ahead of these curves and be prepared to mobilize the resources to make sure that they're in compliance. An operator who hasn't done a mechanical integrity test for 8 years is not on top of their operations. We brought it to their attention and still gave them a 1-year extension. So I think we operated in good faith on that account. I'm not looking to hammer this operator. Frankly, I don't think a $24,000 fine is hammering an operator in light of the cost of running an oil and gas operation in this state. So, and the other thing I just have to say, the idea that we would create a perverse disincentive for complying with MIT tests because if you look, you may find something, I categorically reject that too. That is an absurd argument in my mind. So I think this, the idea that we went 8 years without getting a mechanical integrity test causes me tremendous heartburn. But that's a discussion that we have internally. That doesn't get held against an operator, but even after that period, still give a 1-year extension and have the issues that we're dealing with. I think we have to walk that balance between making sure that the public understands that we are enforcing our rules, that they're not voluntary in nature, and coming up with something that the public will say, yeah, that passes the straight face test. Not punishing an operator inappropriately, but holding them accountable and making sure that other operators understand that compliance with our regulations is not optional.
Mr. Allward?
I really appreciate the perspective. And I'll just back up and reaffirm one thing with regards to the prices. Prices of resource, I don't see them as in any way relevant, in part because they're not producing. They haven't been producing. So it doesn't matter what the price has been. That shouldn't be what's affecting the decision. And the price was through the roof in 2008. And we had no MIT. So I think that while it certainly does enter into business decision-making process, it doesn't justify non-compliance. Testimony that we've heard actually questions their arguments that they couldn't get there. It was just entered today that indeed they could get to the wells had they pursued it. They argued that there are external political factors going on, but those are always going on. They're going on today. They'll be going on forever and still need to comply with the rules. I fully understand their difficulty with dealing with multiple federal agencies, a state agency, and I don't know if I've worked up in that area as a third-party contractor, and then you toss in two counties also. And it's a nightmare, no doubt about it. I prefer not to work on Forest Service because you end up then with BLM and counties and states and all that. So yeah, it is difficult, no doubt about it. It's difficult to ensure that you are abiding by all the rules and the various rule changes that can be taking place over the lifetime of a well. But that is in part, I mean, the staff is commendable in that they grant variances and work with operators, recognizing that, especially with smaller operators, that it can be difficult. And that it's important, what we want is compliance, not to punitively penalize operators who are trying to stay in compliance. So I'm troubled also by the testimony of the last witness who talked about how much time was spent trying to figure out what was downhole. That suggests to me that they had no idea what was downhole up until 2014. That's disturbing and suggests that they haven't been on top of their responsibilities, and that when there are difficulties, important that you work with the regulatory agencies, and I don't see evidence of timely communications from this operator to our agency, COGCC, expressing their difficulties with being compliance schedules. That variance that went through the end of July 2014, heard testimony that only gave them about 15 days to come into compliance. But did they communicate that with staff in December or January or February or March? No. But that's not something that just came up. So I'm not seeing anything in what was presented today that suggests to me that staff has done anything untoward. And but that we do indeed have violations in front of us.
Mr. Chairman.
Commissioner Hawkins.
Yeah. I want to agree, I guess, with Commissioner Allward and Commissioner King. It appears to me that when the company took over these operations or these wells in 2006, that they should have been familiar enough with our rules that they're purchasing wells in our state that we have a requirement that they either run an MIT or return their well to production. And so I feel like they've had almost 10 years, since 2006, since they took over operations to perform an MIT on their wells. And admittedly, there's a lot of difficulties working with multiple agencies, but there's a lot of operators in our state that work with multiple agencies. So it's not an impossible task. And I agree, it wasn't until they received a warning letter that we started to see some action. And they did request a variance, and that was granted. So I think the state worked with them to give them ample time to try to figure out how to get these MITs performed. And I don't see that they were, responsible enough to get that done within their variance time. So I view these as violations of our regulations. On the 326B1 for both the Will Source 113 and the Little Beaver 1-20. On the other hand, I think after they did do the MIT work on both of those wells and found one that needed repair, I feel like they were reacted as quickly and as responsibly as they could in getting that well repaired and passing an MIT. So I don't really see the benefit of fining them for an additional 4 days in there that they were potentially in violation of not having the MIT. But I do see that they had some significant violations by just avoiding their obligation from 2006 forward.
Additional comments or?
So when were the violations? When did they occur? I mean, when did you give them the NOAV? I mean, some of the paperwork that I'm showing, it says that November 13th to 14, well past MIT, and then we gave them an NOV on that day. Am I reading that right?
Can I respond to that?
No, record.
Commissioner,
I can't see that, but
I can give the way I interpret this, okay, is that once their variance expired on July 31st, they were in violation of the rule at that point on August 1st. Now, whether they got an NOAV before then or after then or anything else, that was the date that they had plenty of opportunity to have complied and failed to do so. So the violation period would start August 1st for 10 days under the old rules.
So why wasn't an NOAV done August 1st? Or August 2nd?
That was the disconnect. They had to go back and revise it and issue it because they did it before July 31st. And that was the one that was issued too early. That was inappropriate. Mr. Chairman, if there's further discussion, I'm obviously open to it, but I'm prepared to make a motion.
Biggest thing for,
make a motion, we'll have the opportunity.
just one more comment.
Please.
I mean, the biggest thing for me is that the wells are in compliance now. I mean, they weren't for 8 years, but I think that's what our rules are meant to do, is to make sure that stuff gets into compliance. And maybe it's a process we need to change within the commission itself so that we're a little bit more aggressive about making them comply.
May I? I don't disagree, but I think the amount of work and the amount of process and the amount of time and resources that were expended in order to gain that compliance shouldn't be overlooked. And just for my part, since I'm not the technical guy on this particular subject matter, just at the 30,000 foot level, it seems like there's a lot of activity and a lot of talk, a lot of potential credible and not credible reasons for missing dates and access and timelines and things like that, but that it's all in this latter period. When again, from where I sit, back to a point that was made, if you're going to do business, if you're going to purchase wells, you should understand the rules. You should understand where they're located and the federal agencies that you're going to have to deal with. And there was just a very long period of time, whether you look at 1 year or 8 years, in order to make sure that you were in compliance. So.
May I make one?
Would you please?
Quick. During Ms. Maxted's opening, Will Source objected to the reference to 6 or 8 years in the past and said there's a 1 year statute of limitations in our act. And that's exactly right. There's a 1 year statute of limitations. And Director King said, well, I'd like to hear the bigger story, the broader story, with more context. And I think he's done that throughout his hearing, whether it's admitting evidence or understanding that broader context. If you find a violation, it needs to be within the last year. The conduct for purposes of assessing liability beyond a year from the issuance of the LAV. Relevant. It provides important context, but it can't form the basis for liability.
Okay, Commissioner King, you're ready.
Mr. Chairman, I'm going to roll up the proposal for an order finding violation as well as the fines. And if the council tells us we need to tease them apart, we can. I just want you to know where I'm going in total as I roll this out. Mr. Chairman, I would move that we find an order finding violation for 326B1 on the Will Source 113 well, as well as the violation of Rule 326B1 on the Little Beaver well, commencing August 1 and going for 10 days thereafter. 2014 is the year. I also move that we not find a violation on 326E for the Little Beaver well, and that the fine will be $500 a day for each of the wells, so $1,000 a day total for the Will Source and Little Beaver violations, and for a total amount of $20,000.
Okay, you heard the motion. Is there a second?
I'll second.
We have a second. Any further discussion?
$500 a day for 10 days each, up to $10,000.
Right. But both. Did I misdo the math?
Yeah.
It's not surprising if you know me.
10 days. Staff suggested $1,000 a day for 10 days.
You're right.
That's one violation for each. So.
I would amend that to $1,000 a day for each well for a total $20,000 fine.
Second. Okay, any other discussion?
I have a question.
Commissioner Oliver.
So I'd like to know why you don't see a violation of 326E. I recall at a hearing in, I think it was in Rifle, where we discussed when an MIT test is overdue and the results of it are that it fails, that means we should really throw the book at somebody, because for all we know, we have no idea how long it's been failed. What we could do is say back to when the last MIT would have been required. We could count all those days. And so to say we're not even going to count 4 days, and that's troubling to me, and what that says.
Mr. Chairman, I would not pretend to have done anything other than advocate for the theory that we learned in law school called rough justice. I get the point. From my perspective, it goes to Commissioner Hawkins' correct assertion that when there was a problem found, the response was very, very quick. And so it is a balancing of the equities as I see them, and nothing more than that.
Was there a comment made that they were pressuring up? That's when they might have lost the problem? So until we know for certain,
Which we never will.
which we won't. So we're cutting some slack. I don't remember the term you used, rough justice or whatever. Okay. So that's why I want to.
Okay, I intend to support the motion. You have demonstrated that. Violation. Didn't to address those the argument could have been better done, could have been earlier, and quicker, but I'm going to support the motion. I think that makes reasonable sense, and I think there's a case to be made for encouraging the company to address the problem as quickly as they can, which I think termination of a 4-day penalty does. Any other comments?
I'm going to support the motion as it's been put forth. If the mover and seconder was interested in accepting an amendment, perhaps finding them in violation of 326D, but waiving any fines, recognizing the prompt response of the operator to fixing the problem. But whether or not that amendment is accepted, I will support the motion.
That, whether we can even do that goes to we're acting under the old rules, not the new rules, because the new statute says that if we find a violation, we have to issue a fine. And I don't remember whether the old statute had that same requirement.
And we don't know the process.
That's a good point. Dr. Craig raised a good point. I'm going to not accept the friendly, I'm rejecting a friendly emotion because it wasn't friendly enough.
Now, that was rough, Justin.
Okay, any other discussion or comments? If not, those in favor of the motion indicate by saying aye.
Aye.
Opposed, same sign.
Nay.
We have a nay. Commissioner Wall? Is that recorded? So the motion carries. All right then. Let's see.
I would suggest that we take our afternoon break at this point and start again at 1 o'clock. 20 minutes?
Yeah, I think we can do it. 20 minutes is enough. We don't have any other business during lunch. Going to go ahead here in just a moment and convene. I did want to stay off the record. It's really a waste of time, and off the record. That for 2 weeks, I've been looking forward to listening to a Jost versus Wozniak discussion. So I hope word gets back to Mr. Wozniak how disappointed.
We will let him know.
Okay, docket number. Is this right? Maybe I better just let Ms. Dorancy tell us. We're going to deal with docket number 1410GA06.
Yes. And actually, I need that.
Why does that have the old nomenclature?
Yeah, I need the mouse.
Oh,
I was gonna show
get me to move?
No, just pass it to me.
Okay.
And we do have a quorum. Dr. Walk will be back momentarily. But we have a quorum with
In
them.
the top. Or just do the main.
It's Jane.
Do you want me to do it?
No, Jane is gonna help.
Okay, Ms. Dorancy, we're ready. If you want to kick off.
Yes, I am ready. This is the matter of docket number 1406. I need to, my map up. 1410 GA06 in the matter of the objection of KP Kaufman of Encana's proposed wells. My name is Jill Demancy. I'm the hearing officer in this matter. The parties are present. I would ask that they identify themselves for the record and the party with whom they're associated.
Jamie Jost of Jost and Shelton Energy Group, here on behalf of KP Kaufman Company, Inc.
Karen Spalding and Jill Durancy, Beatty and Wozniak. Excuse me, Jill Fulcher, here on behalf. Excuse me.
That's what.
I'll start again. Karen Spalding, Jill Fulcher, here on behalf of Encana Oil and Gas USA, Inc. from Beatty and Wozniak.
It was not a Freudian slip, I'm hoping.
Now, just as in terms of introduction and a background on this matter, on or about June 9, 2014, Encana sent notices by certified mail of proposed wellbore spacing units within Township 1 North, Range 65 West, Section 2. The 9 planned wells, as indicated on the PowerPoint, within the application lands were proposed running north and south, and they're circled in yellow and orange. Damn it, I don't know how to do this. Go to the next slide. On June 13th, KP Kaufman acknowledged receipt of those proposals. On about June 30th, 2014, KPK objected to those proposals. The objections filed by KPK were not perfect. However, staff accepted them as valid objections. On or about July 31st, 2014, KPK filed 6 applications for permits to drill for the south half of the application lands with the wellbore orientations running east-west. Those passed for completeness on August 1st, 2014. On August 7th, 2014, Encana filed 9 APDs for wells in bottom hole locations in the south half of the application lands. In its APDs, Encana did not identify that there was an objection to the well proposals. On August 28, 2014, Encana filed an application with the commission for an order to approve the APDs to be drilled in the application lands. The application filed by Encana also was not perfect. However, we accepted the application as a request for hearing on KPK's objection to the well proposals under Rule 318A-E5. On October 10, 2014, KPK filed a protest to the application and a motion to dismiss. On October 20th, after this matter was already ensued, the COGCC published a guidance regarding the Rule 318A GWA spacing units. The premise was to provide guidance and an explanation of this expedited process to the operators and to encourage the operators to work together in this area. On December 12, 2014, Encana filed an amended application requesting an order to establish an approximate 960-acre drilling and spacing unit, which included the application lands. On December 24, 2014, Encana filed a second amended application requesting an approximate 640-acre drilling and spacing unit for these application lands. On or about January 14th, 2015, KPK filed a second motion to dismiss and a protest to the second amended application. A pre-hearing conference was held on January 29th in which each of the parties argued their respective sides in the motion. On February 11th, I issued an order on the motions to dismiss, granting in part the motion by dismissing the amended and second amended applications filed by Encana as invalid amendments because the amendments were too significant and did not relate back to the original application on the objections to the wellbore spacing units. The order also retained the original application filed by Encana on the wellbore spacing units and set this matter for hearing. The purpose was to ensure that notwithstanding the mistakes made in this case by the parties, that the matter would be heard by you today. A motion for reconsideration was filed by KPK of my order. That motion will be argued this morning after Permitting and Technical Services Manager Jane Stanzik provides a brief overview of the administrative permitting process under Rule 318A to you.
Good afternoon, Commissioners. Whoa, sorry. As Mr. Ansey has stated, I'm just going to present a brief overview of the regulatory procedures for the creation of Greater Wattenberg Area Wellbore Spacing Units. The Greater Wattenberg Area, or GWA, Wellbore Spacing Unit is a unique feature of Rule 318 Big A. It provides operators a quick and direct method of creating a unit, as the director administratively approves the unit without a commission hearing. Because the unit configuration is tailored to each individual well, it also allows maximum flexibility for a variety of well designs. In order for all parties to realize these benefits, there must be a high level of cooperation among operators, and all operators must understand and respect the procedure. This overview will outline the rule requirements, some changes in industry practices relating to this rule, and the recently developed COGCC guidelines. An operator wishing to create a wellbore spacing unit must first provide notice to all the owners within the unit. The information included in this notice is specified by the rule. A noticed owner may object to the proposed unit. The objection must be based on one of 4 claims defined by the rule. It must be made in writing with a copy to the director, and it must be made within 30 days of receipt of the notice. If no objections are received after 30 days, the operator submits the APD for the well, attaching a letter that describes the proposed unit and certifies that no objections were received. When the director approves the APD, the unit is approved. If an objection is made, the parties can resolve issues privately, in which case the objection is withdrawn. Or if unable to come to an agreement, the proposing operator can request a hearing before the commission, at which the objecting operator bears the burden of proof that their objection should stand. Here are the 4 claims upon which an objection to a proposed unit can be based. The notice did not include all of the information required by the rule. The proposed unit will result in waste. The proposed unit will adversely affect correlative rights, or the operator proposing the unit is not an owner of the mineral estates through which the wellbore penetrates the target formation. The rule also requires the objection to be supported by specific facts. In the past, objections were made, but operators typically resolved their issues and then submitted their APDs, as outlined here. Because operators worked things out privately, there was little need for COGC staff to be involved with the details of the objection. Recently, however, some operators have not fully complied with the rules. Some of the compliance problems are: not all the owners within the proposed unit are notified, the notices are incomplete or inaccurate, the objections are invalid or are not timely, the director has not sent a copy of the objection, The letters inaccurately certify that no objections were received, and the APDs are submitted prior to the end of the 30-day response period for objections. The lack of compliance created considerable confusion for operators and for the permitting staff. In order to sort through the chaos, staff began to carefully review and track the objections. We also created guidelines for industry. The guidance explains the requirements of the wellbore spacing rules and clarifies the expectations for compliance. It explains that staff will review the objections and determine their validity. And finally, the guidance reminds operators that if they cannot successfully use the wellbore unit process, they do have the option to apply to the commission for an order creating a drilling and spacing unit.
Before KPK starts its motion for reconsideration, I want to advise the commission that the ultimate issue today is whether the objection submitted by KPK to Encana's proposed wellbore spacing units are valid and should stand. If you determine that the objections are valid and should not be dismissed, then Encana's proposed wellbore spacing units will be dismissed. Go ahead.
Your Honor, excuse me, Mr. Chair, before we get going on that,
Yes, ma'am.
if I might address a preliminary matter that I think will involves the authority of the commission to actually hear this matter. If I may present that to you at this point in time, I think that would be, it's a motion that I've told Ms. Jost about. It's a motion regarding subject matter jurisdiction. I don't think the commission has subject matter jurisdiction over this case. And so I'd like to get that out there for the Assistant Attorney General to consider.
Ms. Jost?
Well, she did tell me about it. I guess it was my interpretation that she was going to do it after the motion for reconsideration hearing. Subject matter jurisdiction, recognizing that can come up at any time. However, I mean, it seems like we should have the reconsideration initially first, because that may absolutely deal with this issue as a whole.
If there's no subject matter jurisdiction, then there's nothing that can be heard at any point in time.
Well, I would object to hearing it at this point.
Do you think that you need to speak before we address the motion for reconsideration?
Yes, I do.
Do you understand the basis of the?
Well, what's your true basis for the subject matter jurisdiction? What rule are you citing to?
The true basis for the subject matter jurisdiction is the commission rules 318 AE5B, which specifically sets forth the facts that must be in an objection letter. And if they're not in an objection letter, then under COGCC rule 318 AE5C, there can be no hearing on the matter. If it says if an objection pursuant to subsection B is timely received. So that's a two-part test. It must be compliant with subsection B. It must state that there's an informational requirement of subsection A that's not complied with by the operator. It must state a technical objection to either waste or causing correlative rights issues, and it must state that the operator is not an owner. You have in your file, you can take administrative notice of.
I think there was a question of what it was under versus argument, so I do have to jump in here.
And CRCP Rule 12-1A is subject matter jurisdiction.
I think I understand where you're coming from, but I also don't want to step on Ms. Durancy's shoes. If this is something you've addressed or you understand or.
I just have two brief statements. First, obviously throughout this process, the original applications were filed in August. Throughout this process, we anticipate that each of the parties will file motions to us in writing so that these matters can be addressed well in advance of this hearing. Our staff did review the document that Ms. Spalding is referring to, and our staff determined that it was appropriate and that it would be more appropriate to have this matter heard before the commission. So at this point, I would, I mean, obviously you have your counsel before you, but we believe at this point that any motions would be untimely and that it should be heard by the commissioners today.
If I might just say, subject matter jurisdiction is something that can never be waived. And the fact of the matter was, because we had the second amended application pending until the pre-hearing conference just recently, we weren't thinking about the original application. We were thinking about the second amended application. which was then just recently dismissed.
It was
And
dismissed on February
so,
11th.
and by the time we got, there was also an order by you closing out the portfolio. And so there was no written motion filed, but just the fact that there was no written motion filed, I don't think can be a waiver of subject matter jurisdiction. It can be filed at any time, even on appeal, so.
Okay, go ahead.
And are you saying that the KPK letter saying your proposed wellbore spacing unit is inconsistent with our development plans, is insufficient to constitute an objection and did not contain the specific facts setting required under 5B?
That's correct.
Great. I will defer to Ms. Durancy on that. She has determined that it was, and I think she's within her discretion to make that determination.
Thank you. At this point, there's a presentation by KPK on its motion for reconsideration of my order.
May I have a minute before you start the time?
Sure.
Thank you.
She'll have 12 minutes for that.
Hey, and I did pass out a hard copy of the presentation as well. Thank you, Jill. All right. So thank you all for the time this morning. Again, Jamie Jost on behalf of KP Kaufman. KP Kaufman respectfully filed a motion for reconsideration on February 23rd, 2015 of the February 11th, 2015 COGCC hearing officer order. KPK realizes that motions for reconsideration are very rare in front of this commission. However, this situation warranted KPK's filing for such reconsideration because of Encana's continuing violation of the COGCC rules and Encana's own counsel's admissions that the original application was not being pursued. First and foremost, the motion for reconsideration was properly and timely filed, and the substance of this motion determines its character and sufficiency, citing very quickly to State ex rel Southers v. Mandatory Poster Agency, Inc., 260p 3rd 9 at 13, Colorado Court of Appeals, 2009. Here, Encana's original application for a hearing on 9 APDs was allowed to stand only by virtue of a mistake and error in the COGCC hearing officer's February 11th, 2015 order, which expressly stated that Encana violated Rule 318A-E5 with respect to the 9 APDs at issue. Please listen to the audio of the pre-hearing conference whereby Encana's counsel up to 5 times states that the application up for hearing today, which is what was in front of you, was withdrawn, was moot, and was not intended to proceed. I really hope this works. Do we have audio on the PowerPoint? Okay, well, I can read it to you then. Let me get this. Okay. That's really unfortunate. So at minute 29, Karen Spalding discusses the original application was essentially withdrawn through the filing of the amended applications. She says you can't apply for a wellbore spacing and a drilling spacing unit at the same time. So the application for a drilling and spacing unit essentially withdraws the application for a wellbore spacing unit, regardless of whether it's done through the filing of a new application or through an amended application. At this point in time, hearing officer Durancy specifically asked Ms. Spalding if she was moving forward on the original application. Her answer was no, they were not pursuing the application on KPK's objections and that the original application was moot. With respect to the second audio that was going to play at minute 31, and I'm stating these minutes just specifically because we do not have the audio and you can pull the transcript and it's at these minutes. Ms. Spalding argues that the original application, as well as the first motion to dismiss that KPK had filed, was moot. At minute 36:40, Ms. Spalding mentions again that the first application is moot. At minute 38, Ms. Spalding mentions that the original application had been essentially withdrawn, is moot, and that Encana was not seeking the wellbore spacing units. And again, I believe at minute 40:10, Ms. Spalding again says that the original wellbore spacing unit application was withdrawn by the filing of the amended application for the drilling and spacing unit. Based on counsel's express statements, the application up for hearing today has been withdrawn. It is moot, and it was an unequivocal admission of counsel that it was not moving forward. The state of Colorado has expressed case law with respect to the adoption of a Childs v. Franco case, 563 F. 290 at 292, Eastern District of Pennsylvania, 1993, that says if unequivocal, A admission of counsel during the course of trial is binding on the client. That was outrightly adopted by the case of Larson v. ATSI in 859 P2D 273 at 275-76 by the Colorado Court of Appeals in 1993. The mistaken error by the COGCC hearing officer was that it did not take into account counsel's express unequivocal withdrawal, and Encana is now benefiting from this mistake on an application it expressly stated it was not going to pursue. This is an error of fact that clearly mandates a different result under Rule 121 of the Colorado Rules of Civil Procedure, and it's also another reason justifying relief from the operation of judgment under Rule 60 Colorado Rules of Civil Procedure. Further, by allowing this hearing to proceed, KPK is prejudiced by the order because it rewards Encana with an express violation of the rules by allowing APDs to remain in place. KPK's original motion to dismiss moved to dismiss the original application based on Encana's failure to comply with Rule 318AE5. Again, the application up for hearing today is only in place by default due to an error discussed earlier, and Encana is not only being rewarded with a hearing it never intended to pursue, but it's also being rewarded with a hearing on APDs that have already been found to be in violation of Rule 318AE5D because they did not specifically identify KPK's objections when filed. Ms. Stanczyk just spoke to you about Rule 318A, and it's clear that the COGCC's GWAL guidance, in that COGCC GWAL guidance, that a submittal of a false certification is a serious matter and can result in an enforcement action. I am not here to comment on an enforcement action piece, but I will comment on the fact that the APDs were filed in violation of the rule. The COGCC cannot allow these to go to hearing when Encana is in violation of the rules. Over the course of the last 9 months, Encana has violated Rule 318A 3 times. By the filing of its APDs on August 5th, and not listing the objections by KPK, first violation. By actually filing its original application to approve 9 APDs, instead of actually filing it to request a hearing on the objections to the APDs, second violation of Rule 318A. And then when we get to actually December 15th, 2014, there were 3 additional APDs filed on the subject lands that are up for hearing today. None of those APDs had the request or the reference to an objection by KPK that was filed last June. So again, you have 3 new APDs that are filed in violation of the rule. Encana will argue that their original application remains in effect because their second amended application was dismissed. This is not correct. Where Encana expressly withdrew the application at the pre-hearing conference, there is nothing to fall back on. KPK has worked through this cumbersome process in good faith for 9 months. At this point, KPK had to preserve its rights for any future actions based on the COGCC's allowance of Encana to proceed on these 9 APDs in known violation of the rules. And I do want to take you back to the order where it specifically states, this is the February 11th hearing officer's order, that says, when Encana submitted its APDs on August 7th, 2014, and inappropriately failed to identify that KPK had objected to Encana's proposed WSUs, wellbore spacing units, in violation of Rule 318AE5D. And a reminder what the guidance says with respect to this. KPK respectfully states that the COGCC hearing officer is very good at her job, and she appreciates the work that, and I appreciate the work that she's done and industry does as well. However, in this instance, KPK has alleged a manifest error of fact, which is supported by Encana's counsel's unequivocal admission that the original application was withdrawn, and this clearly mandates a different result to prevent injustice to KPK. Those are words taken directly from Rule 121 and Rule 160 that allow motions for reconsideration to be heard. KPK requests that this commission reverse the February 11th order and either strike Encana's original application, determine that the application was moot, or grant KPK's original motion to dismiss based on Encana's violation of Rule 318A. Thank you for your time. I really appreciate it. Thank you.
Response by Encana on the motion for reconsideration.
Thank you very much. Karen Spalding, Beatty and Wozniak. The standard of review here on a motion for reconsideration is whether it should be left to the sound discretion of the hearing officer. If the hearing officer abused their discretion, then it can be overturned. If not, then it should be affirmed. The standard of review is not a mistake made by the hearing officer, because no mistake was made, but CRCP 60 is not the rule in this case, as was noticed in the pleading. CRCP 60 only deals with final judgments and final orders and is not applicable in this particular case. We provided you case law on that point in our response. Based on the facts here, Encana submits that the hearing officer did not abuse her discretion, did the right thing in dismissing the second amended application, which we did not appeal, and then in dismissing the motion to, denying the motion to dismiss the original application. KPK's motion for reconsideration should be denied for the following reasons. You have to look at the context of the pre-hearing conference, and you can do that. In the context of the pre-hearing conference, we were looking at two different pleadings. We were looking at an original application that was filed in August of 2014, and we were looking at a second amended application that was filed later on. The original application was on a wellbore spacing unit. The second amended application was on a 640 drilling and spacing unit. These are two separate things, and as Ms. Stanzik said, you can't do both. You either do one or the other. So at this hearing, Encana was wanting to go on the second amended application, which was the 640 drilling and spacing unit. In district court actions, when you file an original complaint, you then file a motion to amend the complaint. The court then says yes or no. If the court says you may amend a complaint, then you go forward on the amended complaint or the second amended complaint. And the original complaint or the original application is, the case law uses the term superseded. So my point was that if we went forward on the 640 drilling and spacing unit, we obviously wouldn't also be going forward on the wellbore spacing unit, because that's a conflict. And so I said it was essentially withdrawn or essentially moot. That was not to say that if the 640 didn't go forward, that we had withdrawn the original application. I was making it the statement in the context of what happens. You have the 640 drilling and spacing unit. If it goes forward, the original one is superseded and would essentially be moot, because you're not going on a wellbore spacing unit. You'd be going on the drilling and spacing unit. So in the context of district court litigation, if the motion to amend the complaint or the application is denied, you go back to the original complaint. And that is exactly what hearing officer Drancy did in this case. She decided that we would not be going on the second amended application or the 640 drilling and spacing unit, but she decided that we would be going on the wellbore spacing unit original application. And I think that is correct as a matter of law. The fact of the matter is the hearing here today is on 5C, whether there is some basis for an objection here. And these alleged violations of statements in an APD, which are under 5E, are really not relevant in this particular case. The fact of the matter is that KPK has put up every single roadblock imaginable after Encana filed its original application, and here we are today. We would like to move forward on the original application. And the key point, I think, for you is that Encana never withdrew its original application, never withdrew the original APDs, and my statements really need to be looked at in context of what was going on. As to the original application, while it does say that Encana is asking for wellbore spacing unit approval, it also has a clause in there under relief that says B. We would like to have any other relief that the commission deems just and reasonable. That would be a dismissal of the objection of Encana. It qualifies under that subsection B in our application. Hearing officer Drancy understood that and actually set the matter for hearing on the KPK objection. And it's notice pleading. Everybody understood. That's why we were here, and that is why we are ultimately here today. We're here on the objection by KPK to Encana's wellbore spacing unit applications. And prejudice, last, doesn't come into play when you're looking to see whether the hearing officer abused his or her discretion. Prejudice to a party, I would submit to you that Encana has been every bit as prejudiced as KPK in this case. Encana's had its application out there longer. And so I think it's not based on the case law, and it's really just not relevant to this discussion. So we would respectfully request that hearing officer Durancey's order be affirmed and that KPK's motion for consideration be denied.
I have additional.
KPK has.
Yes, ma'am. I was just thinking, I wasn't, I'm trying to decipher abuse as opposed to mistake.
Different.
Okay. You want to explain it? Director Lepore would like to.
No.
Okay, I'd just like to make sure that you understand the ultimate question that's being asked at this point, and whether or not you would prefer some guidance on what the issue is at this time.
I don't know about my colleagues. I would prefer guidance. No, I don't know if Tommy wants guidance or not.
Mr. Chairman, if I may, I think I can make this straightforward, and that's what I'm going to try to do. Obviously, the parties should be given an opportunity to respond to what I say. Could you put up the slide for me that has the wellbore spacing units? I think it's one of your slides.
One of Mr. Yancey's slides.
Yeah,
Yes.
yeah. Under our rules, an operator can ask for wellbore spacing units. When they do that, they must notify all the other mineral owners. And unless a mineral owner objects on a set number of grounds, the wellbore spacing units are deemed approved. It's a short-circuiting process to a pooling and spacing unit for a single well, a drilling and spacing unit for a single well. That is where this case starts. Encana applied for a number of wellbore spacing units going north-south in that section. They were 640 stand-up wellbore spacing units. Okay, that's where this starts. That's Encana's application for wellbore spacing units. KPK owns a very high percentage of the minerals in the south half of that section. And they filed an objection to Encana's application. Because they own the south half of that section, they have 320 acres there. The basis of their objection was that they, KPK, not Encana, owned those minerals. They didn't say that very well in their objection. And that's one of the issues here that you actually need to decide. The hearing officer has deemed that they said it sufficiently for Encana to be on constructive notice, basically. Okay? If there's an objection, excuse me, in this case, the hearing officer has deemed that there was, the right procedure is for the applicant, Encana, to ask for a hearing in front of you to solve the objection. Okay? Encana filed something that, again, didn't probably very clearly say we'd like a hearing in front of the commission now on the objection. Again, the hearing officer has deemed it was sufficient to accomplish that purpose. From my point of view, you can throw out everything else. That's why they're here today. That's why you're here today, is to decide on KPK's objection to Encana's request for stand-up wellbore spacing units on the basis that KPK owns the minerals in the south half. A lot of things have happened in the meantime. The amended applications that Encana has referred to, they shifted from asking for wellbore spacing units to a traditional 640-acre drilling and spacing unit. Again, staff's estimation is that you can't do that, okay? It's not a pleading in court. It's not an amended complaint. These are permit applications. An application for wellbore spacing unit is not the same thing as an application for a drilling and spacing unit. And we decided they shouldn't jump shift from one to the next. We also decided their effort to do that shouldn't prejudice them entirely from being here and allowing you to hear KPK's objection to their wellbore spacing unit. You're being asked to decide whether KPK's objection should win or lose over Encana's 648 north-south wellbore spacing units. You haven't had too many of these. We try to get the operators to work these things out. That's the whole point of the way the rule is written. In this case, they've not been able to work it out.
Commissioners, do you happen to have any questions for the director before we let the parties comment on his? Okay, Mr. Rancy, we let.
Well, KPK had, KP Kaufman had 3 minutes and 45 seconds remaining. I don't know whether or not they'd like to take it, and if Encana would also like to respond, or.
Well, I would just really jump ship here and say I think I would like to hear their response to Director Lepore, but not, you don't have to put them on a clock.
No.
But you don't get unlimited time to respond.
Fine with that, thank you. This is just in response to Director Lepore, very respectfully. I think that the classification just needs one tweak by how Director Lepore presented you with the issue that's here today. He made a statement that said you can throw everything out and you get to the issue of whether KPK's objection is valid. You cannot throw out the motion for reconsideration in front of you, number one. You have to decide that. Number two, you cannot throw out that the validity of the objection is not an issue. Whether KPK can support its objection is what its issue is, my understanding of why we're here. And so the validity of the objection was just decided on the, non-allowance of the subject matter motion to dismiss. The validity of the objection got us here today to the hearing on these 9 wellbore spacing units. If it gets there based on the outcome of your decision for the motion for reconsideration, what you are hearing is whether KPK can support that objection as to why its correlative rights will be harmed on the basis of the 9 wellbore spacing units proposed by Encana in violation of the rules. So that's my initial response and clarification to Director Lepore's statement.
Can I make a comment?
Yes, ma'am,
Would
you
that be
may.
okay? One thing that I'm going to be looking for, because you talk about KPK's correlative rights, but I've got to worry about the states and waste. And so it is my understanding that there is a reason for the north-south orientation, that is the maximum recovery of resources in the area, rather than going east and west. That has to be included. I know you all are going through the process of these things that were filed, but ultimately wells are going to be drilled and oil will be produced. And if what results is not the most efficient for production and what eventually will go to the state, I really have to ask, how come?
And I think that's a question better suited if it goes to the sufficiency of KPK's objection to support it, because we have prepared testimony to provide why correlative rights are harmed, but also why waste would occur on KPK's assets as well. So we were prepared to provide technical evidence that you're looking for, if it goes there.
Ms. Spalding.
Yes, thank you, Mr. Chair. I think everything Director Lepore said was supported in the record, while we take exception to the fact that the objection was compliant with the rule, because it certainly wasn't. But I think the question for you now is, in the order, Hearing Officer Durancey's order of the other day, she denied KPK's motion to dismiss the original wellbore spacing unit application. And so KPK has asked you to say that what Ms. Durante did was wrong so that we don't go to hearing today. And so what Encana is saying is what the hearing officer did was right. It was not an abuse of discretion. It was correct as a matter of law. The motion for reconsideration that KPK has posed to you, we ask that you deny it so that we can get forward with the hearing and show you why correlative rights are protected. Waste will not occur with these wellbore spacing unit applications.
Okay.
Can we utilize our additional time?
I'm sorry.
She's just asked for her additional 3 minutes and 45 seconds. It's your call, Chairman.
Is it use it or lose it?
Yes.
Use it.
Okay, thank you.
But they would have the last word.
Okay.
KPK would have the last word because it's their verb.
Right. And I can make this very quick. So thank you for indulging me with this. Ms. Spalding made a couple comments that absolutely have to be addressed when you're considering this motion for reconsideration. Again, it is very rare that a party is actually going to bring a motion for reconsideration in front of the commission unless there's an absolute necessity or an absolute error of fact or law that clearly mandates a different result or other circumstance resulting in manifest injustice, as I cite from CRCP 121. I also cite a case, there's 3 cases actually in Colorado, that while Ms. Spalding said it should have been pled under 121, not 60, 121, whatever the case may be, the Colorado courts have been very clear that says that when the substance of the requested relief was clear and consistent with the statute, the precluding relief based on a misnomer and a cause of action would improperly elevate form over substance. We are here, we've provided facts that came out from counsel at the pre-hearing conference that absolutely unequivocally indicated that that original application was withdrawn. We should not be here today. Encana has avenues available to it if you deny the WSUs today. They can go back and refile. They can seek a hearing under 503B10. There's lots of other avenues that they can be here to take to bring these back to you. There's no reason for this to move forward when there has been an unequivocal withdrawal of the original application from Encana. And really, again, just to confirm, I put this back up here for a reason. What is happening is if this is allowed to go forward, the commission is allowing Encana to move forward in known violation of your rules. Compliance with the commission rules has been the aspect and topic of the last 3 or 4 hearings that we've had in front of the commission. We have to ensure that the rules are properly followed. And so on that basis, we would argue that you grant our motion for reconsideration, and that motion for reconsideration is asking you to either strike the original application as expressly withdrawn by Encana's counsel. It is moot, as specifically stated by Encana's counsel, or you grant our original motion to dismiss, which moved to dismiss the original application on the basis that they violated the rules, which has already been found by the order of the hearing officer. So I really appreciate your time, and I ask that you seriously take this into consideration before you move down the road of what happens with respect to these 9 WSUs as a whole. Thank you.
Where do we get to the form over substance?
That is Trans Shuttle Inc. versus Public Utilities Commission.
I understand
I'm
that.
sorry.
But in this process, that rings true to me.
Mm-hmm.
We don't want to be so tied to the form
Mm-hmm.
that we really don't address the substance. How do we get to that?
How do you get to that today for purposes of discussion?
Today or going forward?
Or moving forward? I think for purposes of discussion today, you can utilize KPK's motion to dismiss that was filed and the reasons set forth in that to have this reconsideration in front of you. And the substance is that there have been express statements that this original application shouldn't move forward. The form piece comes into play because Encana's counsel has said, well, it wasn't properly pled in the motion for reconsideration when Rule 121 was actually pled as well as Rule 60. So to get to the form versus substances, I think that if you, to basically say it, I think in the most general terms as possible, if you kind of don't look at what was on the paper, but take what was expressly stated at the pre-hearing conference and carry that through. That's how you get to your substance. So I hope that answers your question.
Okay. How are you doing? Do you want to give us advice and counsel, or
Sure.
do you want Mr. Rancy to?
I'm going to sing Mr. Yancey's praises for a minute. When this sort of came to the surface, I went back and looked at, this is actually a fairly new rule. And so I went back and I looked at the statement of basis and purpose for establishing wellbore spacing units. And it's described as, the idea is to provide operators a simple method to create a wellbore spacing unit and only utilize the commission adjudicatory process when the parties cannot agree on terms. These proposed amendments to the 318A rule are expected to allow further development of the GWA in a logical and cooperative manner. Well, that hasn't happened here, and as a result, it's gone to Ms. Durancy to sort of sort things out. And I think she was the first to recognize, and the parties have recognized, that things may have not been done with the particularity that you would expect of some operators, or if you're in federal court, but we don't have that level of formality here necessarily. And you count on Ms. Durancy to sort through the formality or lack of formality and maybe some errors along the way and tee matters up for a hearing. And she has teed this matter up for a hearing. And her February 11th, 2015 order is very well organized. It provides a great history of what, how we got here, and her recommendation. Her recommendation is that we have a hearing today on the substance of KPK's objections to what Encana seeks to do.
That's kind of what I'd like to do, but there are some, how do I get there? How do we get there?
You overrule KPK's motion for reconsideration and proceed to a hearing as outlined in Mr. Rancy's pre-hearing orders, including the February 11th, 2015 order.
Okay, colleagues, you understand where, am I alone in wanting to go to the substance?
Yes. No.
I am alone? Oh, okay.
You're not alone. Just go, yeah.
Okay, and you understand council's guidance on how we get there. So we'll maybe entertain a motion relative to the, what do we do with the motion to dismiss? Is that right?
You would overrule the motion for reconsideration.
Consider, not dismiss, reconsideration.
So I move that we overrule the motion for reconsideration.
And a second. Any further discussion of that? Hearing none. Those in favor indicate by saying aye.
Aye.
Opposed, same side. So motion for reconsideration is not accepted, not approved. Now then.
At this point, KP Kaufman has its opening statements.
We'd like to take a couple minutes to hand everything out for purposes of this presentation, please.
Thank you, sir.
Thanks.
We have a 2-minute break if you need coffee or
Whatever.
get rid of coffee.
My time. I should be in the alley room. Yeah.
we have KPK's opening statements. Ready to do?
Thank you.
So actually, do you want to do your stipulations first?
Yes, can we do that outside?
Actually, the parties will talk about their stipulations that they've reached before the hearing, before we start with our opening statements.
Oh, good.
They do have some agreements, yeah.
We just didn't agree on the first part, so we did stipulate to the admission of our experts, so we don't have to go through a lot of time of stipulating to their qualifications and the experience and their knowledge of the application lands. And then in CANA, yes, we did.
Both sides. Yes.
Both sides. In CANA did have one additional geology exhibit that they had submitted yesterday, and we didn't have any issues with that. And we have actually, and Jill, I can pass these around. We have updated geology exhibits that CANA did stipulate to. The only change from the exhibits that you already had was that the cross-section was on these. They were not on the other geology exhibits. But we have also stipulated to G1, 2, 3, 4, and 5 of KPK's geology exhibits because they were being utilized to show that the Codell and Niobrara formations were underlying the application lands. And CANA had very similar exhibits with respect to G1, 2, 3, and 4. And so we've stipulated to those so you don't have to get into a whole geology discussion when we're very limited on our time. And Karen, please let me know if I didn't phrase that properly.
No, that's correct. We've stipulated that the geology under section 2 is Niobrara and Codell.
Okay, we got that taken care of.
All right, we'll start with opening statements. There's 40 minutes total there's 40 minutes for each side for their case in chief, including cross-examination. Start.
All right, thank you. Well, again, good afternoon. Realizing that we have time constraints on the parties, KPK's opening statement can be very brief. 3 points support KPK's position on objecting to the 9 wellbore spacing units you have in front of you today. In CANA's proposed wellbore spacing units significantly harm KPK's correlative rights. In CANA's mandated north-south well orientation is inaccurate and unsupported on a localized basis. And in CANA's 9 APDs for the wellbore spacing units were filed in violation of Rule 318A, as already found in the COGCC hearing officer's report. We do have, just by way of background, the lands that are at issue. This is Section 2, Township 1 North, Range 65 West. And CANA holds an interest in the north half. KPK holds an interest in the south half. And CANA has 0 interest in the south half. KPK will have 2 direct witnesses, Avi Mailer, landman at KPK, and Ken Cooper, petroleum engineer with Petrotech, who you've heard from before on other matters in front of the commission. With other witnesses potentially available for rebuttal, we'll present evidence supporting KPK's position that these 9 wellbore spacing units should be denied, and we'll show that KPK's correlative rights will be harmed. KPK's objections are supported by technical evidence, and CANA violated Rule 318A, and that in CANA's technical evidence is inaccurate and does not equivalent to a mandated north-south well orientation as put forth by CANA. I do want to take you through 2 minutes of the procedural timeline as a demonstrative way of narrowing down the last 9 months. You've already seen this. You do have a larger one of these in front of you because it got so small. And I think, even though we just had the motion for reconsideration, the facts still stand. We still stand that the rules have been violated, and that's not going to go away for purposes of KPK because you do have rules for a reason. Regardless of whether you ruled on that motion for reconsideration, you can absolutely take into account the fact that CANA violated the rules by actually filing these 9 APDs that we're up here for wellbore spacing units on. In June, KPK received 12 wellbore spacing unit proposals from CANA. In July, KPK timely objected to all 12 of those wells. On July 31st, KPK filed 6 APDs in the south half of the section. They have a majority and a substantial amount of interest in that south half, and CANA has 0 interest in that south half. On August 27th, CANA filed its original applications to approve 9 APDs, not ask for a motion or a hearing on the objection as stated in the rule, despite KPK's objections. On October 10th, KPK protested the original application, and this is when it gets a little hairy because Encana couldn't figure out what it wanted to do with respect to this section, and KPK's been dragged through this as just along the way. On December 12th, Encana filed an amended application seeking a 960 acre drilling and spacing unit. Before KPK could do anything with that, they then filed on December 24th a second amended application seeking a 640. They didn't file any additional APDs in this except for 3 on December 15th. They filed 3 additional APDs for the McGill wells, all in the east half of the section 2, failed to disclose KPK's objection to these wells, and failed to notify them that they are actually being filed. Another violation of the rule. So we as KPK file a protest to the second amended application. The pre-hearing conference occurs.
The second amended application is not here before you today. It's the original application, and I think this is far afield of the objections that KPK gets to make in this particular hearing. They're set forth under 5C of the rule, and the second amended application is not before you. So
This is really just establishing a factual timeline for purposes of education to the commission.
relevance.
It's their time.
Okay, well, thank you. And really just to close out, at the the January 25th pre-hearing conference, we've already addressed those issues, and Encana did not have any intention at that point of moving forward. And then on February 11th, the COGCC issued its hearing order and expressly stated that the APDs were filed in violation of Rule 318A E5D. And so with that, I'd just like to wrap up my opening statement, because we do request that these 9 wellbore spacing units be denied. And there will be technical evidence presented to show why they should be denied. Outrightly, they should be denied, frankly, on a violation of the rules. Again, to allow folks to not follow the rules and carry that forward is basically in violation of the Oil and Gas Conservation Act. There's rules in place for a reason. Encana participated in the rulemaking that was read from the Statement of Basis and Purpose in 2011, understands these rules. And so we have a known violation as addressed by the hearing officer that these APDs are now being allowed to move forward. So with that, I'll stop my closing statement. Encana's opening statement? Opens.
Good afternoon, Commissioners. Again, Jill Fulcher with Beatty and Wozniak here today on behalf of Encana Oil and Gas. Despite the multitude of pleadings and motions that have been filed in this matter and any allegations regarding the procedural timeline, the issue before you today is simple. Should Encana's proposed horizontal wellbore spacing units that have been designated for the McGill wells be approved over KP Kaufman's objections? So put differently, has KP Kaufman provided sufficient evidence to establish a basis on which these wellbore spacing units can be denied? Rule 318A governs establishments of these units in GWA, and as Ms. Stanzik set forth, it sets forth a very narrow basis on which these units can be denied. The objecting party has the burden of proof to present evidence for denial of these units. So it's KP Kaufman's burden to provide evidence either that Encana didn't comply with the informational requirements as set forth in the rule when it proposed the wellbore spacing units, that Encana is not an owner with the right to drill within these units, or that establishment of these units would either cause waste or harm KP Kaufman's correlative rights. Encana's evidence will unequivocally establish that KP Kaufman cannot meet its burden of proof in this case, and these wellbore spacing units should stand approved. Encana will testify that it complied with all informational requirements when it proposed these wellbore spacing units, and that it is an owner with the right to drill in each of the proposed units. Encana will also testify that the objection letters the KP Kaufman filed, as you've heard, did not set forth a valid basis for objection under Rule 318 AE5B. But Encana will submit substantial evidence that establishment of these units will not cause waste and will not violate or adversely affect KP Kaufman's correlative rights. Encana has drilled over 100 wells to the Codell and Niobrara formations in the vicinity immediately adjacent to the application lands. And through this experience, Encana has determined that the optimal method for maximizing ultimate recovery of the hydrocarbons in this area is by drilling horizontal wells on a north-south wellbore orientation basis. By drilling wells with north-south, utilizing north-south laterals, Encana knows that it's able to stimulate more of the reservoir, making these wells more economic and efficient for recovery, and therefore preventing waste. So Encana proposed properly these wellbore spacing units 9 months ago on June 9th, 2014. And throughout this time, its sole intent has been and continues to be to develop Section 2 in a way that maximizes ultimate recovery of the resource. So any arguments regarding what happened thereafter are irrelevant to KP Kaufman's burden of proof, including anything that was allegedly misstated on the APD that still doesn't get to waste, doesn't get to correlative rights, and doesn't justify basis under 318 AE5C for denial of these wellbore spacing units. So at the conclusion of today's hearing, Encana would respectfully request that this commission determine that KP Kaufman has not satisfied its burden of proof and that each of these wellbore spacing units stands approved. Thank you.
Thank you. Now, we have so many minutes for our, what do you call it, case in chief?
Yes,
Yes, sir.
regarding why the objection should stand. You have 34 minutes and 54 seconds.
Okay, I'd like not to start it yet. Avi, can you please come up until we get in place? Thank you. Okay, our first witness is Avi Mailer. He is land manager at KP Kaufman Inc.
Mr. Mailer, would you raise your right hand, please? Do you swear or affirm under penalty of perjury that the testimony you are about to provide is truthful and accurate?
Yeah. Do you want to do a mass swearing?
We'll have a mass swearing for everybody after this one.
Okay.
He's special.
All right, Avi, thank you. Avi, just by way of background, can you provide an overview as to how long KP Kaufman's been operating in Colorado and how many wells KP Kaufman operates?
KP Kaufman has operated in Colorado for 31 years. Currently, KP Kaufman operates over 900 wells in Colorado and is a working interest partner in another 300 to 400 wells in Colorado.
Okay. And what is KPK's net acreage position in Colorado?
There's approximately 55,000 net acres in Colorado.
Okay. And is most of that in the greater Wattenberg area, DJ Basin?
Yes.
Okay. And has KPK been actively engaged in permitting horizontal wells?
Yes, we have to date secured approximately 15 horizontal pads with surface use agreements in place. We have also permitted over 100 horizontal wells for development on these surface pads.
Okay. And is one of your surface pads in the south half of Section 2?
Yes.
Can you please describe that pad and your intended development in the south half of Section 2 for the majority of KPK's interests?
KP Kaufman owns a substantial interest in the south half of Section 2 in Township 1 North 65 West. We have submitted permits to, and we intend to develop this undeveloped virgin south half of Section 2 in 1 North 65 West. We have actively talked with the surface owner. We have secured location for the development of this acreage, and we intend to protect our correlative rights in the south half and develop this unit as well.
Okay. And how many wells do you intend to locate within this south half for purposes of development?
Currently, we have 6 permitted, and we intend to put up to 11 wells in this 320 acre unit.
Thank you. And does Encana have any interest in the south half of the unit?
No.
Okay, thank you. Has KPK participated in any horizontal wells with its partners?
Over the last year and a half, KP Kaufman has participated in around 25 horizontal wells, 1 mile long laterals and 2 mile long laterals with other operators in the basin. KP Kaufman was an active working interest partner. KP Kaufman owned up to 50% of these wells and has developed these wells over the last year and a half.
Okay. And Avi, can you please expand on why KP Kaufman objected to Encana's 9 proposed wellbore spacing units?
We objected because it was inconsistent with our development plan. We wanted to, KP Kaufman has our asset base, and we've protected and maintained our asset base over the last 30 years. And we intend to develop our assets. KP Kaufman was concerned that Encana's proposals would be detrimental to our correlative rights. We also believe that we wanted to prevent waste, and there was the 9 horizontal wells for which we are meeting here today would strand our southwest corridor in section 2 due to the fact that the unit only is comprised of the majority of the east half.
Thank you. And for purposes of reiterating the rule, 318AE5B states that one of the reasons for an objection is that an owner is not an operator as defined in the Act, which meaning having the right to drill, of the mineral estates through which the wellbore penetrates within the target formation. Does Encana's wells penetrate the south half into your mineral interest?
Yes.
Does Encana own any interest in that south half?
No.
Thank you. With respect to additional development on the south half, is it your understanding, or have you seen any additional APDs filed by Encana in the west half of section 2?
Yes, in December, they filed 3 additional permits in the east half of section 2.
And did you object to those permits?
We had objected to them in June.
Okay. And again, can you please elaborate on why you think Encana's proposed development on these 9 wellbore spacing units will waste the southwest quarter of section 2?
Currently, the 9 wells are only spaced on the east half, and thus, because the southwest quarter would then be stranded without any development once their wellbores would go through our southeast quarter. Furthermore, the southwest quarter is the city of Hudson and would not have a viable surface location to develop those wells.
Thank you. With respect to the APDs that KPK has filed for purposes of the south half, does KPK intend to drill these, they're called the Rubel wells, that are currently awaiting APD approval?
I'm just going to object. That's way beyond the scope of the burden of proof under 5C.
Well, I believe it goes absolutely to the protection of correlative rights. A part of the correlative rights, I wish I had my act in front of me, but is that each owner has the ability to obtain its just and equitable share in production by virtue of its interests. So that's my response.
Your objection is noted.
Okay, thank you. So moving forward, does KPK intend to drill the wells in the south half that have permitted right now, assuming they get approved?
Yes.
Okay. And can you provide me with a little bit of background as to not really the timing on the wells, but how KPK typically treats virgin acreage for development because it's a privately held company?
Being a privately held company, KP Kaufman has always tried to develop its assets in a prudent long-term manner. Not being subject to holder pressure, KP Kaufman has that drilling flexibility in order to develop our assets efficiently and in a prudent manner. We have identified the south half of section 2 here, being that there is currently no producing Codell or Niobrara wells in the entire south half, as a very high candidate for our development. KP Kaufman had participated as a non-op partner over the past year and a half in a number of horizontal wells, as I mentioned earlier, and was planning on their development program for 2015 to kick off our operated program, this location being one of our top candidates. However, due to the commodity prices, we have currently postponed that, but it is our full intent to develop this south half due to the fact of our substantial leasehold interest in the entire south half here.
And will you be able to develop that south half if these are approved? these wellbore spacing units are approved?
We would not be able to develop the entire south half. The southwest quarter would be stranded.
Okay. Just another brief question. Have you participated in any Encana horizontal wellbore spacing units?
To date, we have received about 10 notices from Encana, the Renier Farms and the Rasmussen wells, which we would be working interest partners, which we have not objected to and look forward to developing with them. We also have an additional 10 wells with other operators that they have sent us notice, and we are on notice, which we have not objected to. We solely objected to these ones because of it would be inconsistent, and we wanted to protect our correlative rights due to the fact of our very high interest in the south half and our intent to develop the entire south half.
And KP Kaufman's not in the business of objecting to wellbore spacing units on a typical basis, correct?
No.
Okay.
I need just a clarification, if that's okay, Mr. Rancy. May I ask for clarification?
Yes.
I got a little bit confused. I thought I heard you say the southwest portion would be stranded.
Yes.
But then you just said your intent is to develop the total south half.
Yes, our intent is to develop the entire south half. If the 9 McGill wells, the Encana wells, are approved, they are only in the east half. That would strand our southwest quarter.
Okay, I have a question.
Or did I open the door?
Yeah, I'm sorry, but who owns the northeast? I don't understand. I know what you're saying. The reason you want to drill your 9 wells from east to west is because you own the south portion of what I'm seeing as a square. Now, right now, Encana has proposed wells only on the eastern portion. Who owns that northwest corner? Encana. They just haven't proposed the wells in that area to intersect your southern portion.
I haven't seen.
Right, and at this snapshot in time, we have to deal with what we're dealing with right here. We are looking at proposals where you have to go back and look that they had the opportunity to do that. They put up a 960 drilling and spacing unit.
I'll object, this isn't testimony.
Okay, and well, it's clarification for a commissioner question, but may I finish?
Noted.
Okay,
You can put them back on the clock.
Put it back on the clock now? Okay.
so I can't finish the response?
Do you
want me to finish the response?
Question or should?
You wanted to finish.
I get what they were
She
telling me.
Okay.
said she got it.
I got it.
Okay, thank you. Well, from that basis, Avi, for purposes of protecting your correlative rights, is it your belief that if these wells are allowed and the wellbore spacings are proposed or approved, do you believe that KPK will have the opportunity to obtain and produce your just and equitable share underlying your mineral interests?
Objection leading.
You can go ahead.
Oh, there's an objection.
I'm sorry.
I didn't hear him, I'm sorry.
Oh, I said I objected because that's a leading question.
Okay, I can rephrase. Do you believe that your correlative rights will continually be violated?
Yes. If Encana drills into the south half of section 2, it prevents us and harms our correlative rights.
Okay, thank you. With that, I have no further questions for this witness.
Redirect.
Yes, thank you, Mr. Chair.
Hold on a second.
Hold on a second. He doesn't want to take too much time away from us.
May I go now? Thank you. Mr. Mueller, Karen Spalding, I know we've met before. I'm going to hand you what we've marked as Exhibit 7. And are those the letters that you sent to Encana stating your objection to the wellbore spacing unit notice letters?
Yes.
Okay. And you just testified that you thought correlative rights of KPK are going to be abused by the wellbore spacing units. Is that correct?
Yes.
And you didn't actually put that in that letter, did you?
No.
I'm going to object on the basis, and I hate to do this, I'm sorry, but I am going to object on the basis that this has already been dealt with respect to the validity of the objection being in here, and then the hearing is actually on whether KPK can support that objection. That's already been decided. But
Just goes to credibility of the witness. He's saying that correlative rights is extremely important to KPK, yet they didn't put the very important words, protect my correlative rights, in their objection letter. Goes to credibility.
Okay, but it's on the record.
Thank you.
Okay. You also, testified about, the wellbore spacing unit, and having the mineral interest in the south half. Now, KPK doesn't own 100% of the mineral interest in the south half, does it?
No.
That's correct?
That is correct, but we do have a substantial, very high interest in the south half.
Okay. And you indicated that you've participated in some long laterals with other operators, is that right?
Correct.
And I think you indicated that you participated 50-50 with them?
In a number of the wells, yes.
Okay. And if these wellbore spacing units actually get drilled, you'd be about a 50-50 participant with Encana in these, wouldn't you?
Correct.
And you also indicated that you are anticipating drilling or going in with Encana on some other wells that you
Yes.
testified to, about 10 notices you recently received from Encana?
Yes.
Okay. And you understand those are not anywhere near the application lands?
Correct.
And you also understand that those wells are going to be drilled on a north-south orientation?
Correct.
Okay. The Encana, McGill, A, B, and C wells include the east half of the west half of Section 2, so the southwest quarter won't be stranded, isn't that right?
It will, part of it will. The west half of the southwest quarter will be stranded.
Okay, but not the entire thing?
Let him finish the question, please.
And you understand that because KPK owns minerals in the proposed wellbore spacing unit, that KPK is entitled to receive its just and equitable share of production?
Yes.
And KPK has not drilled any horizontal wells to the Codell and the Niobrara itself in Colorado, has it?
KP Kaufman has not operated any wells, as I mentioned before, and we have been an active participant in, as a working interest partner in horizontal wells to the Codell Niobrara.
Okay.
You should speak into the
If you can speak just a little louder because
I'm sorry.
Pass the witness. Thank you very much.
Just redirect for 1 minute, please.
is there a redirect?
I don't think
No,
so.
we don't need to go there. In the interest of time, let's move on.
Yeah, I just have 2 questions, Avi.
Oh, yeah, thank you.
Ready? Yep. Okay. Avi, with respect to the wells that KPK proposes to drill from in the south half, would your percentage be approximately 100% in those wells that you would recover your just and equitable share on?
Yes, it would be approximately 100%.
And by having the wellbore spacing units proposed by Encana come through, that would basically cut your interest to 50%, correct?
Yes.
And please repeat to us why KPK has been holding on to this virgin acreage.
KPK has maintained our asset base, this being one of them, where we have an entire unit of south half with a significant, very high percentage of the unit, approximately 100%. As I mentioned earlier, to date, there are no producing Codell Niobrara wells in the entire south half. We've identified this as a high candidate for us to develop and want to develop our asset base in a prudent long-term manner.
Okay. And when KPK develops the wells proposed in the south half, would you utilize your rigs and your rig crews?
Yes, KP Kaufman has their own drilling company, our own well service company, our own trucking company, and thus would minimize the cost to drill the well, but also, as you mentioned earlier, since our high interest, would maximize our revenue from this entire south half.
And that would be lost if you had to be subject to Encana's wells, correct?
Objection leading.
Thank you. No further questions.
Okay.
Thank you.
You have other witnesses.
I do.
Could we have, if this is correct, can we have all the expert witnesses that have been stipulated to be experts that intend to testify so that Mr. Matter could swear you in en masse?
So we have one additional Expert.
Fact
Mr. Cooper.
witnesses, expert witnesses, surprise witnesses, everybody raise your hand. Do you, each of you swear or affirm under penalty of perjury that the testimony you will provide today is truthful and accurate?
Yes, I do.
May I just have a housekeeping matter? I move for the admission of Exhibit 7.
Yeah, I guess I should request the land exhibits that were as part of the PowerPoint be moved into evidence as well.
There's no objection to either one of these, right?
No, not from our standpoint.
Now, what,
The,
Well-
the two land exhibits, Karen, this one
No.
and this one. Oops, I'm on the wrong ones, my apologies. These two that were in the PowerPoint.
no, no objection.
Okay, thank you. All right, and again, just for purposes of housekeeping, I am going to skip the next 5 slides because we've stipulated to the geology exhibits for purposes of this hearing. So while they're very beautiful, we'll not use them for this. Thank you, Avi. Joe, can you let me know how much time I have left, please? All right. I'd like to reserve 10.
Okay, then I'm gonna start you at 12.
Okay, that's fine. Thank you. All right. Yep, thank you. All right, KPK's next witness is Mr. Ken Cooper from Petrotech Engineering. And he is here to provide the technical support for KPK's objection. And I'm going to go ahead and ask Ken to do a brief introduction summary of your testimony.
Sure. Thank you, Commissioners. I'd like to take everybody through some of the materials that we had presented as part of the written submittals that had been made. Can I be heard okay?
So far.
All right, very good. So what we've ended up doing is we've independently pulled a variety of commission data. We've taken a look at technical testimony that has been submitted up to date in this matter. We've taken a look at various other public information, Niobrara literature information that's publicly available. And as documented in my written testimony that was previously submitted, my staff and I derived some projections that showed the KPK development plan was reasonable, and our independent analysis was pretty much consistent with what KPK subsequently provided to us that they had done internally, and then also work that KPK had Netherland and Sewell Associates do. Just so multiple people were kind of coming to the same conclusions on things. And I'd like to have everybody take a quick look at this exhibit. And what this is a copy of the Exhibit E1 that had been provided, wherein we had taken a look at some nearby surrounding laterals. And granted, a majority of them are north-south because the vast majority of the wells in the Niobrara play are north-south, as I think we all know. We took a look at them and we ran some decline curve analyses, went through it and came up with probable EURs and came up with a confirmation that the types of volumes and production expected were going to be reasonable. We also took a look at things from the perspective of the subject acreage and noted that for the purpose of oil in place and EUR sections, there isn't currently any production from the south half. What we did note is that in the northeast quarter, there is some vertical production, we believe, some old vertical production that had been produced from wells historically. So with that, obviously there would be dilution from the production of north-south laterals that wouldn't occur with east-west laterals because of historic production from vertical wells. So to the next slide, this is a summary that we've got that shows EURs, it shows the types of lateral lengths that have been utilized. It provides some information as to how we have been calculated probable drainage areas, and then also provides some estimates of drainage radii that show that the The proposed wells that KPK had, their development plan was consistent with the 318A offset, 460-foot offsets and so on and so forth. With that, we can kind of move into some additional exhibits here. And we'd like to take a look at some.
We're going to object to this exhibit. I'm sorry, but the offering of this exhibit is in violation of the hearing officer order issued on February 11, 2015, in which time the hearing officer directed the parties to submit all exhibits that they intended to present in evidence by February 23rd. This is a substantive change, and the exhibit that Encana's presented today was a clerical error, excuse me, but this is a substantive change in Encana, and Encana has not had an opportunity to see this.
May I respond to that, please? This is Encana's exhibits that were submitted with their pre-hearing statement. So they have seen this. That's a misstatement on behalf of Ms. Fulcher. We reserved the ability to utilize all exhibits at the hearing in our pre-hearing statement, including any exhibits submitted by Encana. When the pre-hearing statements were were submitted, it was on two dockets. It was this docket as well as KPK's application for the 320-acre drilling and spacing unit that at the last minute got continued to the April hearing. And so there were additional exhibits submitted by KPK that were used to support both of these, but we did reserve the right to use other exhibits, and these are Encana's exhibits that KPK is utilizing to support their objection. So we would ask that they be allowed.
I'm going to see if the hearing officer can help me out here.
Can I make a comment?
Encana has objected to the.
As a technical person, I would like to discuss this exhibit. I am not a lawyer. I don't want to be a lawyer. This is not a court. I'm anxious to find out the technical answer. And if this is going to contribute to that, then I want to hear it.
Well, that's great. I agree with that, but I don't want to step on your toes.
No, my toes have boots on.
Mr. Rancy, can we just brief response? I'm sorry. This is Encana's exhibit. We wouldn't dispute that, and we will be submitting our testimony on that exhibit. But items 1, 2, or I believe that should be a 2, and 3 are all new information that we didn't have an opportunity to see. So just for the record, we want to object. We want to get to the technical merits as well. So to Mr. Rancy.
Okay, we'll just, we will duly note your objection.
Thank you.
And then we'll continue on with this test. We duly noted the objection. We'll continue with the test.
Great. And I just want to say for the record that Commissioner Wilk is back. Sorry, I'm sorry.
And happy I rushed back.
Sorry. Okay. You ready?
Yeah, how much time?
Well, you have 18 minutes and 47 seconds, but you've reserved 10 minutes for rebuttal.
Done, thank you. Thanks. All right, can you please tell me what this exhibit is denoting and walk us through your exhibit?
Yeah, what we had done is took a look at materials from the written submittal, and we do, acknowledge and fully understand the thought process behind, if we've got a uniform, isotropic, homogeneous system, what sorts of transverse versus longitudinal versus oblique orientations we might end up getting when hydraulic fracture stimulation is conducted along a horizontal well. And the problem that we've got with taking a look at some of the materials is that based on the geology that has been put together, very localized for this south half of Section 2, which you can see in some of the geology exhibits that have been provided, is that we've got some faulting and some other things that are going on right within Section 2, which we believe is going to have some relevance to the way that the section is going to likely be drained and the way that hydraulic fracture stimulations are likely to propagate from horizontal wellbores that are installed. And so we think that the situation is such that because of transecting faults that are known to exist in the section and the probability that this faulting and fault zones have relevance with regard to the nature of the stresses that are present in immediate proximity to those fault zones, that we're probably going to have a situation where not only will the fracture propagation be to some degree influenced, but also drainage through the natural fractures and drainage potentially from the faulting in the system, the fault zones in the system is probably not going to be at a direct 90-degree from either the north-south stand up or from the laydown possible orientations that could be used to exploit the reserves here. So perhaps we can get to the next slide. And this is another slide here with kind of microseismic that has been cited, which, you know,
I'm sorry to interrupt,
Sure.
but can you please confirm that this is an Encana exhibit that you would utilize your slide on?
Yeah, what I've done is I've just taken the, you know, the written exhibits that were previously provided in February and just cited that right there on the slide, and want to go through the fact that, as is shown in that center map, we've got an area that is shown that is fairly sizable. We've got some microseismic that is cited as supporting the north-south development case. But those seismic data, microseismic data, are actually from wells that are 10 to 15 miles away in what is, as we get further south in this area, fairly complicated. And you can see in the right side there, that's actually something that's been available for 15 or 20 years, I guess, as a base with some of the faulting that has been mapped in the area. It goes back to some work that Halliburton's done. Weimer and Sonnenberg.
Sonnenberg.
With it. Right. Yep.
Yeah.
Yeah. And what we've done is we've overlain one of our geology exhibits kind of on top of it so that we can see the various faults. And you can see the red lines there. So the south half of section 2, this is 9 sections, okay? And so the south half of section 2 is what we're talking about here. And you can see that you've got faults that transect from northeast to southwest. You've also probably got some orthogonal faults that end up intersecting at what is relatively close to a 90. There is some private seismic that has been examined by Noble. There's various people that have looked at this that have come to similar conclusions as we have. And then on top of that, we've got various cross sections and geologic exhibits that have previously been submitted that show that, in fact, that kind of northeast southwest fault was in fact transected by 2 wells. One of the wells actually cuts through it. The other one, the interpretation is that to explain the differences over fairly short distances, you pretty much have to interpret that fault to be there. So you see it on seismic, see it in the geology, you see it in cross sections, the list goes on. So the point of the matter is that we see that we've got microseismic from a fairly long distance away that is somehow going to give us supposedly information that states that we know that stresses are going to be oriented in a precise direction when we've got some faults that are cutting across things that we believe are going to make things quite variable. And looking on a very localized basis, we think that, you know, the averages, large scale, they certainly matter, maybe when you're doing a statistical play, and they're certainly good guideposts. But we also wanted to make sure that local data is being used. And this local data, we believe, suggests that both the north-south stand-up and the east-west laydown are likely going to transect through faults at fairly similar angles at the end of the day, and is going to have impacts on the way fractures are going to act in the subsurface in the vicinity of these faults. Next slide. Okay, so again, this is another slide from the testimony from a couple of weeks ago that had been submitted in written form, just copied verbatim. And I've got 2 points that I wanted to make on this one. First off, you know, again, as I just mentioned, we've got this intersection of faults, an intersection of probably a fracture fabric that's related to those faults. And it's close to, 50-40 and that's assuming that we have everything accurate. And I don't feel comfortable saying that I know what the faults and fractures are going to look like with a high degree of precision. Are we plus or minus 5 or 10 degrees? Probably. So we're actually fairly similar with regard to the way that we're going to cut through these faults. Secondarily, the figure there, down there to the lower left that shows kind of from 3D seismic kind of different textures that are present in the system. And if we presume that some of those textures likely are related to pathways that are going to end up allowing the drainage of the Niobrara in particular, you can see that north-south or east-west is going to cut through a lot of that texture. And I don't know that random is really right. I mean, Sonnenberg, mentioned it as in terms of random, but there's certainly a lot of pathways, and it's pretty messy. And from seismic that we've seen, it kind of looks like broken glass. You've got a lot of stuff that's laying over top of one another.
Is that figure just section 2?
That's actually just an analog, and that's not section 2. No, it is not section 2. That's from a Sonnenberg paper from 2012. Yeah, but is it precise with respect to section 2? No. So let's go to the next slide.
Okay.
Another issue that we want to make sure that we're thinking through here, which is part of what KPK has done, is thinking about anisotropy in the rock, anisotropy associated with fracture zones, and how that's going to affect local situations with respect to stress. We're kind of in an area where things are kind of bending and going a little bit more from east-west to a little bit more north-south, and you kind of got curving. There's wrench faulting. There's all kinds of stuff going on here. It's fairly complicated, as I think a lot of people are aware. But there's work recently that's gone on by CSM that's taken a look at, from some cores. And again, how much can we extrapolate from core to the field? Well, it's useful. Is it precise? Well, it has a lot of use to it, and you got to be careful to extrapolate too far. But there is work that is suggesting that so long as your natural fractures are not offset too far from your stresses, that you would end up seeing a situation where you're going to have natural fractures that are going to open as kind of weak planes, in addition to having probably fractures that end up propagating along the maximum stress direction. And so you're going to end up seeing this combination, and it's going to be, a messy dendritic system is what we're envisioning here, particularly in proximity to these faults. Next slide. Again, related to this issue of kind of scale and sense of scale, and KPK looking at things in terms of, kind of just their 320 acres and maybe the offset 320 stand-up, we've got a situation where that little map on the left figure is just superimposed right over one of the NCANA exhibits. And the idea there is that little 9-section map that I just showed you, that has all that faulting in it and all that complexity in it. That's how big that is relative to the larger scale study that's been presented. And you can see that we're talking, kind of a 23 by 28 mile, give or take, size map on that left side. And we've got a situation where there's a lot of complexity on a much smaller scale than looking at it, over a larger scale. So next one here. A lot of the wells that have been cited, very interesting and useful data. General comparisons are valuable to estimate averages that we'd expect from, many wells over a large area, perhaps in a statistical play. If we're pursuing, hundreds or thousands of wells, I think on average that makes a lot of sense. But I don't know that it represents the variability that we think exists on a real local scale here. We also know that, there's normalization that can be done with various different parameters. And, we understand that a certain degree of that has been done probably, although, not all the details were there, which is fine. But, if you look at it in the simplest terms, like, for example, compare 7,000 foot laterals to 4,000 foot laterals. Don't normalize for lateral length. And I'm not saying that that's what NCANA did. I think they did take care of that, and they did some good work. But you can kind of twist results around, and you can get kind of a real family of things. And so I think without having a lot of data from east-west wells in the area, it's very hard to say that the variability we know is likely to exist from the complexities that exist out here isn't going to contribute to the ability of an east-west lateral to have some real success in exploiting the resources that are present in that south half of the section.
So let me ask you one question. For purposes of summarizing your testimony, is it your conclusion that east-west wells could produce this very similar to northwest or north-south wells here because of the variability from what you've just discussed?
Yeah, we think the data we've reviewed indicates there is substantial variability on a localized basis. And there's a lot of variability with regard to well performance, even north-south laterals right next door to one another. You can see, double the rate, and there's a whole bunch of different variables that go into it. And so, yes, we believe that it is a reasonable approach to pursue this with east-west laterals.
So there's not a mandated orientation for purposes of this localized data for section 2, which is what we're dealing with here today, correct?
Correct.
Okay,
yes.
Thank you. I have no further questions.
Redirect. Cross-examine.
Just a few questions.
You're getting cross.
So, Mr. Cooper, the exhibits you submitted, or the offset wells you analyzed in exhibits E1 through E3, were all analyzing offset wells that were drilled on a north-south lateral basis, and that's correct. Yeah, great. And you are aware that there are wells that have been drilled with east-west laterals in this area as well, correct?
I'm sorry?
You are aware that there have been wells that have been drilled with east-west laterals near the application lands, correct?
Yes, there are
But
a
you,
limited number of wells that have been drilled east-west. PDC has some wells to the east and to the northeast that are permitted. There's a few of them that have already been drilled. There's also some wells out to the west that have been drilled east-west also. And again, we're looking at 5 to 10 miles away, as I recall from the stuff that we had looked at.
but you didn't include offset analysis on those wells, correct?
No, we didn't.
Okay,
We
great.
used things as close as possible
Okay.
to try and stick closest to the kind of geology that we felt existed, locally.
Great. And your data points that were listed on exhibits 12 and 13 that were actually submitted by KP Kaufman on October 15th, which are included or transposed on your slides here. Those, I'm sorry. So they're going to be on the slide. So I'm sorry. We've got obviously a lot of overlapping exhibits here. But what we have here at the top is where you've indicated.
Slow down.
I'm sorry.
Let's see. You're talking over
Sure.
each other big time.
I'm sorry. Well, this would be, it's not labeled under KP Kaufman's exhibits, but if we can go back. There we go. Yeah. So just the top left. So this would have been the data points that you listed early on regarding faulting, but this map doesn't note the presence of natural fractures, strike slip faults, or subwell logs or seismic scale faults. Isn't that correct?
That's correct. Yes.
Okay, great. And so basically, is it fair to say that you're not really showing the complexity of the fault system? Would that be correct?
On that figure, I would agree, yes, that's
Okay.
correct.
And KP Kaufman has really presented no evidence analyzing maximum horizontal stress in this area, have they? It's simply been on faults.
I would say that there is data in some of the slides that we presented that does have, I would say, it's not really regional data, but I wouldn't say it's local data either, because we haven't been able to find any local data because I don't really think any exists. As I pointed out, I think some of the stress data that we had looked at that Encana had presented, in fact, is ranging, kind of the closest is probably, 5-6 miles away, something like that. And I'd have to look and measure it precisely, but it's on that order. And some of it's a lot further than that.
Okay. And, we appreciate the amount of time you've taken to look at Encana's exhibits, but does KP Kaufman have any data to support that drilling transverse to faults creates enhanced production?
The data that's been reviewed, as I had mentioned, involves the geologic characterization that has been generated based on a variety of both internal and literature information, and then based on some of the work that KP Kaufman has done with some other operators. There's been access to some spec seismic that can't be publicly put out there with all of the actual analysis. And I am not a seismic expert, but from looking at it, as I mentioned, it's, I think the best way to describe it is kind of broken glass in the immediate vicinity is kind of, a way that maybe people can, visualize it. And so I would say that although KP Kaufman has not conducted any stress testing or breakout analysis or had access to things like that in the immediate section of interest, we don't think any exists. Certainly there has been examination of data surrounding to try and draw some conclusions the best we can.
All right, thank you. No further questions.
I just have one redirect.
Wait, hold on.
Is it common for operators to utilize data from the surrounding area and not just their own when proving up other acreage?
Oh, absolutely, yes.
Thank you. Okay. At this point, we have no further witnesses. Thank you.
So your other witnesses are just in case witnesses?
They are just in case witnesses. Thank you, Ken.
Okay. Ms. Spalding, Ms. Fulcher.
If we could just have a brief moment that isn't counting against our time to get everything set up, that'd be great.
There's a lot of prep on these.
We need the mouse in here.
What's the time? You have 6 minutes and 49 seconds. They have 29 minutes. That's very much crossing.
No. Oh, yeah. No,
Thank you.
not. Thanks, Joe.
Tickle your fancy. Trying to watch Bill because I can't tell by his expression.
He's more stoic than I am.
Commissioner Hawkins, you play poker?
Occasionally.
I would never get in a poker game with you.
But he
I
jumped
cannot
at it.
read your expressions.
Just go ahead. Are you ready?
All right, Mr. Kroom, can you please briefly state your name for the commissioners?
Jack Kroom,
And even though we've stipulated the qualifications, go ahead and just briefly describe what you do for Encana Oil and Gas.
senior land negotiator. I've been with Encana for 8 years, and that entire 8 years has been in the DJ Basin.
Great, thank you. Can you please explain for the commissioners Exhibit 1, page 3 that's presented on the PowerPoint above us?
That sets out Section 2, Township 1 North, 65 West, Wells County, Colorado.
And in 2014, what were Encana's drilling plans for Section 2?
To develop our assets in the section.
To effectuate these plans, what did Encana first do?
I sent advance notice on June 9th for the McGill 1A through 1L well.
And did Encana's notice letters comply with Rule 318 AE5A?
Yes,
And were these letters sent to KP Kaufman?
yes.
And what was KP Kaufman's response to these letters?
I received a phone call that followed up by a letter from Avi Mayer.
And what did that phone call entail?
Avi said he was objecting to our advance notices, and we also set up a meeting in that phone, and that letters would follow.
And do you recall approximately the date that this meeting took place?
It was July 17th, July 16th, I believe.
And what was discussed at that July 16th meeting?
We discussed our advance notice, we discussed wellbore orientation, and we discussed our desire to settle this issue by looking at different trades.
And did KP Kaufman disclose its planned proposals for that south half of the application lands during that July 16th meeting?
No, they did not.
Did Encana subsequently meet with any member of the commission staff regarding these objections to the proposed wellbore spacing units?
We met with Jane Stansnick.
And at this meeting, did Encana alert Ms. Stanzik to the fact that the KPK objection letters were not compliant with the rule?
We did.
And how did she respond?
She agreed
How did the meeting conclude with Ms. Stanzik?
that we should get an opportunity to go to hearing.
So what did Encana do subsequent to that meeting?
On August 28th, we filed our application for hearing
And what was the ultimate intent of Encana in filing this application?
to have the invalid objections removed and our wellbore spacing units approved.
So following the submission of its application for hearing, did Encana have any further discussions with KP Kaufman as to resolution of this matter?
We did.
And during those discussions, did Encana make KP Kaufman aware of its intentions as to the west half of these applications, or of Section 2?
I will go back and say that in our July 16th meeting, that was brought up, and in some later conversations.
And does Encana have plans to develop the west half of Section 2, which would include its 100% acreage in Northwest Quarter?
We did.
So moving back to the slides here, can you please explain to the commissioners what Exhibit 1, this is page 4, entails?
That sets out ownership in the northeast quarter, and in this case, it's all formations, and it shows Encana with 100% gross working interest.
Okay. Moving on to Exhibit 1, page 5, please describe this slide for the commission.
This sets out working interest ownership, gross working interest ownership in the southeast quarter, and this is split up between the Niobrara Formation, which is owned by KP Kaufman, KC Operations, and Prime Resources, and then there's also ownership for all formations less Niobrara, which is between KP Kaufman and Prime Resources.
Moving on to the next slide, please explain this slide for the commission.
That sets out ownership in the east half wellbore spacing unit, Niobrara Formation, and all formations less Niobrara.
And please clarify which of the proposed wells are actually included in the east half for the commissioners.
Those are the McGill 1D through the McGill 1J.
And is Encana the majority working interest owner in this unit? Or
Yes,
these
we
units?
are.
So then moving on to Exhibit 1, page 8, please explain this slide for the commissioners.
That is the wellbore spacing unit proposed for the McGill 1A through 1C, which brings in lands in the east half, west half, and the west half, east half of Section 2.
And again, who has the majority working interest in these wellbore spacing units?
Encana does.
And how has Encana obtained the information contained in these exhibits?
We requested a title opinion be rendered.
And do you review the title opinion on which these working interest numbers were based?
I did.
And are these working interest numbers correct and true and accurate?
Yes, they are.
And was the information contained in Exhibit 1 prepared under your direction and control?
Yes.
All right, at this time, I'd move to admit Exhibit 1 into evidence, and no further questions right now. Examination.
Yes, just a couple of questions. With respect to, I'm sorry, this well, when this McGill A1A that you have up here, what was the date of filing of this APD?
That's not something the paperwork, I'm not responsible for that. I can't answer that question.
Okay, thank you. And then with respect to your interests stated on these, you have not made those interests anywhere public because they're subject to a title opinion, correct?
That's correct.
So there's no way anyone can justify or verify those interests today, correct?
Correct.
Okay, thank you. No further questions.
No redirect.
Next witness.
Any other witnesses?
Mr. Garrett, I'll call Kirsten Wallace, please.
Okay. Yeah.
I'm sorry.
Oh, you go work your PowerPoint.
Yeah, we need a, Kirsten,
Yeah.
you could close out of that. We've got 2 slides.
Karen, I'm sorry. Is this,
What do I do?
geologist or engineering? Geologist. Okay, come on.
Thank you.
Am I doing this? What am I doing?
So,
I'm not real good at this stuff. Do I close this one out?
that's right. And then, here, yep, that's right.
Now what? Now I go where?
You are making me feel really good.
I know, right?
My husband would be
We're a
appalled.
crack team up here. Okay, now.
And now what, do I just click on it or something or? Whoops.
You.
There we go. And now to get to the next slide, I just hit this one here. Okay.
Ready?
Sorry about that. Okay, now I'm ready. Mr. Wallace, would you let the commissioners know your name, please, and who your employer is?
Kirsten Wallace and Encana Oil and Gas USA Incorporated.
And would you just explain briefly your job duties and responsibilities at Encana?
I've been working on the DJ asset for over a year on reservoir characterization. Specifically, I've been analyzing production engineering data, completions engineering data, and subsurface data with the goal of enhancing our development program.
Okay, I'm just going to skip through the first G1 through G4 slides, which you prepared. We've stipulated that the Codell and the NIBRA are underneath the Section 2 lands. And then we're going to get on to Exhibit G5 in everybody's packet. And did you compile a chart here showing north-south and east-west orientation of wells near Section 2?
Yes.
And what is the orientation of the majority of the wells? It's 565 horizontal wells drilled near this disputed area.
95% of them are in the northwest or north-south orientation.
Okay. And explain why you chose this area surrounding Section 2 as part of your analysis.
It has comparable geologic properties, reservoir properties, and a similar stress state.
Okay. And who has drilled the most north-south horizontal wells in this area?
Kerr-McGee.
Okay. And did Kerr-McGee drill any of them east-west?
No.
Which way did Kerr-McGee drill them?
They drilled north-south.
Okay. And how many of the horizontal north-south wells has Encana drilled in this area to date?
97.
And how many east-west wells has Encana drilled?
9.
And why did Encana drill these few east-west horizontal wells?
They were early on in our program, and since then we've learned more about the state of stress and the impact it has on production.
Okay, and we'll get to stress and production in just a minute. But are the 97 Encana north-south oriented wells economic for the company?
Yes.
And based on this Encana data that you've referenced, would a reasonable and prudent operator want to drill east-west in Section 2 for any reason?
No.
Has KPK drilled any horizontal wells, either north-south or east-west in this part of the Wattenberg field?
No.
Okay. All right, another slide showing the disputed area well count and how many horizontal wells drilled by Encana near Section 2?
106.
And how many by KPK?
0.
Okay. Would you please explain to the commissioners why 95% of the horizontal wells in this area have a north-south orientation?
Yes. To understand the predominant orientation in the previous exhibits, it's important to understand the way that stress behaves in the earth. And to explain this briefly, stresses can be simplified into 3 principal orientations, each orthogonal to the other and each with a unique magnitude. The weight of the overlying rock and the direction of gravity makes one of these stresses vertical. That's called the vertical stress, the overburden stress, or SV. By definition, the other 2 stresses must be perpendicular to this stress, so they're horizontal. And because of tectonic forces in the earth, the magnitude of those stresses are typically out of balance. One is greater than the other, hence a maximum horizontal stress and a minimum horizontal stress. In the DJ Basin, the scientific literature and our data indicates that the relative magnitudes of the stresses from greatest to least go vertical stress, maximum horizontal stress, then the minimum horizontal stress, which is a normal tectonic regime.
Anything else on this slide? Okay. On to G8. If you would please explain how hydraulic fractures propagate relative to stress in the DJ Basin.
Right. A hydraulic fracture opens against the least stress. So if you think about a planar frac, it can only open in one direction. It's going to open against the least stress. That's the easiest direction for it to open because it's feeling the least pressure. In the DJ Basin, the least stress is the minimum horizontal stress. That means hydraulic fractures will be vertical and in line with the maximum horizontal stress.
And explain the differences in stimulation geometry for the three types of well orientations after fracturing in your bottom chart there.
Sure. The diagram on the bottom is a map view showing three wellbore orientations relative to a constant stress direction. The stress direction is represented by the red arrows, and one well is drilled orthogonal to that. That's called a transverse well. One well is drilled at some angle to that. That's called an oblique well. And I don't want to hit her in the head with the laser pointer, but one is drilled parallel to that, and that's a longitudinal well. In each case, you can see that the hydraulic fractures propagate in the same direction. That's because that's the stress orientation. But for a transverse well, these fractures propagate perpendicular to the wellbore versus a longitudinal well where they propagate parallel to the wellbore. So a transverse case has the potential to access much more reservoir than a longitudinal well would.
Taking it now to G9, does Encana have any actual data that shows the concepts that you just discussed in G8 are actually valid in the DJ Basin?
We do. As you said, the purpose of this slide is just to indicate that the previous exhibit, the concepts behind it, are indeed what we see in the data set. So this is two wells that have microseismic data from the basin. Their location is shown on the map relative to the disputed area. And if you don't know, microseismic data is an acoustic emission that's measured and located in the reservoir. The source of the acoustic emission is the hydraulic fracture fluid that comes in contact with the rock and breaks it. So each of those dots should represent where the reservoir is being stimulated. The color of the dot represents the stage with which it's associated. In both of these cases, the maximum stress orientation is between 90 and 110 degrees from north. But one well was drilled north-south and the other one was drilled east-west, making one transverse and one longitudinal. Again, transverse means it's perpendicular to maximum stress. Longitudinal means it's parallel to maximum stress. You can see that the behavior from these two wells is significantly different. I've outlined the dots that are in a light color with an ellipse to illustrate the geometry more clearly. You can see that in the longitudinal case, there's significant overlap between the stages, and hydraulic fractures propagate parallel to the wellbore. In the transverse case, hydraulic fractures are propagating perpendicular to the wellbore and are able to access much larger portion of the reservoir, which if you look back to the diagram from the previous exhibit, which is shown on the right, you see that it very much falls in line with our concept and proves that this is a valid concept for the DJ Basin, as it is in other basins throughout the world.
Did you review the actual data from these two wells that you're describing here?
Yes.
And are these two wells located near the disputed area?
Yes.
Okay. All right. We're going to go to Exhibit G10. Would you please explain the orientation of the maximum horizontal stress in the area depicted here and the optimal drilling orientation then in the disputed area?
There are several different types of data that can indicate the maximum horizontal stress orientation. The map shows tadpoles, if I can pick one out, that are our data points. The location of the tadpole is where we have the data, and the orientation of the tadpole is the interpreted maximum horizontal stress orientation. The very faint red lines in the background of the map are the interpolation between these data points and represent the maximum horizontal stress field. The darker blue lines that are orthogonal to the red lines is the minimum horizontal stress field, which again must be orthogonal to the maximum horizontal stress. This is also the optimum drilling orientation. So if we look to the disputed area, we see that the optimum drilling orientation should be 15 degrees from north.
And is the stress orientation in this area consistent with the north-south orientation of Encana's proposed wells in its wellbore spacing units in Section 2?
Yes.
Take you on to Exhibit G11. First, I think just to clear the record, we've given you a revised Exhibit 11 because the disputed area on our chart that was submitted last week is a little bit different. And so would you please first just show the commissioners where the actual disputed area is on your revised map that we gave you earlier today?
Yes, it's right here.
Okay. And does the stress orientation in this area match the majority of the wells drilled in this area?
Yes, it does.
Okay. Take you to figure G12. Did you figure out how optimally oriented fractures translate into better hydrocarbon production?
Yes, I'll explain the chart here that has our data results. The x-axis of this graph shows the angle between our interpreted stress orientation and an existing well. So 0 means that the well is parallel to the maximum stress. That's a longitudinal well again. And 90 means it's drilled orthogonal or perpendicular to the maximum horizontal stress, which is a transverse well. The y-axis is relative EUR, that's the estimated ultimate recovery. That was determined from decline curve analysis on our wells. This is then normalized by lateral length and then divided by the maximum value to scale it between 0 and 1.
Okay.
And, oh, sorry, keep going. The data shows a positive trend with an R squared of 0.294.
Okay, and then why is there scatter in this data trend?
There are a lot of variables that affect the EUR, as was mentioned by KPK. We have not normalized for every variable, which leads to the large amount of scatter in the plot. To illustrate this, we've colored the data by one of those variables, which is the amount of fluid used to complete the well. And you can see that this begins to stratify the data, where light-colored points fall towards the bottom and darker points plot towards the top, and can explain some of the scatter. The main takeaway, though, is the fact that we see a trend through all this noise of the variables indicates that the well orientation is one of the most significant variables that can affect the production.
Take you to Exhibit G13, and how does the EUR trend from prior Exhibit G12 then compare to actual production data in Encana's possession from the area of interest?
Yes, we took the area of interest, the closest wells, and the data plotted on the right is the actual data. It's the average cumulative production for east-west and east-west oriented wells and north-south oriented wells. East-west wells are the blue line, north-south wells are the red line. There's no interpretation that goes into this plot. It's simply the cumulative production that's average for these wells. And you can see that the east-west wells at 24 months produce 28% less than the north-south wells. And this is 2 years into the life of these wells. You can note that the slope of the lines at this point is not the same. And we would anticipate that these two curves would diverge more and this reduction would increase with time. To compare this to our estimate from the previous exhibit, you have to get the correct angle for the area we're talking about. So the map at the top of the exhibit shows the interpreted stress orientation for the area of interest and a north-south and east-west well relative to that stress. You can see that the north-south well intersects at a 75-degree angle. The east-west well intersects at a 15-degree angle. So if we plot those 2 points on our predictive chart, we see that there's a 37% reduction expected for the EUR. Again, the EUR is at 30 years, and so after 2 years, we're seeing a 28%.
Let me ask, I want a question, a clarification on this. Were the lateral lengths the same? Were they approximately drilled at the same time? What is the separation between the stages? Roughly how many pounds of sand were pumped in each of the stages? Was it close?
Do you mean for the data plot on the right or for the data
For
on
the
the
28% reduction in orientation,
Right.
lateral length,
Sure.
number of stages, the type of the frac job, the amount of the sand pipe
Yes.
pump, all that matters. Were they exactly done at the same way?
No, ma'am. This plot shows it's almost 500 wells in the plot. So this is just the raw data looking at every well. We didn't filter or cherry pick any of the data. It's just what was available. But you're right, those variables are important, and that's something that we showed in the previous exhibit. But what I think that this gets to is that if all of those variables can be considered as noise, and noise should more or less cancel itself out because they're all being changed independently of one another. So if we're still seeing this strong of a trend by just looking at one variable, we deem that significant. We look at a lot of different types of trends in this basin between factors that we do to the wells versus EUR, and we see nothing this significant.
Any further questions, Ms. Craig?
I'm still thinking I'm going to have some more questions.
Okay, and then,
I have just a quick question.
Yeah.
Since there are so many more north-south wells drilled, would it be safe to say that they're more recent wells as opposed to the east-west, and they might have other improvements more recently?
I can't answer that specifically. I don't know the date of every well that was drilled east-west, but it's likely that they were newer wells, and for the same reason that we drilled our east wells and then abandoned that approach because we discovered that they were less economic to drill that way.
Okay, thanks.
And then just one clarifying question on this Exhibit G 13 here. Is the data you used normalized data?
On the right side, no, that is not. That's the raw data.
Okay, and on the left side was the normalized data?
Yes, it was normalized for the lateral length.
Okay. All right. Exhibit 14, can you explain why you prepared this exhibit?
The reason we prepared this was because, like KPK did to our exhibits, we read theirs ahead of time, and their argument is predominantly centered around faulting. And so one of the things that goes into the assessment of whether or not the hydraulic fracture will propagate in a certain direction is natural fracturing, as KPK presented. Although, like they said, there are a lot of factors that influence how strong this effect will be. This is actually something that is my expertise. I modeled the interaction between hydraulic fracture propagation and natural fracture sets, and I have a pretty good grasp of how these things behave in nature. Additionally, we've been out to the outcrop, we've reviewed the literature, and we've reviewed 16 formation micro-image scanner logs, which give you a good indication of what the natural fracture system orientation is. We've seen consistency throughout the basin with this pattern here. The map shown at the top is a digitized copy of the outcrop fractures that we went out and mapped, and shows a predominant east-west orientation, which matches our reservoir signal. We've confirmed that the outcrop signal matches the formation micro-image scanners for the reservoir for spacing and for density, and feel that it is a good representation of what the natural fracture system looks like. So while there might be a larger scale faulting pattern, the natural fracture system, which is subwell logs and subseismic, may indicate that north-south is still the optimum orientation, even without the presence of the considerations of stress.
All right, and then Exhibit G15, KPK took your charts here and gave some testimony on that. And so would you please explain what you are presenting to the commissioners here in G15?
Right. So one of the points, like I was mentioning with the previous exhibit, KPK argues that there's a lot of complexity in this basin, and we certainly agree. The faulting is highly complex, oftentimes random. This seismic image is a polygonal faulting system. Think mud cracks, desiccation of the formation. This complexity is not localized to the area that's being disputed. This complexity is rampant, but we still see consistency in the results, and consistency in the stress orientation, and consistency in the microseismic data that indicates our hydraulic geometry.
And then would you also explain the top chart?
Yes, this is taking KPK's fault map and intersecting it with a north-south oriented well, which would be the red line, and a blue line, which would be east-west, showing that drilling north-south still intersects this fault pattern at a greater angle. I think it was pointed out to us that the math is not correct on that. It's 50 degrees and 32, though those angles should be complementary. So whether it's, I can't say offhand whether it's 58 and 32 or whether it's 50 and 40, but it certainly is a steeper angle to drill north-south.
Okay. And is the faulting that KPK used and that you've talked about on this slide, was that actual 3D seismic?
Based on the extraordinary straightness of those faults, I would say they were interpreted from well logs, not from a 3D seismic, maybe extrapolated between 2D seismic logs or 2D seismic lines. It would be really difficult for me to believe that that was mapped from a 3D seismic volume.
And what would be the benefit of 3D seismic mapping?
It would confirm that that is the actual shape of the fault. And since so much of this argument hinges on the orientation of these faults, I don't believe we know that confidently enough.
Okay. Anything else then you'd like to say about Exhibit G15?
No.
Okay. Take you to our last slide, Exhibit G16. What's the calculated recovery factor for horizontal north-south oriented wells in the disputed area?
6.15%.
Okay. And based on this north-south orientation of Encana's proposed wells, would you expect these wells to be economic?
Yes.
Okay. And anything else you'd like to explain about this exhibit?
No, that's it, unless there's any questions about it.
Okay. Then at this time, we'd move for the admission of Exhibit 2, and I pass the witness.
Can I buy some time? No, I'm just teasing. We have a couple questions with respect to cross. On your exhibit 14, how far away from section 2 are the FMI and the outcrop data that were displayed?
Do you want me to go back to G14? Okay.
For
Okay.
the outcrop data, that was a significant distance. They cropped out at the front range. The FMI data were scattered throughout the basin over a large area.
And what's the mileage to the outcrop?
I can't estimate that offhand.
Is it over
15 plus miles?
Okay, thank you. With respect to G5, your exhibit G5,
Okay, hang on.
understanding and, confirming KPK's statements that, localization needs to be utilized when you're looking at this. Isn't it true that Encana has drilled east-west wells in section 34-1 or 266, your McConaughey wells?
We have drilled those, yes.
Okay, so you have taken into account the east-west versus north-south orientation, correct?
Like I said, we drilled those wells without knowing as much as we know now. We would not do that again.
With respect to your, you said that you've reviewed wells in the area. You couldn't provide any data to Commissioner Craig with respect to the length of the laterals, any of that, which typically should go into comparisons when you're trying to do north to south, east to west. So you've reviewed the wells. So isn't it true that Noble has drilled approximately half their wells on an east-west orientation and PDC has drilled wells on east-west orientation?
That's true, but this is a
Thank you.
convenient slide to have up. They make up a very small percentage of the wells that have been drilled in this area.
Thank you. And with respect to your, sorry, my eyes are bad. How many wells within 2 to 3 miles of section 2 have measured stress data?
None that we've incorporated into the study that we know of. So.
Thank you. Is it true that stress directions vary over 15 to 20 miles in the DJ Basin?
It's very true that stress can vary in the DJ Basin and can be locally different, and we've seen this many times, but the large picture that we see from me looking at over 30 wells with microseismic data is that this localization may only affect 1 or 2 stages. Faulting does change the orientation of stresses, but the regional picture is what largely determines the behavior of the well. It's not the local stresses.
And is the microseismic data reviewed confidential in Canada data?
Yes.
Okay, thank you. Anything else? I have no further questions. Thank you.
Okay. No further questions of Mr. Wallace at this time.
Do you have any other witnesses?
No, we do not.
So perhaps you have another witness, or
No, we don't.
you have some just-in-case witnesses?
We do. We do. They all swore to tell the truth, but they've decided that they would prefer not to testify.
Okay.
Well, because it's KPK's burden, they would have the ability to, or the opportunity to rebut. They have 3 minutes and 50 seconds remaining.
Can I have 1 second?
3 minutes. 3 minutes and 51 seconds. No, just kidding.
So I have one question for rebuttal for Avi, if I could bring Avi back up. Thank you, Ken. Thank you.
You can do that. And then
So you wrote it, please, yeah.
Is this the one you're talking about, right?
Okay.
Just for clarity, I would put period right there and say
All right.
the grounds for such an objection are 1, 2, 3.
Just one piece of rebuttal and point for clarification. I'm looking at Encana's land exhibit. It doesn't have anything on it, but it's the exhibit with respect to this. There's 2 parties listed on there, Prime Resources Corporation, KC Operations, Inc. Are those companies still existing?
Not to my knowledge.
Okay, thank you. That's all I have right now. Thank you.
Cross-examination? No. Okay.
Okay, thanks, Avi.
Ms. Jost, did you expect me to figure out why you asked that question?
I can tell you why, if that's all right for purposes. I'm just saying, I'm sure an objection would have come, but it's truly for purposes because, in canon, can you ask the question?
I won't answer.
Okay, there's a reason.
Maybe when she.
Can I talk about where I'm troubled right now, where I have questions, to see if maybe somebody can shed some light on this? It strikes me that right now what's happening, I'm leaning towards a north-south orientation would probably give a higher recovery per well than an east-west, assuming a similar frac job, okay? But from the perspective of KPK, it looks to me like the west-southwest portion of their acreage is going to be stranded because there is no proposal to go ahead and drill that little piece, which I understand is under the town of Hudson, and the northwest portion is not going to be drilled. And I think that that's open for drilling, but it hasn't been proposed. The problem for KPK is an analysis, a comparison between less productive east-west wells that strand the whole southern section versus leaving out that one little piece on the west-southwest. That's where I'm stuck. Because from the individual wells that are drilled, it looks to me like if everybody owned equally, if one company owned those four pieces equally, north-south, would provide better recovery for the state on a per well basis. Am I missing something here? Because it strikes me that that's the analysis that you all are doing, is that you've got a little portion of the west-southwest that isn't going to be drilled of the acreage that you own. And it's probably going to render it economic for a horizontal well. Is that right?
I could answer, I mean, to answer part of your question, we do not believe.
Can we hear?
Based on the analysis that we've conducted so far, we don't think that there is a practical way to drill an economic lateral that is, kind of a stubby lateral, for lack of a better way to put it. And so I don't think that would be something that would be considered. I mean, I don't want to speak out of turn, but we certainly wouldn't recommend that it be done. So we believe that would be stranded asset. That's correct. So if that helps, yes.
Well, there's where I'm stuck. Because I don't know what's in the best, right now, I'm concerned about what's in the best interest of the city.
Commissioner Craig, we've got, our witnesses can answer that concern too, because we recognize stranded acreage is a concern. And Canna owns 100% of the northwest quarter, so that's a concern for them. So they can answer that. If we can have either Jack in Canna in the northwest, so excuse me, John Jordan can respond to that.
She's not listening right now, John.
Sorry, I had to explain to
That's
him
why
what
I'm
I was
patiently
talking
waiting.
about.
It did come to light in one of the face-to-face meetings with KPK early on in this entire ordeal that it was in Canna's intention to develop the 640 in its entirety with up to 24 wells in the section. So as these things have transpired over time, the development of the west half of Section 2 was actually incorporated into what we had at one point of having a drilling and spacing unit for the entire 640.
So I am going to object to this respectfully. I mean, I get where you're going, but the 640 is no longer here. The 640 was dismissed for purposes of the hearing officer's order. The 640 is not up for hearing here. They haven't proposed a 640. They're not moving forward on a 640. There's no application on that. So respectfully to the witness, I understand what he's trying to get at, but it's gone and they haven't refiled it. So that cannot be considered today.
Well, quick response. I mean, we would agree that the 640 is not at issue right now, but Commissioner Craig has a valid question regarding stranded acreage. And Mr. Jordan's response goes to the development plans that Encana has for that asset. So we've put it at issue by talking about we're alleging that it's stranded. So his responses are still relevant to that claim.
And just one point in response is it's not stranded if KPK can actually develop on an east-west basis on their almost 100% assets.
Yes, but the
So
question that I have is, if an east-west well is not the ideal situation and doesn't produce as efficiently and effectively as a north-south, then what are we doing for the state?
and from our perspective,
Actually, I just want to interrupt, and I apologize. The rules provide for a very narrow issue in these circumstances. The narrow issue here is only whether KPK's objection to Encana's proposed wellbore spacing units under Rule 318A E5B should stand, and whether or not that objection should stand. So the issue isn't really whether or not north and south or east and west should be the issue, but only whether or not that objection should stand or whether or not it should be dismissed. And I know that that's a little, it's narrower than you would like to hear, but under the rule, it's a very narrow issue before the commission.
Right. Let me, I'll hand this to you, but I wanted to read it first. So this is the rule that Mr. Ansey just quoted. The written objection or the objection by KPK must be based upon a claim that the notice provided by the operator does not comply with the informational requirements of the rule, and/or a technical objection that either waste will be caused, correlative rights will be adversely affected, or that the operator is not an owner as defined in the Act of the mineral estates through which the wellbore penetrates within the target formation. Specific facts must set forth the basis for the objection. So those are the criteria that you need to consider in resolving the objection.
Well, and Mr. Matter, if I can, thank you for reading Rule 318A5B. I appreciate it. And our position would be that is what KP Kaufman needs to state in their original objection letter. And if that claim is basically, if they present one of those claims, that basically gives them standing to present their case before you today. And then they have to prove the elements actually of Rule 318AE5C, which are just slightly different. And I think Ms. Jost actually set that out earlier on.
and I'm sorry, I have to make a statement here because Encana continues to hound on the validity of the objection. The validity of the objection is not an issue. Whether that objection is supported is the issue. KPK has presented substantial technical evidence to, put some question into the north, south, east, west variability. So I'm just responding to the thing to clarify for purposes of what we're actually here for. So.
Right, and Ms. Fulcher has a valid criticism of what I just said. Encana has a threshold issue, and they're saying that the letter that they received initially from KPK does not comply with the rule. It did not state particular facts setting forth their objection. So if KPK gets through that initial hurdle, which is the basis for that criticism, then you need to consider these other factors that I just identified.
Okay, we probably are pretty close to closing statements.
Yes, it is time for closing statements. KPK will begin, and they have 3 minutes and 32 seconds remaining.
Okay, so I apologize for probably the spotty nature of this for purposes of this, but for purposes of closing, the commission should deny the 9 wellbore spacing units. The 3 points supporting denial were supported by substantial technical testimony that there are holes in Encana's presentations. Not only was this still filed in violation of the rule, which we cannot forget, the commission has entered an order. Commission hearing officer has entered an order saying there's a violation of the rule. So one, they shouldn't even be in front of you today. Secondarily, KPK has presented substantial technical evidence to show that the Encana well orientation may not be optimum and mandate that orientation in this area. KPK has set forth localized data to support their development plan and proposed development plan for the east half. They've also shown how their correlative rights will be harmed. There will be a stranding if Encana's wellbore spacing units are approved today, and which is again why they should be denied. There's substantial correlative rights issue here with respect to KPK, recognizing Commissioner Craig's concerns for the state as well, but we cannot forget an operator's correlative rights too. And so by having that basically taking of the, east half of the, the southeast quarter being forced into these units, that is an unfair advantage that Encana has if these are approved, especially when they've been submitted in violations of the rules. For purposes of Encana's testimony, I think that they provided, a lot of regional data, but didn't really focus down on the localized data. Ken Cooper presented substantial data with respect to localizing this effort. If you look at one of Encana's exhibits, I think it was exhibit G17, there are east-west wells in this area, some of which were drilled by Encana within the last year. And so, there's substantial concerns here for the actual harm that will occur to KPK. KPK has not been in business for 30 years by not coming in here and protecting its assets. We have to remember that as well. KPK is a long-term operator of the basin. They have data. Whether they've drilled a horizontal well is absolutely irrelevant in this matter. They have participated in over 25 horizontal wells. They're participating in 7 Encanas. That doesn't mean they buy into the northwest, east-west development basis, but they're participating to gather data. Encana's own expert said, yeah, we look at other data. We look at
We're well into closing arguments here.
This is closing argument.
Okay, all right.
Sorry. Well, this is my closing argument, though. It's absolutely that, there will be harm. So when you check the boxes with respect to the whether the objection was valid, it's already been determined that the objection was a valid objection. Did KPK submit appropriate evidence to support correlative rights will be harmed? Yes. Did they submit evidence that waste will occur? Yes. You will have a stranding. Did they submit evidence that Encana is not a, quote, owner where the wellbore will penetrate in that south half? Yes. They've met all the requirements of 318 AE 5 B and C that are required here. So thank you very much for your time. And we really appreciate as KPK you indulging these efforts, because we recognize this is not an easy issue and this doesn't come up in front of the commission very often. We're only here because we couldn't work it out and we're looking for direction. So thank you for your time as well.
You have 22 seconds.
I'm done. But if I only had 22 seconds, I would just say.
Ready?
How much time do I have?
7 minutes and 2 seconds.
Oh, okay, great, thank you.
You're not required to use it all.
And I do talk fast, and so I probably won't. But I certainly, Mr. Chair, members of the commission, and Encana thanks you for your time today in this very contentious case, and we really appreciate you laying the matter to rest, whatever your decision is. We appreciate your consideration. Now here, as Mr. Matter has just explained, the objection of KPK, they have to meet the burden of proof that something is not right under 5C. And so they have to meet the burden of proof that the notice letter of June 9, 2014 did not contain all the 5A requirements. And I don't think that's a dispute. I didn't hear any testimony on that. They have to show that Encana is not an owner with the right to drill within the proposed wellbore spacing units. And they have to show that Encana's wellbore spacing units will create waste or harm their correlative rights. We submit to you that they have not met their burden on any of those points. And since they have not met their burden on any of those points, their objection should be dismissed and the wellbore spacing unit applications should be approved. You heard Mr. Kroom testify that Encana is an owner of minerals in the north half of Section 2 and is an owner in those bore spacing units. As an owner, it has a right to drill wells in the units, including the south half of Section 2. That's what an owner is defined as under the Act 3460-1037. An owner doesn't just mean you're an owner in the south half, and Encana doesn't have any ownership interest in the south half. An owner under the Act means that Encana is an owner in the wellbore spacing unit of at least more than 50%, as the testimony was, and it has a right to drill the well regardless of the top hole and the bottom hole location. That's the purpose of these wellbore spacing units. They're very unique creatures of your statute. The wellbore spacing units will not create either economic or physical waste. Those are defined at 3460-103-13. You heard very credible evidence from Kirsten Wallace of Encana It's undisputed that most of the wells in this vicinity are drilled on a north-south basis. You've seen our slide G11. Encana's optimal drilling orientation matches the majority of the actual development in this area. Encana has drilled 97 wells and only 9 east-west, and Mr. Wallace testified that after they drilled those east-west wells, they realized they would never do that again for economic reasons. You were shown some 2 years of well performance data in the disputed area in slide G13. Shows that there is in fact a 28% greater recovery from the north-south wells than the east-west wells, and that is actual performance data over many wells, with the curve actually going up for recovery of north-south wells. In the wellbore spacing unit, there's 27.5 million barrels of oil in place and an estimated recovery factor of 6.15%. And KPK has not drilled a horizontal well in the Wattenberg field to date. East, west, north, south, any direction. So the north-south orientation of Encana's wellbore spacing units, as Mr. Wallace testified, is transverse to the maximum horizontal stress of the rock. This is important because hydraulic fracturing of the rock fractures at the location of the minimum horizontal stress, and that means that it's going to access more of the reservoir. These north-south wells stimulate a significantly larger area. You saw that in slides G8 and G10. While the stress throughout the DJ Basin changes, and there's no dispute about that, for optimum recovery in this disputed area, based on the slides that you have seen and the stress in this particular area, the wells should be drilled on a north-south basis. You're going to get more hydrocarbon recovery, as Ms. Craig said, than east-west wells. That's our slide G13, as well as others. And the north-south orientation was also supported by the microseismic data that you saw in slide G9. Reasonable and prudent operator is going to be drilling these wells in the wellbore spacing unit in section 2 on a north-south basis. KPK talked about faulting, and faulting issue really here is a red herring in this disputed area because of the north-south orientation of the wells being transverse to the maximum stress for the optimum results. And I think you heard testimony that the drilling transverse to the stress is more important than drilling transverse to the faults, although you saw the faults in the area are somewhat east-west, and so they're going to be drilling transverse to the east-west faulting in any event, but that's not why they want to drill that way. They want to drill that way because of, thank you, because of the optimal recovery of the reservoir. So the wellbore spacing units will not create physical or economic waste. The correlative rights are protected in this area. KPK wants to develop the south half, wants to be an operator, wants to drill east-west, but correlative rights are specifically defined in the Act. They have an equivalent opportunity to obtain and produce their just and equitable share. They're an owner in the wellbore spacing units. They will receive just an equitable share of production. They testified that they're in wells north-south oriented with Encana and other areas, and they're getting 50% of their production. Encana has a majority interest in these wellbore spacing units, and as an owner, everybody's going to receive their just and equitable share. So as a result, in conclusion, Encana requests that KPK's objection to the wellbore spacing units be denied, and we request that the commission approve the wellbore spacing units, or in the alternative, direct the Director Lepore pursuant to Rule 5E to administratively approve those wellbore spacing units immediately. Thank you for your time. Appreciate it.
Okay, hearing officer, I'm affixing to close testimony unless you.
Before you fix the close. KPK does have 22 seconds.
I'll always
like,
use all my time
for its rebuttal closing argument.
And I actually have a question of Ms. Jost too.
Yes.
Ms. Spalding just argued that Encana is an owner in the southern portion for purposes of applying the rule.
Yes, she did.
And will be once the unit is established.
Yes.
As of right now, they are not.
That was
Under the definition of owner in the Act and under 318 big A E5C a B, that states that the operator is not a quote owner as defined in the Act, which is the right to drill, basically a person with the right to drill, of the mineral state through which the wellbore penetrates the target formation. At this point in time, we're in the wellbore spacing units have been proposed, and Encana owns 0 ownership in the south half of that section. So they are not an owner under your rule on the statute.
Right.
May I object, may I, not only object, but may I address that at some point?
Sure, I think this is a critical issue, and the question is, do you make the ownership consideration before or after the unit is established? And it seems black and white to me that Encana is not an owner in the southern portion as of today.
Mm-hmm.
As of right now.
As of right now.
That's why you have
It could
pooling.
be.
And I'd just like to say that 5B, which talks about his owner as defined as the mineral estate through which the wellbore penetrates within the target formation, is in B. And that's what you have to say in your objection letter. That is not what an owner under the act is under 5C. An owner, the whole purpose of these wellbore spacing units is so that you can have some sort of ownership interest in it somewhere, and you can drill in the wellbore spacing unit. That's the whole point. And so it obviously, you have to send your notice letter out, you have to get the approval, and then you're going to do your pooling and your other stuff like that. But if you look at the definition of owner under the statute, and it's 3460, 102, 103, I apologize, I'm getting to it. 1037 means a person who has a right to drill into and produce from a pool and to appropriate the oil and gas he produces therefrom, either for himself or others, or for himself and others, including the owner of a well capable of producing oil and gas. So for purposes of the wellbore spacing unit and 5C, the owner, Encana is an owner, even though its ownership now is in the north half.
I mean, do I get a chance to respond to that argument? Okay, because I absolutely disagree. The definition of owner is very clear under the act and under your rules, that the person who has the right to drill into and produce from a pool and to appropriate the oil and gas he produces therefrom, either for himself or others, or for himself and others, including the owner of a well capable of producing oil and gas, or both. When you put that into the context of the rule that we are here under, the owner has to have that at the time the wellbore spacing unit is filed, that meaning the right to drill, where the wellbore penetrates. Encana was involved in the rulemaking in 2011 and probably helped come up with some of this definition in statutory language or regulatory language. So we have to absolutely keep in mind that that right to drill piece is a critical factor here. And there's no right to drill in the south half at this point in time. Thank you.
So if you're right on that legal issue, all the business about north, south, east, west is relevant, right?
Absolutely, because that issue is part of the piece for the objection, which has been determined valid.
She still has 13 seconds?
She has
22.
She had 22 seconds.
I was answering questions.
I mean, just.
We would probably have enough.
Okay, I would like to use the 22.
Well, I think we have enough discussion. Well, she has
22
30
seconds. Yeah.
Well, this maybe just.
It has nothing to do
brief-
with that.
Maybe a brief response from Encana, just because it is such a critical issue, understanding the difference between 5B and 5C. Okay.
No, I think we understand the issue. I honestly do.
Well, okay. Ready?
Yes. So I need to officially move all the exhibits in the PowerPoint into evidence. I would request that be done. There were no objections. And that there is a point that you can absolutely deny these applications up for you today with respect to the wellbore spacing units. And you can make Encana, and they can refile and they can do it right. Right now, they're in violation of the rule. We've submitted and supported all of the elements. We submitted evidence, and we would ask you that you deny these applications, the application. Thank you.
All right, Mr. Dorancy, I'm fixing the proposed testimony.
That's, so you're fixing correctly. Closing of the record.
Okay. Now, Mr. Dorancy has given us 30 minutes, I think, to deliberate and ask questions. I don't know how much of that time you've used up with all of your questions, but no, we have 30 minutes or whatever. So, what's the issue? What do we need to decide?
The ultimate issue here is, and if you bear with me for 30 seconds, that stands before the commission is whether KPK as the objecting party has carried its burden to prove its objection should stand under Rule 318A, E, 5B, and C. The grounds for the objection are either that notice provided by the operator does not comply with the informational requirements of subsection A, that the operator is not an owner as defined in the act of the mineral estate through which the wellbore penetrates within the target formation. 2, the approval of the boundary well location, wellbore spacing unit, horizontal wellbore spacing unit would either create waste or 3, adversely affect the objecting party's correlative rights.
Mr. Rancy, I think you're reading from 5B and their burden
I'm
of
reading-
proof is in 5C.
I'm reading from 5C. Sorry, I didn't mean to say it that abruptly, but I have to read it.
So on my Greater Wattenberg Area Wellbore Spacing Unit Operator's Guidance document.
Well, the guidance document was provided to the operators after this issue started. So it was submitted on October 20th. So it should not guide you today.
We make them all a copy of 5C so they can look at it.
Okay, do you all, do my colleagues understand the grounds that the objecting party will bear the burden of proof and so on?
Well, I think it's important to understand whether the ownership, the right to drill into that south half is something that exists prior to the wellbore spacing unit or after. And that's the question I'm trying to get some clarification on. Is there any clarification of that rule?
I don't know if we've ever had this sort of hearing in a wellbore spacing unit.
That's our interpretation.
Shall we get all our issues out on the table so you all can kind of help us through the process? Because I'll tell you right now, I am seriously struggling with the fact of going east-west as opposed to north-south. Because my concern is, and the recoveries are not great, that you go east-west and you have 2 poor wells and 640 acres are done. Because they've been rendered non-economic if they can't go north-south because you've got 2 wells going east-west. I'm very concerned about the viability of going east-west. And I know this is a technical argument that KPK is saying, we're gonna go east-west, we don't wanna lose that little section. But they may stop drilling after a while because the economics are poor. And I think we do have to worry about that.
So you're
That's where I am.
concerned about creating
Correct
waste?
me. That's my definition of waste, but.
Commissioner Hawkins.
You know, I agree. I think the evidence that we saw today indicates that we should be looking for maximum recovery of drilling wells north-south. But I think we also have to look at what's the best way to accomplish getting those wells drilled. And the wellbore spacing units is one way if they've met the definitions of having the ownership to be able to drill their well into the south half from the north half. If they haven't, then they probably need to create a 640 acre spacing unit that joins the north half and the south half, and then they can drill north-south. But they don't have, that's not the question in front of us today. So the question is,
the KPK's,
you know, did their protests meet the burden of proof? And, you know, and partly in my mind is, are the wellbore spacing units legal from Encana's point of view to drill into the south half? So I'm still trying to figure that out.
Commissioner King, you have some, is erudite a word?
Oh, don't set the bar too high. So this is coming from the guy who couldn't do math to get to 20,000. I found the last presentation more than a little overwhelming. And I kept thinking, you know, this is the complex connection between business, engineering, geology, politics, all of the things that go into this. And I am personally, we've had a handful of these things, and whenever they come up, I get very, very uncomfortable because we're being asked to pick winners and losers, right? And I don't think that's the role of government. And I think that we have an obligation to fulfill the statute, but we also need to be very judicious about when we start going down this road. And I think this whole system is set up intentionally or not to create stress and uncertainty, which will encourage operators in the future to resolve this on their own and control their own destiny, as opposed to come in here and roll the dice and see what we'll come out of this with. I think that we have stranding of the resource issues that will KPK find that going east to west is uneconomic? Potentially. They don't think so. There's at least a handful of wells that are doing this. It's not the predominant number, but some, right? We also have the potential that going north-south would strand some of KPK's resources. So how do we measure one stranded resource versus another? And it seems to be all of a sudden we get into quicksand. I don't like being in this situation. What courts will generally do, and what I would propose today, is when you find yourself in a situation where you can make an expansive ruling or a narrow ruling, that you make a narrow ruling. And I think that the narrow ruling would be to say that under the standard that Encana is required in applying for the spacing order, or actually stated a different way, KPK can make a legitimate objection that the operator is not an owner of the mineral resources at the time of the application. That only makes sense to me because that's a basis to object. And so you can't create the spacing order because then they would have the right. And so the only way that this sequentially makes sense is if KPK at this point in time, it is appropriate for them to object that Encana does not have the right to drill, and that they asserted that appropriately in my mind, if not quite perfectly, appropriately, they got the marker down, and that we deny this. Or actually, we would say it again differently, affirm KPK's objection and uphold that objection at this time. That's where I'm at. And again, in a very, very uncomfortable place with conflicting legitimate policy objectives.
Could I borrow your statement of basis and purpose just to take a look at that?
Okay, other comments? I am in like total agreement with Commissioner King. No matter how you slice the pie, right now, with the information we have, there's a high likelihood there are going to be resources stranded.
Well, not only that they're under the issues that we have to just focus on today. There could be some stranded resource. There's a cloud over whether the wellbore spacing unit is appropriate with the current ownership. And I guess I'm kind of leaning where Commissioner King is, that even though I technically might prefer to see north-south development, I don't think that the objections that KP Kaufman has brought forth are wrong. I think they're right to make their objections, their protests. So that's kind of where I am.
With what we have, relatively narrow, it seems like to me that's our choice. Now, you've been thinking, and I've smelled the smoke from the wheels turning.
On the basis of what Director King said, I think we have to go to that, but I gotta tell you, from an engineering and a business perspective, it's killing me. I feel like saying, people, go back to the drawing board and do what you have to do to get all 640 acres and drill north-south. That's gonna be the most economic, and I'm having trouble, but I see what Commissioner King has said, and I think we have to do it.
Commissioner Holton, I'm watching your eyes and it looks like you're ready to say something.
I'm really uncomfortable that this is so narrow. I mean, this should include that entire section to see what is going to be stranded and what isn't. We've been put in this position before where I feel like I'm a negotiating tool between Encana and KP. I mean, we had the one up on the western slope where Chevron or BP or somebody owned like 17 acres, but they couldn't make a deal. And so we ended up turning down the project over the 17 acres because Chevron or somebody couldn't get the amount of money that they wanted out of it. That's why I'm uncomfortable with not including the entire section in there so that we don't leave anything stranded by our decision. And I realize that Encana can come back and maybe do some more negotiating with KP to get the whole 640, but I don't like being put in this position.
Well said. Well said.
Okay, other comments? I think the last comment that we could make is that if we end up approving the protest, the objection, then there are no wellbore spacing units. And the parties can figure out what, if there still is some room to negotiate something that would allow north-south drilling. So I don't feel too bad about approving the protest.
Well, I'm going to suggest if you don't feel too bad, you might make a motion.
All right, I move that we, I guess it's approve, is it approve the protest by KP Kaufman?
I forgot how it's worded. Is that right?
It says in the
Yes, sir.
rule that the objection shall stand, so it could be to uphold the objection.
Uphold the objection.
We have a motion
Second.
and a second. Any further discussion? Hearing none, those in favor of upholding the objection, according to that motion, indicate by saying aye.
Aye.
Opposed? I understand. Opposed?
Nay.
Nay. Commissioner Holton decided to vote nay. But we do have a majority, so then that objection is upheld, approved. That's a tough one. And we appreciate your eloquent arguments. And realize we didn't make anybody happy. I could tell from the way the commissioner voted. But I think at this point in time, that's about as good as we can do.
Thank you for your, yeah, thank you very much for your time.
How about my emotional? Okay, commissioners, am I fixing to adjourn?
You're fixing to adjourn.
Do we want to talk about schedule for future hearings, or do you want to do that via email
Yeah,
later?
let's talk about that. If I understand correctly, you want to eliminate, is it the June? Just a minute.
Old
Hold on.
school. She has a calendar. This is great.
I went ahead and twice updated new operating system and lost calendar and my.
Could you hold up the
my
calendar for everybody to
contact
see the
list.
pictures too?
Sure, it's Salzburg.
Awesome.
Okay. Good job. May is 18 and 19.
May 18, 19 stays on the books.
June, you eliminate.
Correct.
July, it's open for 13 or the 20th, to be
And I'm going to
decided.
propose the 20th.
The 20th? Okay. 2 days?
We always schedule for 2 days and try not to use all of them.
The only comment I have to make is I'm going to have to travel on the second day, but okay.
Okay, and then now let's go forward because we're also proposing to eliminate the August 3, 4 and stick with the existing scheduled September 14.
Got it.
And some of those might be outside of the Denver metro area.
Yes.
Thank you. We will get that published. Thank you. You can commence fixing to adjourn now, again, if you would like, Mr. Chairman.
We are adjourned. This hearing is adjourned.